We,
I think my, say, cross will take probably as long as OKTs. I do have a few questions on a few of the points brought up by Judge English, but I don't think I might go an hour, but that's, and also there might be some duplication with what OKT plans to ask, so that could of course cut things down as well. So I think if we went up to lunch with OKT, let's say I take another 45 minutes, we should certainly be able to do this afternoon from our end.
Federal, Catherine?
Hi, it's Federal Catherine. I think I'm going to go with that in all my matters going forward. I actually don't anticipate having any cross-examination questions. I'm going to speak to the rest of my team after today, and if there's anything that we do want to follow up on or clarify, then we reserve the right to ask that at the time it's played back. Thanks.
Okay.
Does that work for you to have one wake in an hour or slightly more than an hour?
Yep, sounds reasonable. Okay. Well, thanks for going over the logistics. I'll turn things over now to Ms. Wicks.
Thank you, Ben. As Mr. Brookwell mentioned, my name is Victoria Wicks. I'm one of the other lawyers at OKT representing the Innu organizations today. So thank you, Judge English, for your report. I just wanted to start off sort of quite broad. In the executive summary, you had mentioned traveling to Labrador to meet with various people who had been working in the child protection system and also others who had been involved in the delivery of child protection. Just wondering if you can walk us through how you identified who you were going to speak to for the preparation of your report.
Yes, thank you. I asked that question of the inquiry organizers, and I was provided a list of people who, initially, it was a fairly long list of people who I might want to talk to, both in Happy Valley Goose Bay, in Wabush, and in Sheshi, and in Natchitoches. And I did travel there for about 10 days for that purpose. I ended up talking to people in Wabush, and it was primarily Judge Trahy, who had a large part of the responsibility for matters in Goose Bay and Sheshi. And I also, of course, went to Sheshi, and I talked to people at IRTS, and also to some of the people who travel to Natchitoches from St. John's. Now that I did in St. John's. While I was in Happy Valley Goose Bay, I had occasion to speak to the provincial court judges briefly about some of this, and also more intensively to the legal aid lawyers who were dealing with the cases on a day-by-day basis. And there were a couple of those, both with long experience. I mean, there were individuals who had been there when I was there and before that. So they had long experience and depth experience in both communities and frequent involvement with hearings. So those were the principal people. The social workers in Natchitoches, or the individuals in Natchitoches, ultimately came down to the social workers who rotate in and out of the community on a regular basis. And I had a very good meeting with them here in St. John's, because that's where they happened to be at that time. And we discussed, well, a wide range of things. And they were extremely helpful to me, give me some insight, because as I said, that was an innovation, the idea of having completely rotational social workers in one of the communities. That was an innovation since the time when I was there dealing with it regularly. And I wanted to know, what their work involved and how they found it all and how they got accommodated and how they interacted with the court and all this kind of thing. So those were the primary conversations, I guess.
Okay, great. That's quite helpful. Thank you. And I just wanted to clarify, were you able to speak to any staff at Innu organizations?
IRTS, yes.
Great.
I spoke a couple of times with some of the staff there. Most of my conversations were with the supervisors because when I did go there on a couple of occasions, they were everybody else was busy doing other things, and I was told and that that would, you know, I could get an oversight by talking to the supervisors who dealt and had been dealing with it. Some of them with very, very long service in Labrador.
Okay, great. So I want to now shift over to the particular recommendations in your report, and I'll just kind of go in order.
Okay.
So the first recommendation about expanding legal aid, you had described some difficulties that, you know, Inno parents have in accessing legal aid, and I think also in your presentation this morning noted your concern that there are some cases where Innu parents can be unrepresented or don't have a lawyer in these complex proceedings. And I take it your view is that these parties should have legal representation. Have I characterized that all correctly?
Yes, yes, whatever the mechanism may be.
Okay.
And I was made aware of that really through those conversations. And it, no, I think I'm dealing, you know, I'm speaking here of a minority of cases. And I want to make that clear. I think that in practice, the legal aid system and the way it works now does end up representing most individuals. But I was concerned about two groups, well, perhaps three. I was concerned about the group of parents who have some income. And the example given to me in conversations was people who have employment insurance. For instance, they receive employment insurance. And when their child is removed from their care, they're basically, if they have no other children, they're treated as single individuals. And often they're living with families, so they don't have high living expenses themselves. You know, someone else is helping them out. I know from my long experience with legal aid and the way these things are evaluated, that it's quite possible those parents would be designated as having excess income, particularly if their employment insurance income is not at the lowest amount. If it's at the lowest amount, probably not. But if they had good work, well-paying work, and now they're on employment insurance, and that covers a fair number of people in the Innu communities, because there is more than there used to be in years gone by. There's lots of people working whenever the work is available to them, and it might be reasonably paid work. So I was concerned about that group because I know that eligibility in those circumstances depends on income versus expenses. And that evaluation is done by legal aid. So I had reason to believe that there might be some people who fall through the cracks that way. The second group I was concerned about, and again, this is based on my own experience because I lived with all this in practice and then I saw it happening in front of me as a judge. There are some people who do not do well as clients. They have their own problems. There may be, you know, addiction issues. There may be mental health issues. There may be all kinds of issues. They do not communicate well. They do not keep in touch. You know, that's the nature of many people who are in court for all reasons. And so from a legal aid lawyer's point of view, they do their absolute best to represent those people and to stay on the case. But I realize there are certain instances where, for instance, that person doesn't want them anymore on the case, and yet they are the lawyer who, you know, would normally do that work, or the lawyer has, for some reason, had to withdraw, and then the person ends up unrepresented. So I was concerned about that group because I know that will happen on occasion. And then the third group is could be a subset or an overlap. It's the parent who is struggling to maintain the ability to participate. And often those are, more often in my experience, they are the women. Often the men opt not to participate, the fathers of many of the children, they're reluctant to, and they come into it and they come and go, you know, they don't. But the mothers always have a direct interest. But if they are struggling generally, in their own lives. And then, of course, on top of that, there's a removal of their child. They often have a very hard time responding to the lawyers, participating, applying, just following through. And then, of course, if they, and I have seen this happen more than a few times, if they're entitled to disclosure, and so they're not represented at that point, and they get disclosure themselves, they can't, they cannot handle it. They cannot handle reading it. It's often confusing, often redacted. It's technical language. There's all kinds of abbreviations. I mean, it's social workers talking to their file and to one another, of course, you know. And so it's extremely difficult. I made the comment, which came from a senior person on the Innu side. I made the comment that the overwhelming response that person gets from parents is, I feel alone, even when they have a lawyer, and I feel totally isolated. I feel like nobody's helping me. Now that's a perception sometimes it's the reality, but it's often a perception. And this is a reflection of the difficulty they're having taking part. So there's those three groups. I mean, I could, go on more, but those are groups where if they fall through the cracks, legal aid has done everything they can for them, but they're still before the court with no lawyer. I'm concerned about that minority of people. Supposing of those 120 children that I referred to earlier, that was 10. That's 10 parents or 10 sets of parents, depending on the situation, right? 10 parents who might have to go before the court for a hearing or for a presentation hearing, whatever, complicated as they are with all the jargon and the disclosure and the technical language, and have to survive that process. I think that's extremely difficult. And so I talked about the question of state-funded counsel because it comes out of the Supreme Court of Canada cases and the New Brunswick cases. It's clearly available. It's clearly available if the charter applies, but there is no system. There is no fund. And if there was a fund, it would be probably within government, not within the communities. So that you'd have to have, well, a number of things would have to happen. Someone would have to apply to the court to appoint state-funded counsel. Now, in the criminal context, when that happens, in Labrador, at least my experience was, the person had been rejected for legal aid, but when they were going forward to their trial, the judge would say they need counsel. They definitely need counsel for this. And they would order that counsel be appointed. It would be a legal aid lawyer. So legal aid became the residual or default provision of counsel, even if the person didn't qualify. And that could happen too in the child protection cases. In effect, the court would be providing counsel to assist the person the best way they can, either as full counsel or as what we used to call amicus curiae, a friend of the court, whatever. The point is you do not want the person there alone without the access to legal advice. So I will be quite straight with you because it was made straight with me that from the legal aid point of view, this is a very small number of people. But the problem is that when a person stops participating, like when a parent stops showing up and is not in touch with the legal aid office, you don't know whether if they had counsel, they would show up. And of course, there's nobody there to apply for the state-funded counsel. There's no one there to set out their financial circumstances, their personal circumstances. So we don't have a system for that. Now, whatever system you set up, people may still want legal advice, even if it didn't involve the courts directly. And so we need to always keep in mind that there are people who will, through no fault of their own, fall through those cracks. And courts are very conscious of this in the criminal cases. There's a mighty struggle that goes on in criminal cases of any significance to get the person to have a lawyer for all kinds of reasons that you fully understand. But and there isn't certainly an effort made in the child protection cases. But what happens when the person simply kind of gives up, backs off, gives up? And I was, you know, I won't identify by whom, but I was told of instances like that, that people working in the system were concerned about, that the person had sort of emotionally given up, practically given up on the court case, and yet had something to say, something that should be before the court but wasn't going to be. So that's the scope of it.
Thank you. That was a very comprehensive answer and answered a few of my next questions, so I appreciate that.
Okay.
And so I understand from your report, you've identified sort of 4 possible options to potentially address this gap. And I know you know them, but just for the transcript, I'm going to go over the 4 of them. So extending legal aid to allow for full representation of all Innu parents in all child protection cases. 2, extend legal aid to cover advising and assisting the parent on the application for state-funded counsel. 3, taking steps, including an application to the appropriate court to compel the responsible provincial authorities to establish a funding mechanism to fill this gap. Or 4, establish a funding mechanism to be administered through an Innu agency such as IRTS to pay for new counsel once all legal aid options have been exhausted. Now, I'm just wondering if of the 4 options, if you had a personal preference or you had some thoughts about why one might be better than the other?
Yeah. Under the current system, the first one would be the best. And the reason is, again, you've got this group of highly qualified, highly experienced, available lawyers through legal aid and even a specialist office. And if they were available to all parents, and now there might be conflicts, so there'd be conflict counsel brought in, but if their services through legal aid were available to all parents, then that would give you ready, willing, and able lawyers. When I worked with legal aid, there was a different system which doesn't exist anymore, and that was you could provide legal aid to parents who had some income. So in other words, they had some means, and maybe the means wasn't minimal, but it certainly wasn't enough to allow them to bring a lawyer to Labrador. And legal aid would enter into an agreement with them. It's called a payment agreement. And the payment agreement meant that the parents would agree to pay a certain cost, a certain portion of the cost of the legal aid services. That was defined, and there was a payment schedule put in place and so on. And parents would sign that. It was very formal. And that way, legal aid went forward knowing they were going to get some reimbursement to the legal aid fund, which is a provincially managed fund. Some time ago, after I was done with that, and so all that was abolished. And so you either qualified or you didn't qualify. There was no gray area of partial payment that was involved. And so you don't have that option available anymore, although I don't know why it couldn't come back, frankly, because I think many parents wouldn't feel badly about contributing to the representation if they had means. And that means can be assessed in the same way that their general means can be assessed. The legal aid has intake workers who do all those assessments, the financial assessments, and they're quite capable of it. But anyway, the current method doesn't allow for that. So it's all or nothing. You're either in. But that's the main reason why I'd be concerned. The thing about the state-funded counsel, theoretically, it's a very good idea, and the Supreme Court has approved it, and other courts have approved it as an option. In fact, in the New Brunswick case, they mandated it. They mandated that there be some system. And I think what happened after is that New Brunswick legal aid started doing those cases that they weren't doing before. And that's how they handle it, using their existing people. But the state-funded counsel, it won't necessarily give you experienced, knowledgeable people about the communities. And that's my only concern. You can pick a lawyer in St. John's or Corner Brook and say, you're willing to do it, thank you very much, you're the state-funded counsel. But they go to Labrador and they start from scratch unless they're doing a lot of that work. So that's my main concern, because they're ready, they're willing, but do they have the local knowledge, the cultural knowledge, to do the work right? So theoretically, it's a great solution, but the best solution and the cleanest solution is for legal aid. As I said, in the criminal context, this is what happens. When the judge makes a formal order under the criminal code for appointment to counsel, it goes straight to the legal aid office. And the local person, one of the local lawyers, takes it on. So they're the default provider anyway. Now, the reasons why they don't do it, of course, as you know, there are federal provincial legal aid agreements, and they define pretty succinctly and in great detail exactly who the legal aid fund can be used for. But civil legal aid is totally provincial in Newfoundland, and you know, family in particular is totally provincial. So all of the funding, all of the cost is from the province. So that's a, you know, that's a burden on the province, no doubt. There is no, unless there's federal money coming in through other programs that I'm not aware of, there's no federal money that comes into that. So one possibility, and I didn't go into it in general because it's not directly related, is that there could be a federal component for Indigenous people for child protection matters, because that's where the federal interest hits most solidly. A federal component to the legal aid fund, which is specifically to augment what legal aid can provide and what the province can provide. I mean, we are the poorest province in the country. Fiscally, we're in not a great situation. Everybody knows that. So any fund augmentation from a special program or from other funding would make a big difference, because you're not talking about a large number of cases here. You know, you're talking about, I would estimate maybe 10, and that's just a guess really, per year would fall into that. So it wouldn't be terribly expensive. And if you use the existing people, well, they're salaried workers, because now all of our legal aid lawyers in Newfoundland, unlike other provinces, are employees, staff solicitors. And so they're paid by salary anyway. So it's just a question of they may have to bring in other people from other places from time to time, which does involve some expense. So I think that number one would be my first choice. I have tremendous respect, not just because I dealt with it, but because I saw it for 40 years. I have tremendous respect for the work that legal aid does and the lawyers do, particularly in Labrador. And the fact that some people have been doing it now for well over a decade, doing the same work, brings them up even in my estimation.
Thank you. That is very helpful. I wanted to move specifically to the option 3, which is the taking steps, including an application to the appropriate court to compel the province. I just want to clarify, if you can help me understand, am I correct in understanding this option is suggesting like a potential lawsuit against the province?
Well, it's, and I can't remember the name of the New Brunswick case, but it's similar to what happened in the New Brunswick case, because New Brunswick at that time specifically did not cover child protection matters through its legal aid system, because, as I said, in most provinces, that is totally funded by the province. So the province has an interest in that, and they determined they didn't want to cover it. So when this person went to court, they made an application. And of course, the application in effect was against the government and legal aid for an order from the court using charter principles that it was required. And yes, so it is a lawsuit. That's the kind of thing I'm thinking about. Now, that application could be made, arguably, to either provincial court or Supreme Court. You know, for instance, in many of our child protection matters in other parts of the province are heard by the Supreme Court. And the Supreme Court can certainly make that order if they feel the merits, the application is properly made and so on. So yes, it could be an application made to a court in the context of an ongoing child protection proceeding. If there's counsel, say for the parents, and they feel for some reason legal aid's put limitations. One of the things I used to run into as legal aid counsel, I'll give you this example now, this is an analogy. As legal aid counsel on serious criminal charges, we would often need to hire experts. And under the legal aid rubric in every province, you have to make a special application to legal aid to get authorization for the cost, because in the criminal law context, that could be many thousands of dollars. And so we would do that, but then they would put a limit on it, right? And then you get into the case and you'd realize that limit undercut, it went well under what the cost was going to be for various reasons. And then you'd have to go back. Well, if you'd reached, I always got that worked out. But if you reached a point where you needed an expert or you needed help, maybe even co-counsel, who knows, during your proceeding, for instance, and that could happen in a child protection proceeding, legal aid may not authorize it. However, you can make an application to the court saying that this, and laying out your reasons. It had to be a serious application, laying out your reasons, asking the court to make an order that this expert be retained and that the cost of it be borne by somebody, either through the legal aid fund or by the province, because of course the province is the other party through the manager to these proceedings. So it's that kind of application. That application where there's counsel can be made. Now, as far as I know, I did ask a number of people, there hasn't been such an application made in this province. And that may be because most people are being taken care of through the legal aid system and taken care of well. But I am concerned about the ones who aren't. And so I can see it being made. For instance, you can make it to provincial court. The provincial court judge then refuses it, on the merits. You can take an appeal on that issue to a higher court, to the Supreme Court, and of course, the Court of Appeal and so on that very issue, because that very issue may be essential to having a fair trial. So that hasn't been done. It may never have to be done, but it's all theoretically possible. And in an appropriate case, finding someone to argue it. Now, the way to do it is, and I would even argue actually that I can conceive of a case where the manager's lawyer, manager's counsel might look at a case and say, okay, I'm here to represent the manager. This person doesn't have counsel for whatever reason. I don't think it's going to be a fair process. It's going to be a process that might be challenged later if this person doesn't have counsel. The manager can certainly make such an application that counsel be appointed for the parent, and the parent then at least you'd have some more assurance of a fair process, right? When that counsel is appointed, then they'll decide what needs to be done. So again, this is perhaps a niche area, but I always think of minority interests being the easiest ones to forget. And so if this is 1, 2, 3, 4, 5 people a year, the whole community knows about this. And they see this person not going to court or going to court by themselves, coming back to, despairing and whatever they're going through. And they say, what is this process? I understand why they would say that, So again, out of respect for the community and the individuals involved, I think we need to have some kind of recourse where a person falls through those cracks. And we'll see if that ever becomes real. Now, if you go outside to a system which does not involve the provincial court, you're probably still going to need access to lawyers. So the same issues theoretically could come up, whether the adjudicator or the court, whatever the tribunal is that will be deciding on the difficult cases, will have the power to appoint counsel. This is an important point, because again, those cracks can occur in any setting, any tribunal, no matter how local it is or how governmental it is. And I would like to see the tribunal have the power to do the same thing that any judge would have as well. And when you're constructing the system, this could be considered.
Thank you. In terms of the obstacles to this problem, in your view, is funding the main issue, or are there other obstacles to access?
That's a really good question. Funding is always an issue in justice. it it never has not been an issue. So we'll leave that where it lies. But at the same time, a lot of it is cultural, what I would call community burden, cultural burden. What I mean by that is that you're dealing with, as I described earlier, a group of young, indigenous, perhaps undereducated parents with a lot of burdens, personal and otherwise, economic and so on. A group that comes out of probably very low income community and a low income portion of that community. And their ability to function in the legal context is impaired anyway. So the need is greater. And the interest that they have, the interest in their children, is even greater. Like we don't have capital punishment in Canada. I always thought that in the family law context, the equivalent is the permanent removal of children. You cannot do anything worse to a person, in our society than take their children away permanently. And yet that's what the system potentially could result in. And there may be excellent reasons for it, but it's a very high stake game. And so I've always thought that the burden and the onus that lies on the parents there to try to keep up with what's happening, to try to understand it and to try to participate in it is much, much greater than it is in the criminal law context. And we worry about it all the time in the criminal law context. Is this person adequately represented, et cetera, et cetera? Do they understand what's happening? But in the child protection context, the case can be made even more strongly for ensuring that a person has ready, willing, and able counsel. And so that was my concern. I have interacted with parents in that situation in all the Indigenous communities in Labrador, and they all struggle to understand. And that's if they don't have overwhelming personal issues. They struggle to understand how this could happen. This is even more true, of course, as you know, in the Innu context, because the Innu, from my familiarity with what I've heard in court and from elders and what I've read, for many, many years, the Innu took care of all their family issues, difficult as they might be, themselves. They might have got a little bit of help from this one and that one, and maybe the churches would help occasionally, maybe they wouldn't, but their provision of food and care and safety was always in their own hands. If you read, I'm sure you have, if you read, I have this book here now, one second. Excuse me. Excuse me. George Gregoire's book, Walk with My Shadow. Now, of course, I know George quite well because he always was there to speak to the court and help the court in Natchitoches. So I know him, but it's a wonderful book. And what he talks about is the terrible onus that often rests on people in the Innu communities, of dealing with the social issues around them, the family issues and the trauma and so on, and yet at the same time being responsible for their own children. And George is very graphic in this book about how he struggled with that and some of his thoughts about it, and he's very candid about it. But I think it just goes to show, and he's one of the most intelligent men I ever met in Labrador, and one of the most resourceful, and one of the most forceful when he wants to be. George is not a shy man, but I give that example because he struggled with that responsibility, and there's no reference to child protection matters, none. So all I'm saying is that I'm well aware that Innu have done everything they can for centuries and to take care of their families. And all of a sudden, in the child protection context, you're presented with a situation where not only do you not have the care of your children, but you're told you may not have them. And here are the many, many reasons why. And I think that hits home with an Innu parent in a way, as bad as it is for all parents in that context, to cope with. It's much worse for the Innu. And I compare them to the Inuit. And the Inuit always had the protection and oversight of Moravian culture, and since 1771 in Labrador. And so their communities were organized by an outside group who did not come from their culture, whereas the Innu were resourceful, self-sufficient. And so that's the reason why everything in the Innu communities around child protection, I think, to me, has always seemed escalated. It's always been more intense. And I'm speaking from my own observations and my dealings with people, but I think we have to remember that we're dealing with people who are struggling to be in the modern age. And yet at the same time, only a few generations back, they were expected to be totally self-reliant for everything, every day. And that's like the yin and yang of being Innu and Labrador, from my observation from the outside, how difficult that is for them when they get there and they're sitting in front of a judge and they're trying to figure out what's going on. So they need all the help they can get. They deserve all the help they can get. Their children deserve it. Because I used to say this to parents, it's self-evident under our child protection law, but when they're 16 or 17, they're on your doorstep. And the same parents that couldn't take care of them at 12 now must help them at 17. And so you cannot destroy the parents. You cannot allow a process that doesn't support the parents. And that's was one of my main concerns as we were watching it occur, is that they need support. Even if it goes a way they don't want it to go, they need that support.
Thank you. I think I definitely appreciate, and I hope the inquiry does as well, the repeated sort of emphasis that you put on the broader context to understand the issues that are arising in the legal system. I think it's very helpful to understand that context and constantly be reminded of that. I'd like to move to recommendation 2 now, which is about the need for a thorough review of child protection hearing timelines and potentially consider other timelines. I think you've covered quite a lot of this issue in your report and the presentation as well. But I wanted to just focus in on, you made a specific, I think, comment in your report that there used to be sort of much longer delays that were common in the court system, but this has improved substantially over the last decade. And I'm wondering if you can just speak a little bit more about the delays that have been eliminated. What type of delays are those ones that you see having been eliminated?
Yes, thank you. That's a great question. One of the big delays that we had when I was both counsel and on the bench was disclosure. You had a system where before you really made any progress, you had the application, of course. The application can be quite detailed, but it never gives you the direct flavor of the incidents that are concerning. And so disclosure does that. And it would take months and months and months and months, sometimes 6 months. And disclosure would not even be begun. And I have to say, I banged my head. Damage was done, I suspect. I banged my head many times, metaphorically, trying to figure a way to get it done. But the reason was bureaucratic. The reason was that it was expected to be done locally first, and there was never any staff to do it because it meant transcribing enormous amounts of material and copying material and redacting material and so on. And so the resources were never there in Labrador. Everybody was way too busy. And so we put up with it. I mean, we didn't like it, but often you could count many months before you even got to a position where a lawyer was fully informed or could sit down with their client. So my understanding from talking to the legal aid lawyers in particular is that that disclosure, and I said it in my report, has now been centralized and to that extent professionalized. And it does mean shipping around files, and electronic files are more easily shipped around than physical ones. And of course, now the files are mostly electronic, as you know. So, so all of that, but they were physical files when I started out on the bench, and they were, just getting them somewhere was difficult. So that big source of delay has largely gone. But of course, disclosure is an ongoing responsibility. And the case hasn't stopped because the children are still in care, social workers are still doing their work, reports are still being written, they need to be disclosed and so on. But once the bulk of the historical disclosure has been done, then the lawyer has a pretty good idea and can inform their parent client of what the details are and what you need to respond to. First of all, understand and then respond to, either by agreeing or qualifying or mitigating, whatever it is. So that was one big delay. The other delay that we had was conflict counsel. Now, I think you saw in my report, I went into the fact that I was part of the original protocol, devising the original protocol for legal aid as to providing conflict counsel. Because all legal aid lawyers are employed by the government, they all work under the one roof, really, even though they're geographically separated. There was a concern about conflicts when there's, say, two parents involved or two parties involved, either in the civil or either in the criminal or family context. And how would you arrange that? Well, anyway, that was all put to paper, and a protocol was put in place. But what we found in Labrador is that almost all the conflict counsel in most of my years there came from outside. St. John's, Corner Brook, Grand Falls, wherever they could, because the demand was so high. We had so many cases, particularly in the child protection context in those years. And it would take months. You would often get a name, fairly early on, like a month in. So-and-so is conflict counsel for the father, because the mother already has counsel. But then no involvement. So you come back the next month and the month after and ask the parents, have you spoken to your lawyer? And the answer was, so I don't know who my lawyer is. And I said, well, I've got a note here from 2 months ago. It was so-and-so. No, I don't know where my lawyer is, and I haven't spoken to my lawyer. And so the provision of conflict counsel meant that the parent who had lawyer was slowed down by the parent who didn't. And both parents were affected by it because disclosure hadn't been sent out. They were waiting for the lawyer. They were told there was a lawyer. The request had to come, but that lawyer was busy. That lawyer might be on 3 criminal trials. They might be doing 3 murder trials in 3 months. And they are now the lawyer on the child protection matter. So, however, I understand, again, conversation with the legal aid lawyers and officials, because I did talk to the officials in St. John's as well as the lawyers in Labrador, that they've now expedited that. And certainly at the early stages, they provide counsel to both parties. And if there's any appearance of conflict at all, they provide 2 lawyers, 1 to each of the parents. And they're there for the presentation hearing, which is really important. After that, of course, then they have to go through the formal process. So we've avoided some of that delay as well. It can come up because a conflict can become evident, as you know, somewhere in the proceeding. You can be 6 months into it, and all of a sudden there's a conflict for the lawyers. Or the common one that came up is that the parents were together as a couple at the beginning, but then as matters went on, they were no longer a couple. And so all of a sudden their interests are quite different, and what they want is quite different. And then you'd need a separate counsel for them. But my understanding is that legal aid now responds to this fairly well, because they've got the special office in Goose Bay, which is separated, the conflict office, but they've got the other lawyers there who can participate and represent another party in Labrador. So they know the Labrador, they know the communities, they might even know the individual. It works much better. So we've avoided that. And those were huge, huge elements in delay. But as I said at the end of my presentation, circuit courts are fragile. And when, for whatever reason, the ability to go to the community and deal with these matters disappears for a month or a year, all of a sudden you were making great progress, and you're not making great progress anymore, because you can never get that hearing that you need. You know, that issue that comes up. For instance, one of the issues that used to come up, was frequently raised, is while the proceedings going on, the parents want either more or some or better access to their children. So the children are somewhere else being cared for, but parents want to see the children. And they're trying to negotiate that with the social workers, but they can't. And even though provincial court judges are very reluctant to get into that, because they realize there's all kinds of factors that they can't control, it would come up a lot. And a judge would have to at least speak to it, you know, once the issue was raised, would have to address it, if not make a court order, and or at least try to urge the parties to work something out, because it seemed to be sensible. I found that was often very difficult if the parent didn't have a lawyer, because they would have to speak to the court to explain their personal circumstances and, you know, what kind of contact they wanted. And that was often extremely difficult, and not always for linguistic reasons. So at that point, you really, really missed having the other lawyer there to help the person, because maybe they were motivated this month, you know, because they had time, free time, or they had money or whatever. And then the next time they come back, their circumstances have changed. They're not so motivated. They're not asking. They've missed the opportunity, you know, and you realize that you have to grab these opportunities as they occur. So the absence of counsel will slow it down, but the absence of going to, and I'm thinking particularly of Natwashish here, the absence of going to the communities and trying to deal with these things over the telephone, or that it's very difficult to have people heard. And there must be tremendous frustration within the parents. I've heard some of it, but you know, they're incredibly polite. I will tell you, the parents put up with things, they listen to things that would be very hard to listen to, but the degree of politeness in these proceedings, and I dealt with this for so long, but even the 14 years I was hearing them all the time, I don't think I had anyone ever talk out of turn. Sometimes I wanted them to talk more, but they didn't. But there was their frustrations they kept within themselves, and they carried on as best they could. So yeah, it's very important to go to the communities and to have the lawyers there for any kind of a hearing. Anyway, if you're getting into if you're getting into merits and evidence and long submissions and all that kind of thing, need to be there.
Thank you. I feel you have a great ability to anticipate what my next question is and answer it as you go. So that is very helpful. I appreciate that.
All right, everybody, thank you for your attention to that video this morning. We will now have a quick 5-minute break. So we'll start just before 10 with the next video, and that will be the final of Bill English's testimony. That one will be 2 hours. So we'll have a quick 5-minute break now and then come back for a longer video.
Good.
All right, welcome back, everybody. We're now going to resume with the final video of retired Judge Bill English's testimony. As I said before, this one is 2 hours, so we'll do the 2-hour video now, and after which time I expect we'll take our lunch break. So enjoy the final bit.
Great.
Good, thank you.
Okay,
Oh,
well,
good.
all good to resume?
Whenever you're ready.
Okay, so if we could move to your third recommendation, which I understand is to improve and professionalize Innu interpretation services. I take it from your report and presentation this morning that you see some gaps in the support and training for interpreters. So in particular, the inability to trade off with other interpreters, the absence of mental health supports, and perhaps room for improvement in terms of compensation for the interpreters. So just wanted to confirm that those are elements that you see needing to be addressed, and wondering if there are any sort of other supports that you might recommend for the for interpreters.
Yes, thank you. That's a very important question. The way the current justice system works in Labrador, interpreters are needed for a lot of different purposes. And obviously, we're not talking about the criminal caseload, but that's an enormous demand right there. But the family law side of it is equally urgent. And the lack of training, I think, is the other aspect, the lack of initial training. Although we have very experienced people there, they tend to be older. If I look at the average of the age of the ones that I know about now, they're in their 40s and 50s and 60s and maybe even older. So you can foresee a time when you will need, well, we need it now, younger people coming up, people who maybe look at this as a career opportunity, because whatever they learn, the way it works in Labrador now, whatever they learn as interpreters for one area spills over to their advantage and the community's advantage to another area. So I see this as a somewhat larger problem, really, in the effort to preserve the language and continue to preserve the language. There has to be a move within the entire community. And I would like to see it led, obviously, by the people who lead the communities, to recruit and train these people as professionals. I mean, I think the room is there for it. I don't know much about the dealings between the Innu and the provincial government, but I would think both translators and interpreters could be very, very, very important there. And I'm sure they are, and they're well provided as much as they can. But this is a big issue, and family protection cases, child protection cases, are just one example. And as I said earlier, perhaps the most difficult area in which to recruit and keep people. So I would like to see, I recommended, I think, a pilot project. And I thought, since this is a niche area where you don't need 10 interpreters, for each community, you may need 2 trained and qualified or 3 trained and qualified interpreters. This might be an area where the communities could start experimenting with proper training and recruitment and all that. And yes, compensation is definitely a part of it, including very, very important to have time off. Some of the people who acted as interpreters for us over the years, I said they were brave. They're more than brave, because some of them had their own personal issues, and they were dealing with those while they were also trying to be assistance to the court, when the court needed them. And it wasn't easy to balance. So yeah, I think that this is really important. And now, if you had a completely Innu controlled child protection hearing system, and service system, then of course the need for interpreters would be reduced, and the expense of it. Because within that system, everybody who functions would come from the community or be sufficiently attached to the community that language would not be the barrier that it is now. Language is a barrier because the people like myself and others don't have the language. But if you carve out or create a system where that becomes secondary, then the only reason you need those people is perhaps to to convey information to others outside who need to have that information about the system. So that's another advantage of having a completely Innu created, derived, and operated system, is that this burden would disappear. Now, mind you, you still need it over there for the criminal cases because they're probably staying where they are. And so it's still an issue for the community.
And in your answer and in your report, of course, you mentioned this pilot project, and you've just noted that you'd like to see it Innu run. I note in the report you suggested specifically, you had suggested IRTS, I believe, to run the pilot project. Do you have a strong view on IRTS doing it versus having maybe just the 2 First Nations do it, or was your observation more general, more that it would just be preferable to have an Innu organization lead the?
Yeah, I think that's the first thing. An Innu organization, you could create one whose responsibility is interpretation. You notice that it's buried in one of my footnotes. I mentioned from way back when in the 70s that there was a training program for Innu and Inuit Indigenous court workers. And that came out of a grant program, and it was around for at least 5 or 6 years. It was an example of how you can set up a local agency which provides an absolutely essential service, but have it run, by professionals or by people who are able to deal with the needs of that program, but accountable to the community. And I think that that's the model I'm talking about. And how you would do it is debatable, but I'm sure it can be done, and you don't need a huge enterprise, but you need a focused enterprise,
And I believe your comment about the 2007 program was that, a sort of longer term sustainable approach would be necessary moving forward. What are the things that you see are necessary to make sure that any sort of pilot program, if successful, is sustainable in the long term?
Yeah, that's a very good question. I think it would lead to have a term of operation at least 5 years. I would start with 5 years because you really can't do training and recruitment and then a little bit of operations in less than that. A lot of the spade work was done in 2007. I mean, the way that was done was good. The only thing I would change is that since you have the 2 main communities, I would do the training in the communities. I would bring the trainers to the communities because it was very difficult. There were people who had to drop out, fall by the wayside because of family responsibilities, which they really couldn't handle for long periods of time being out of the community. So, but you could do that. Once you put your training module in place, you've got some experienced interpreters within the community now who could become part of your training program. You've got the glossaries that were devised in 2007, which might need to be updated, but not by much. And that was a tremendous effort. That took 2 years at least of solid effort. And that had never been done before. So, that's an asset. But I would say at least 5 years, and you need some degree of independence to the group. Not in the sense that they don't communicate or report, but once they're set up and they're trusted to do the job, then they'd be given a budget and they'd be able to carry on more or less independently and with maybe annual reports or something of that kind. In other words, it's kind of like setting up a nonprofit agency, but with a very specific limited mandate. The biggest question would be funding, because There'd had to be a proposal for funding with a detailed budget as much as you can, and then mechanisms put in place to, especially in the first year or two, to make them accountable for that budget, because these costs can spiral out of control. But one of the great things is we do have the technology now to do training. Like, for instance, it's nice to go into the communities and do the training, but you can do supplementary training and experience and work experience through technology with the courts. You don't need to create it all in person. We didn't have those things back in 2007, not to the level we do now. So I see a proposal that would amalgamate both those delivery mechanisms.
And even when there are, let's say, interpreters available and translated court documents or legal resources, would you agree that there likely needs to be some additional support needed to explain the significance or the meaning of the steps in the legal process? So, for instance, as you may be aware, there are Indigenous court workers, for instance, in other jurisdictions that play this sort of navigator role, not necessarily giving advice, but just sort of explaining where to find things, what the process is, what the steps are. Similarly, in the health context, you've got patient navigators to break down sort of the steps in a complex system. Do you think a similar sort of court navigator or court worker role would be useful for Innu parents?
Yes, and we have the model in Labrador now in the health system, because they have health navigators in both the Inuit and on the Inuit side and the Innu side, who help people when they're dealing with hospitals, for instance, and medical care providers. Yes, I think that will be excellent. Now, legal aid, of course, has its community service workers in each community. And in the Innu community, they have one, I think, now that helps them in both communities, but they could have one in each. And that's their function. Their function is because they're speaking Uemun, because they know the communities, they go in and they assist the legal aid lawyers, but they also do their own independent work before, for instance, a court circuit, to answer questions, or as questions come up, they field the questions. They do their best. If it requires talking to the lawyer, they also do that, and then they communicate back. But whether you put it inside the legal aid apparatus or whether you create it outside, that it's sort of the function that in our criminal law system, the victim services worker performs, where it updates, it's supposed to. Anyway, I'm not sure it's working well here these days from what I hear. But they're supposed to keep victims informed of the progress of the case. And these are minimal expectations, but you could do it separately. I know some provinces have Indigenous advocates, on a sort of a larger scale. Manitoba has something like that. And their job is, again, to keep members of the Indigenous community informed and aware and to field their inquiries. Lawyers can do it, but lawyers are very, very, very busy. And the ones in Labrador are super busy. So it can be hard to pin them down to get an answer to your question. And even the court worker, who I did have occasion to meet with a couple of times and who I know very well from my involvement there, he sometimes says he gets like many, many calls at home at night, with important questions, right? And there's only so much one person can do. So they've been trying, legal aid's been making an effort, and there isn't really anything at the court, attached to the court these days, that does that, except the court clerks in their ordinary, the ordinary duties will try to answer questions, but they can't really go into it in depth for the same reason. They don't have the time either. So I think that would be an excellent idea. And you could, that could be generalized. Legal aid's budget could be added to, because they could use one or two more community service workers, community social workers or service workers. And they would reach a lot of people, particularly if they were able to go into the community independently. Like, for instance, if they were to say, I'm going to be at such and such a place for 2 hours on a Tuesday afternoon, and anybody who has any legal questions whatsoever can come and talk to me. there's no time right now in the current scheme for anyone to do that. But I can, and when they're done, when it's done in a crisis situation, of course, it's a crisis. So there's a lot of frustration and trying to pin people down. But a lot of the questions can come up both on the civil side, the criminal side, and the family side that could be fielded. So I would like to see that service extended. Yeah.
And returning just briefly to the need for interpreters and the pilot program and hoping to get sort of the professionalization set up on a more long-term basis, do you see any legislative change that's necessary in order to implement that kind of program?
Well, I pointed out that in the current child welfare legislation in this province, there is no mandate, no linguistic or interpretive mandate. Now, there are all kinds of things about the cultural and linguistic needs of the child, and those are fairly recent, but they're very important. But there isn't anything in there that would either require or encourage the current providers, the courts, justice, so on, to maintain an interpretive service. I mean, they do it. You know, the payment comes from government and all that kind of thing. There is a fund there for that. But if they decided tomorrow that somebody else should do it, it wouldn't be there. And it can be difficult in the family law context to get that authorized or arranged in the same way, because there isn't the demand. It's more occasional, if you know what I mean. It's not in the criminal context. There's an interpreter needed every day that the court operates in Labrador, every single day. I mean, I once sat down and just before I left, I took a month's court docket, and I sat down with it in Happy Valley Goose Bay, because that's where all the court was then for that area. And I went through it to see what was the likely community of origin for the people who were appearing before the court. And you can pretty well go by last name, although not always. And it came to 65% of the people appearing in court in Happy Valley Goose Bay were from Innu communities. Primarily Sheshi, but not just, also Natchitoches, because of course people come and go in the community a lot. And that was surprised even me. I would have thought maybe 50%, but it was 65%. And that was a typical month. So the need on the criminal side is huge. On the family side, it's smaller. I mean, ideally, you would create one training, if it could be organized, one training for all interpreters who deal with Innu people. And of course, it could be also done for Inuit groups. But the urgency is on the Innu side in every day of the week by comparison. And so if there's an initiative to be taken, I would take it on that side.
Okay. I'd like to move to recommendation 4 now, which is about having more full-time Innu social workers to be recruited and trained for both Innu communities. I am going to put an idea to you and want to get your feedback on it. I'd like to suggest that this recommendation can be understood, or maybe is best understood, as sort of 2 different sub-recommendations. So one being about the need for full-time social workers to address the issue of sort of the fact that staff are not staffed on a full-time basis, but rather rotational for Innu communities. And then the second sort of part is transitioning to a greater composition of social workers being Innu to address sort of more of the cultural familiarity issue and some of the issues of being in community. Would you agree that you can understand recommendation 4 as sort of these 2 recommendations?
Yes, absolutely. Yeah, there are two issues, 2 problems, you could say, or challenges, but yes, you're quite right, because right now not all the workers are full-time, and sometimes there's a trade-off there, because I met with some of the rotational people, I'll call them, and they're incredibly experienced and astute and concerned, and so you're getting experience, which you don't always get, particularly with new social workers. I mean, we went through that, and that's a familiar trope in the North, where people come at the beginning of their career and they're learning on the job, and they're working hard and so on, but they don't always bring with them the experience or the advanced education. So ideally, you'd get both, but really, I think if I had to say which one I'd want the full-time workers. And that's no comment on anybody. It's simply because they get to know the community better. They have a higher stake in the community if they live there. And the community respects them for living there, regardless of where they come from. I mean, if they're Innu and they're living in an Innu community, of course, they'll have connections anyway. But even if they're from another community, the fact that they live there makes a tremendous difference. And you can, if you look at, for instance, Natchitoches, and you look at the people who've been living there full time from outside, and I'm thinking of some of the nurses and nurse practitioners and so on who've been there were there or have been there for many, many years, the degree of respect in the community for them is at a high. So I think full time is good, and there ought to be incentives to turn 2 years into 3 years or 3 years into 4 years, but it should be at least a 2-year commitment, because anything less than that, you probably haven't figured out a lot of things by the time you're finished. So yes, full time is important, and then the fact that there be a higher proportion who are Innu and Innu speaking, to me is, I mean, it's where it's all headed. It is all headed there. And the reason why that's so important is because I don't know how you communicate through an interpreter over the long haul with people who speak a different language than you and not lose a lot of connotation and nuance and all that kind of thing. And so having the language, being an Innu person speaking to an Innu person, can't replace that. Nobody can replace that. And we know, because of the new training program that's been put in place, that the raw material is there. There are more children now graduating high school in both Innu communities than ever has happened before. And so that gives them the basic qualifications to move on to either be fully qualified social workers or in an assistance role, sort of a social work clerk or a social work assistant. I mean, you don't have to have a full degree to be extremely useful in the social work field in a small community. So, I mean, I'm thinking in terms of that, I'm thinking in terms of both. You want someone who's qualified to make decisions, but you also need someone to do all the legwork. And sometimes that'll take more than one person. But I can't tell you how impressed I was when I heard about the training program. And yes, they may lose a few people along the way, because that's the way these training programs are. But with encouragement, the new people, the young people who have already had some academic success will come by, because you see, this is one of those great jobs that you can get in your home community, where you have a lot of responsibility. Hopefully you're paid well, and you will over time gain respect. There are not a lot in the Indigenous communities like that, other than such as with the band council, with treatment organizations and so on. But this one is particularly important. So I would see a lot of young people being quite willing to give this a try.
And so on the Innu training program, you'd agree that they've made some good strides, and it's great that you were able to see that. But you'll agree that it'll take some time to get sort of more people through the program and qualified as social workers. But there is an immediate need right now for changes to the staffing model to ensure full-time coverage. Have I got that right?
Mm-hmm. Oh, yes. I mean, that was the feedback I got. Everybody is overloaded. They're all working flat out. and they're giving it everything they have, but you can only be one place at a time, and they're simply not thick enough on the ground. So yes, I agree with you completely. There needs to be support. I mean, a lot of what social workers do is documentation, and to the extent I know is now computer based. You know, it's electronic in many ways, but even having assistants, you know, if you had two social workers and one assistant whose job it was to do a lot of the more mundane things that the social worker doesn't need to be doing, that in itself would be a tremendous help. I know they do have some staff, but again, they're not very thick on the ground. So yes, there is an urgent need. There always has been. There's a lot of turnover. I can't tell you how many, you know, I just get to know the last name of somebody sitting at the back of the courtroom. And next thing I know, they had moved on to something else. And that happened the whole 14 years that I was there. So I wasn't keeping track, but I couldn't help but notice that there was a lot of turnover. You know? So yes, that has to be a priority. And if they can be Innu speaking, great. And if not, they had to be comfortable with whatever process allows them to do the job. If that's using interpreters, then yes, they need those people, or people in the office who are willing and able to do it. Because unlike a court, the thing about a court is, and I meant to make this point earlier, is you have to create a court record. All court proceedings have to create a court record for all kinds of reasons. One of them is appeal, the other one's review, and of course the other thing is it helps all the parties to know what was said and not said. When you're in an interview, you don't need to create that kind of record. You know, you don't need the level of interpretation, but the social workers need to be able to be free to record what happened and understand it. So interpretation becomes important there in a different way. If it's an Innu-speaking person, it's also a bit of a support for whatever parent is involved or extended family members involved, because they will probably know that person. And once they get over the initial embarrassment of talking about their family, which is real, I would expect them to have a degree of comfort that they can talk in their own language and be understood. So there's a lot of things that are needed, but in the decision-making side of it, you need social workers. You need trained social workers who meet the criteria to be able to make these difficult decisions. They are very hard. Even the decision about a visit can be hard between parents and child. That can be hard. And I have a lot of sympathy for them because they frequently have to say no. And, you need a trained person who knows how to do it and to deal with the saying no part as much as they can.
I'd like to move to your next two recommendations. I think they're quite related, so I'd like to talk about them together.
Yeah.
Recommendation 5, that parents must be fully seen and heard during court appearances in child protection matters, and recommendation 6, that absent full consent, substantial hearings in child protection matters must be held in their home community. So I'm not sure if you're aware, Cheshi First Nation has been advocating for the return of the circuit court to the community.
Yes, I am aware of that. Yeah.
Okay, and is working on plans for a space for this to be hosted. Do you think that the return of circuit court to the community, having a dedicated use space for it, fits with recommendations 5 and 6?
Oh, absolutely. Absolutely. That it's only because those things have been absent that that this became an important part of my report. Now, obviously, you having access to justice when all of it takes place outside your community is problematic. And, I won't go into what I understand to be, the governmental policy behind those restrictions. It's a policy throughout the province. And our province is pretty well connected by roads. And of course, Cheshi is well connected to Goose Bay by roads. But when you look at the makeup and the issues and the difficulties, the childcare responsibilities alone in Sheshi that people who are parents have to deal with. The care of elders, the care of parents and grandparents. It's all falling on younger people, and they're often parents themselves. When you look at that, I think the whole scenario of saying to somebody, you must come out of we're setting a week for your hearing, and you must be here for that entire week away from your everything else that is part of your life, is not fair. It's really not fair. And so, yes, I agree that and I was aware that there was some move towards this, and I was hoping that it would advance. It would cover off an awful lot of the worry, I think, that people have. I mean, it's bad enough, and I issued an awful lot of arrest warrants for people who did not show up from Sheshi to court in Goose Bay. And then, you'd issue the arrest warrant in the morning, and the person would show up in the afternoon because it took them that long to get a ride. I know how that works. And if they get a ride, it often costs them money, and sometimes a lot of money. So, unless you live with that and you see it every day, you might think, oh, well, it's just a ride. It's a reasonable highway. It's this and that. But for these matters, it's very important. And I'll tell you how I learned that. When we used to sit in Sheshi, most of our time was criminal matters, we'd often have a witness who wouldn't show up. We'd be in the middle of a trial. We'd need to move ahead. The Crown was ready for the witness, and they wouldn't be there. Well, we would simply take a 10-minute break, and we would ask the officer, who usually volunteered, to go and knock on the door. I wouldn't issue a warrant. They would go and knock on the door. It took them 2 minutes to do it. And 7 minutes later, the witness was right there. I mean, that sounds simplistic, but actually that's how it works in a small community. Sometimes the person's there doing something else, they've forgotten, or they're reluctant, or whatever, and you have to make that personal contact. Well, if you're in the community, that works. Not everybody has a helicopter, like I spoke to earlier. We can't always drop in and take someone in a helicopter. So, I call it humane treatment. It's humane to require someone to come to court within a reasonable distance. And if they're Indigenous and they're poor, then a reasonable distance is not 50 kilometers away, in my humble opinion. It's in your community, within 5 or 10 minutes walk or drive, depending on the situation. So, yeah, I think that if the hearing spaces were created and they had all the technology that was required and a good feed line, whatever way it's set up, it should be as good as it is in Happy Valley Goose Bay, and I think that would help a lot. There may be cases where parents will agree to something else, and the lawyers will recommend they agree to something else, but that will be the exception.
And so you've suggested a pilot project for hearing rooms and justice spaces in Sheshi. I just wanted to confirm that the recommendation and the discussion, the need for the spaces, it's equally applicable to Natrashish.
Oh, absolutely. More difficult, more challenging, more expensive, but the principles are exactly the same. You can't hold a hearing unless people can see and hear one another. I mean, that's, it's so basic that I even hesitate to say it that way, but that's the truth of the matter. And somebody made the point to me after the report that even when people are on the phone, and I know this is true too, and it's not just because my ears are old, but trying to hear and understand and to be heard and understood is a challenge for almost every conversation, every part of a hearing, or even if it's a 10, 15-minute hearing. I would often ask people, after we go through something and something be said and there was something to be done, sort of steps to be taken, I'd often ask whoever was on the phone, now, can you tell us, what steps you're going to take? and sometimes I got exactly the right answer or what it was, but other times I say, well, I didn't really hear that part. And so the whole point of having the hearing was lost because there was no hearing. There was no understanding. Some of it may have been linguistic, but I think a lot of it was just the technical difficulties of not having a good, steady Wi-Fi signal that would then connect to your cell phone, or other interferences. So yeah, to me, there's going to Natchitoches and having an adequate place to sit. And I did comment at a bit of length about the current situation there when the court does go there is to sit in the school. I did that myself as a judge for, I'd say 4 or 5 years. And it's the only alternative right now, but it is totally inadequate for a whole bunch of reasons that I outlined in the report. And it's not dignified. I'm not thinking about my dignity. I'm thinking about someone coming in talking about intimate family stuff. That's, to sit in a music room, really lovely room for that. But for a courtroom, you need to have a place where there are not children coming and going in the area. And it's even worse for the criminal matters. And you can only imagine how ugly that gets. But for the child protection matters too, some solution needs to be. And I'm well aware of the challenges. I know about the fires that happened up there recently, the band council office and so on. I mean, I know there are terrific challenges for the people running the community. I know that. And I know the expense of trying to build anything new in any of the communities. So, but at the same time, if you're going to require people to come to court and subject them to having somebody decide their future, I think the least you can do is make them reasonably comfortable and secure. And so I have very strong feelings about that. And I don't think it's going to change. We're not going to have a road to Natchitoches anytime soon. The boat only runs and doesn't really solve our problem. It only runs part of the year, doesn't solve the problem. Airline tickets are incredibly expensive and unpredictable. So, I think this is, I was trying to get a handle on the population of the communities, and I didn't spend much time on it in the last few days, but those communities are growing anyway. And the last census, we'll get new figures now after this year. The last census, 2021, the proportion of young people under 18 was about 3.5 times what it is in the rest of the province. The size of the part of the community that was that young. So these communities are only growing, and to not prepare for that, because these social issues that unfortunately everybody's laboring under, everybody's working very hard on it, but we know they're not short term. So any more than they're short term in downtown St. John's, I can assure you. I roam around the city and I hear stories from everybody, and I see people. So I know that these social issues are really, they're entrenched and they need to be allowed for.
I'd like to talk a bit more about how to sort of get this off the ground, assuming funding is a huge issue, and you've spoke to that. Assuming that is secured, are there any other non-financial barriers that you see to setting something like this up, getting the pilot program going and having it continue on a more sustainable basis?
That's an interesting one. There's lots of expertise out there and experience. So that, I don't think that's an obstacle. I mean, in terms of advice and how to set the program up, there's lots of experience and intelligence and knowledge within the communities. People who've been involved with the court, dealing with the court, they know what the challenges are. I don't see, nothing jumps to mind anyway at this point. I think in the back of my mind, there's another thought, and that is because preventive measures are stepped up, and every indication I was given is that the number of cases will diminish. The cases that actually have to go to a full court hearing will diminish in coming years. Is that the burden of this should also diminish, which means that whatever resources you put in place now will probably continue to be adequate for a number of years. So even no matter what budget you come up with, it's like the situation with our schools now, where we have fewer and fewer children in the province, not in Labrador, but on this part of the province. Every year the school population goes down and the number of teachers stays the same. And so there's more resources available over a stretch of years. I think the same way about anything like this. If you set up a pilot project now and you did it reasonably, it should carry through and be adequate for 5 to 10 years if you gave it that much of a tenure. But no, unless there's some particular thing that you're thinking of, I don't see any non-financial barriers. I mean, obviously, you'd need the cooperation of the province. This would be something that would be done by agreement. And whatever is determined by the province will dictate what the courts can do and what legal aid can do. Because the courts as administrative bodies are complete creatures of the province. And legal aid, aside from the funding agreements with the federal government, legal aid is also an agency of the province. So if you get them on side and you have those professionals there, then I don't know why it wouldn't work. In other words, what it would be, it'd be like reinstating a full circuit court, only with very adequate facilities. Because we never had that. Even when we sat in Sheshie and in Nantrashish, we didn't have, yes, we had a little console, for phone calls and stuff like that. But sometimes that worked and sometimes it didn't. We never had a video that worked in our courtroom. Now they do in Goose Bay and they do in Wabush, of course, but we never had it on circuit. So it was never properly equipped. So that if you had a witness or a lawyer who was in St. John's or Corner Brook or even Goose Bay, who didn't need to be there for other reasons, that lawyer can make an appearance and be quite willing to make that appearance by technology. So this would be an improvement on the circuit courts that we did operate previously. So I couldn't see why it wouldn't work, really.
And so in addition to, the making sure there's enough sort of technical support or technology, would there also be a need to ensure sort of the adequate administrative support to run the court system, essentially?
Now, are you thinking about the existing court system operating within the communities, the existing apparatus?
Yes,
Yeah.
in order to sort of get the pilot project going and ensuring that it maintains itself for a longer period.
Yeah. Well, I mean, in that sense, once you bring the court and you bring the lawyers, particularly legal aid, and of course the manager's lawyers as well, and whether they're present in person or by video for certain hearings only matters depending on whether the hearing is significant or less significant. But they're self-operating. Court clerks they work magic every single day. Like, I cannot tell you how many times a court clerk bailed us all out of some technical, functional, operational airline mess. They're incredibly adept, and I know several of them. They're still there, but it wouldn't matter. I mean, they just have a knack. That's why they are in the job. So they make it work in the sense that if you arrange the court and you set it up on a schedule, They will make sure that everybody has notice. They will make sure that everybody knows that when they go there, for instance, lawyers, they can either appear in person or they can appear, and here's the technology that is available. You know, that's their job. They make this all known. And of course, after a while, it'll be self-reinforcing. But I don't think you need a lot of administrative support. I mean, you need the mandate from the Innu communities and from the provincial government. That's really what you need. And I would think perhaps one thing that would be very useful would be a kind of a protocol, because there are court rules and all that, but we're not talking about court rules. We're talking about a protocol where each of the main parties will agree that this is likely to work. And that would be an operational protocol where you would say, you know, we, as lawyers, we expect these facilities to be there. As judges, we expect these facilities to be there. As Innu, in the Innu community and the social workers and whoever's supporting the parents, we expect these things, and we all agree on what they will be. I mean, I think an actual protocol that has to be negotiated, reduced to writing, and can be updated from time to time. I think that'd be very helpful, because that's where when lawyers want to know what's going to happen in court, they call up the court clerk. But this is a bit different because you've got three major entities involved. You know, the community, the court, and the parents as well. Four, I guess, if you sort of categorize them. You know, you need to have it laid out in advance. And that way, when a parent, for instance, 2 weeks before a hearing, calls someone up and says, well, what's going to happen at that hearing? They can tell them. Your lawyer can appear by phone. Your lawyer can appear by video if they're not around. You can go there, and you will be able to see the judge, because either the judge will be there or the judge will be there by video, and et cetera, et cetera, et cetera. In other words, everybody has since you're creating something a little bit different, everybody has to know what that thing is.
I'd like to move now, last bit of questions, recommendation 7. Having dispute resolution methods expanded and employed in child protection cases. So you talked a bit about this in your presentation this morning as well. You know, there's different sort of options, judicial case conference, mediation. To your knowledge, have there been any examples of alternative dispute resolution being used in an Innu community or in an Innu context in a child protection, for a child protection matter?
I think there have been some case conferences which involve the social workers and the parents, and sometimes the lawyers are directly involved as well. I was told that there have been a number of those, although not a great number, but that when they were done, they were very much appreciated. And I got that from the social workers as well as from the lawyers. When they occurred and everybody was there and they got to thrash out either final issues or, more likely, what I would call interim issues. Like, for instance, one of the frequent problems is that the social workers work very hard to follow up with the clientele while they're in the middle of the proceeding, you know, to see what's happening. But the parents are not comfortable anymore because now there's a proceeding ongoing. And so they often either are reluctant to go, they don't, you know, they're not prepared to go and meet with the social worker, or they go and it doesn't go well. And so the breakdown of communication is and it's not, again, it's not just in the Innu communities. This is common to child protection all over. There's always a risk of a breakdown of communication, particularly between the social worker and the parents once the proceeding is ongoing, because then they're in a slightly different, the social worker's in a slightly different role and the parent feels a little more threatened. So, you know, any opportunity for the parents to feel empowered, because I see these as empowerment moves, if you think about it. All case conferences are voluntary. If the parent says absolutely no, then they won't go. and you can't make them go to that kind of thing. Same with mediation. Mediation is a voluntary process. People have to be saying, I want to make progress, or I want to resolve something. You know, they have to be sending the positive vibe. Otherwise, none of these processes work. So, but at the same time, when a parent goes and is listened to, not in a courtroom, that's one thing, but in a conference with the social workers there and the support of their lawyers, they have to, because I have gone to those as a lawyer in years gone by in child protection cases, and it never came out perfect, but it always came out slightly better. And I always ensured that my client, even if they spoke only for 30 seconds, that they spoke, because they heard people listening to them. And so the human side of it is very much supported by alternative dispute resolution. Now, of course, we had lots of experience on the criminal side with sentencing circles, particularly in the early years, and then various things happened where the sentencing circles weren't occurring. But they're still being done occasionally, and even the Supreme Court has done some. So it's the same process. People gather around, perhaps in a circle, and they get heard. They get a chance to speak, they get heard, and it's an organized effort to do that. So that's the main reason why I emphasize dispute resolution methods, both the ones that exist and then other mediation type methods. And the judicial case conference is the in-between, with the element being the presence of a judge. And the presence of a judge generally will be a very positive influence, because the judge is a neutral, like a mediator. The judge is a neutral, no stake in the outcome. And the parents kind of know that. Everybody else kind of has to have a stake in the outcome, but a mediator doesn't, and a judge on a judicial case conference doesn't. Again, why I can't speak to exactly. I never really got to discuss that with the people involved, why there aren't judicial case conferences. It seemed to come down to how busy everybody is and how difficult it is. It's the same reason ultimately why we didn't do so many sentencing circles at the end. Often they would involve like 13, 14 people, and to organize anything with 13, 14 people is difficult. And it often fell down on the organization part of it. So it does need some support, but I think, as I say, because my involvement with mediation organizations and my experience with it, I know that people, if they can only resolve one issue, supposing it's a visit, they have a whole other mindset about the whole process if they do it voluntarily. And unfortunately, that doesn't happen in court, because in the final analysis, they may reach agreement, but often they're in court because they're looking for a judge to resolve it for them. But I'm a great proponent of having parents have as much involvement in the decision making, and particularly in this context, about their children as can be. You can't give them the full decision making if they're concerns, but you can give them a voice and you can give them a forum. And courts are not always the best one. And I'll tell you, the other thing is, under the current system, and I did remark on this, I think, in the footnotes, the laws are about to change in Canada somehow. And so all the criminal matters that we have now are going to get way, 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 way more complicated. And I foresee that the provincial court, which deals with those, whatever burden it has now, the burden is going to be at least increased by 50% because of various changes to the criminal law. And yet that's, under our current system, that's where family matters end up, competing for time and attention. So, this is going to get more urgent because of that. That's out of our control, but it's all happening. And I don't see it as making lawyers' jobs easier or courts' jobs easier. We frequently had to bump child protection matters to deal with criminal matters in Goose Bay. This was an everyday thing. And the only thing I wouldn't bump was a full hearing. If we had a full hearing, nobody could persuade me to adjourn it unless they were also asking to be adjourned, because you don't miss your chance. But it's a competition of time, and it shouldn't be. But that's the realistic side of it.
So you've outlined quite a few benefits, I think, of going through the mediation process, but also I think importantly highlighted that participation is voluntary, and a lot of the times participants may be suspicious or there's not really buy-in to the process. From your perspective and experiences as a judge, do you have any thoughts on how to get that buy-in from participants? How to maybe present that option in a way that is appetizing for participants?
Oh, that's a terrific question. Thank you for that one. We recently had a conference here on mediation a few months ago, and we had some national people, lawyers who've been working in this field for 40 years. And what they emphasized was the flexibility of these processes in comparison to litigation or court processes. So one example of that is, for instance, when you're in a mediation context, and this can also happen with a judicial case conference too, and so on, you can do what's called shuttle mediation. And what that really means is, particularly if you've got, say, a young couple who've had some interpersonal problems between themselves. So they've got problems because their children are, in care or about to go in care, but they've also got problems between themselves. They may have a history. They may have a history which is not, which causes one or more of them to be concerned about being in one another's presence. Well, in a courtroom, unfortunately, they're sitting right there. You really can't change it, in a mediation process, and the good mediators that I know right across the country, when they see this kind of dynamic, and they go out of their business to screen out cases where there may be some history that's concerning, they simply meet with the parties individually. They do the shuttle thing. Now, they may bring them together, particularly if they're close to reaching an agreement, but you don't have that flexibility in a courtroom. And so the buy-in may come from the fact that persons, I don't want to sit down at that table with that other person for whatever reason. And you explain to them, well, then we can ask the mediator so to have meetings with the two of you back and forth and discuss the issues, supposing it is something like a visitation, will you go together? Will you go separately? Who's going to pay for the visit if there's a money issue, all that kind of thing. And that's the other thing. If you can sell to people that they have a certain amount of control over the environment in which it happens. Now, the group that I've been involved with, we've been trying to sell this to lawyers, because lawyers deal with these people. They know the law, and they know the practice, and they have the experience. We've been trying as much as we can to promote this whole idea of recommending it. As you probably know, in 2021, the federal government massively changed the responsibility of lawyers in the divorce context and put on them a requirement to recommend counseling and dispute resolution and mediation to their clients, whatever facilities were available. This was a major change. It took 20 years for it to happen. And so now, in certain family law contexts, a lawyer has to have that discussion with their client. And not only that, they have to sign off that they did it. So we've been trying to promote an awareness among lawyers that this is an option in family law context. And I don't see any reason why in child protection it couldn't have a role. As I said, it may be in a limited number of cases, but those cases are the ones that eat up so much of the time of the courts and the lawyers involved. They are sometimes they are high conflict cases, and sometimes they're cases that may involve a kind of personal animosity that hasn't yet come to conflict, but does interfere with agreement. And so you have to find ways to do that. So I think you sell it to people as it will give them more control over the outcome, and as certainly more of a place to be heard that isn't as formal, as intimidating as a judge. When you go into a courtroom, what do you have present? Besides a judge and lawyers, all dressed up, et cetera, you have a sheriff's officer. You know, and we don't think about that. Those who work in the courts, they don't even think about that. But if you're a civilian walking off the street, that's an intimidating environment. When you have a mediation, unless there's some special concerns, you don't have that. You're sitting in a room having a meeting. Maybe you're in a circle and everybody can talk in their turn. And you can set up the rules. Usually the mediator or whoever convenes the conference establishes the ground rules up front. So everybody knows one person talks at a time, you don't interrupt. We used to use the feather in circles, and when the feather was passed to you, it was your turn. There are, mechanisms like that, which are very easy and work. So I would like to see that used more, because I think it will reduce what I call the burden on everybody involved. And you only need to have one successful, and then you'll have two. When we did sentencing circles and they went fairly well, we got requests for more sentencing circles. So I see this as something that's certainly worth an effort. And there's lots of training available in mediation and mediation methods for lawyers. The Law Society has frequent programs for lawyers. And the group that I'm involved with also does free webinars and so on for lawyers in certain areas, certain topics. We haven't done one in child protection yet, but that might be for the future.
Thank you. And I think this will probably be my last question. You've talked a bit about how we can get buy-in from participants and lawyers. I'm wondering, do you see anything we can do to get buy-in from the courts or judges?
Yeah, I think I don't want to give away any conversations here, but I know for a fact that within the administrative arm of the provincial court, there's a great deal of support for many of the things that we're talking about. And I've made some people there aware of some of these, obviously not my report, but some of these general discussions about using mediation methods, referring to mediation, encouraging the parties to do that, and of course the case conference and judicial conference. And in other contexts, they have settlement conferences. So I would anticipate, I'd be very surprised if there wasn't a great deal of welcome for any initiatives that allow the courts to deal more efficiently with this troublesome and burdensome caseload. So I think that would be fine. In terms of how to encourage them, well, I think this is where having the correct facilities in your hearing spaces is so important. Because I know there are judges, I know all the provincial court judges, or almost all of them, and I don't think there's one of them that wouldn't volunteer to preside over judicial case conference, say out of Corner Brook, or maybe even come up for it to Labrador. But if their schedule didn't allow them to do that, they would be present, fully present on a video case conference, and they would give an hour, 2 hours, a half day, whatever it turned out to be, to that effort. And I know the court would support that. It's just everybody has to be on the same page that it's a possibility. And once you set it up as maybe as part of your protocol, you set up that the court will cooperate to make judges who are willing to do this work available in whatever way is possible, the best way possible, using the best technology possible. And so if you set that down as a principle, and then the other thing I would say, and this is not a criticism at all, because I've been there in every respect, lawyers have to be willing to ask. You'd be surprised what you get if you ask. And sometimes judges are up there thinking about X, Y, and Z, and they're forgetting about ABC. But they get reminded, well, have we thought about it doing this way? You know, have you done a judicial case conference? Could we schedule one, say, within the next month? Well, if the judge you're talking to is too busy, is there a mechanism to request a judge from elsewhere? So, I mean, I think once we establish this as an available resource, then I rely on the lawyers because they're very experienced and they don't want to do this the long way if they can do it a better short way. I would expect them to start asking for these things. And now the outside mediation, if you had private mediators who were involved in these matters, well, obviously there has to be some kind of arrangement for them to be retained and compensated. But the way that they work, just for if you haven't dealt with them, the way that they work is they say, I'm available for a half day. And then everybody knows they got a half day. If you need to continue it after that, everybody wants to, then they'll continue. But they're not open-ended. And, you know, they give you allocation of time because they're all very busy, mostly lawyers, and they're very busy with what they do. So I think the complication there will be coming up with a retainer and compensation mechanism. But if you're dealing with judicial resources, you don't have to worry about that. You just have to worry about getting them there. And their only problem is time. I think right now that each of the provincial courts judges in Labrador is traveling up to 80 days a year. And that's a lot, you know. So making it easier for them to be there in some way and still be fair to everybody, nothing wrong with it.
Thank you. I think if I could just check with Mr.
Yep.
Brookwell. Okay, it looks like we are all good from our perspective. Thank you again for your time and your answers.
Oh, no, thank you. Those were great questions.
I'm ready to go. So Michael, am I up next? I don't know if the feds had anything to ask or.
I think it's a matter of form. The Fed should go first, so you have the opportunity to respond to whatever they have. Federal, Catherine?
I'm sorry, can you repeat the question?
Any questions?
No, we have no questions at this time. Thank you.
All right. Thank you very much, Judge English. Your report was very, I thought, comprehensive. As someone who practiced with legal aid for a number of years in Labrador, certainly a lot of things resonated with me.
Right, they would.
Yes, they certainly did. And you've covered a few things I was going to ask you about in your answers to Ms. Wicks. So hopefully I'll try to narrow this down as much as possible.
Okay.
And my first, I'm also going to go through the recommendations in order. And just with regards to that first recommendation about expanding coverage with legal aid, and you indicated, I think, your preference or if the four options you suggested, the most elegant seems to be that legal aid just accepts members of the Innu community, but with, you know, a blanket sort of acceptance. So my understanding, the issue with that as of now is the Legal Aid Act itself, which does not allow a mechanism for legal aid to waive the financial requirements. In your discussions with legal aid management, did they discuss whether or not any efforts are being undertaken to change the legislation?
No, I'm not aware of any efforts at the present time. They certainly didn't mention them to me. We did talk about the idea of the gaps in coverage, particularly when I was talking with a couple of the administrators, the executive director and another administrator. And I was more concerned about individuals who were who fell between the cracks, and particularly this question of the person with limited income in Labrador. I mean, they were well aware of the practical problem of trying to retain a private lawyer to come to Labrador for a child protection matter, and the enormous expense that would be involved. But they were mandated to consider only income versus expenses, and the family status or family demands of dependents. And often a person who has had their children moved, their situation's changed. They may have a full income or some subsidy coming to them, and then all of a sudden the children are gone, either the subsidy is reduced or totally eliminated. But if they're in the ambiguous position of having some income, then that's what presents it's a judgment call for legal aid. And I know that because I went through that system myself, many of the appeals from denial of legal aid eligibility, center around this whole question of do you have assets sufficient to retain counsel, or reasonably sufficient to obtain counsel. But I have to say, in my experience, I in child protection cases, I almost saw nobody who was in a position to do that, because I often asked them if they'd spoken to lawyers, and they said yes. I said, were you able to make any arrangements? And they tell me some figure that had been quoted to them. And of course, it wasn't something that they could afford. So the reason why, it's obvious to you, I'm sure, the reason why I thought the first alternative of legal aid covering it was the analogy to the criminal cases, where even where the person doesn't qualify, if the court appoints, then legal aid steps in. And not all cases, but 99% of them anyway. Legal aid is then, mandated to provide counsel. So it's kind of like it's a default arrangement. I realize on the civil side, you've got other concerns, and you've got the act itself. I really think that I'm not sure why the payment agreement arrangement was eliminated. I think there was an administrative burden on legal aid to either put those in place or collect the money and all that. Because, then the way things are, then if you're owed money, you're supposed to collect it if you're government. And often that was very, very difficult to do. But I really think in the Indigenous context in Labrador, where people often have money for a short period of time, like this 6 months, they have a decent job, they're making decent money, and then all of a sudden they're down to whatever the employment insurance gives them. But meanwhile, coming after that is nothing. That's not totally different than the Newfoundland context, because lots of people deal with that in all of Newfoundland. But I think because of the remoteness and the very, very hard, the difficult task of trying to recruit or retain a lawyer to stick with the child protection matter, because they go on for a while, and there's no money at the pot. There's no money in the pot at the end of the day as a result of it. So lawyers are business people, most of them, the private lawyers, and so I didn't think it was realistic to expect private lawyers to step into the breach. So yes, it might require either the resurrection of the payment agreement arrangement for, and I would think this could apply. The merits of it are there for all people who live in Labrador and have a serious legal issue because of the remoteness and the cost and the travel and all this kind of thing. I think it could apply to any resident of Labrador. And if that were carved out so that legal aid perhaps could consider an arrangement, a payment arrangement. Now, the other thing that was mentioned to me, and I didn't talk about this earlier, is that there had been cases where somebody in a child protection proceeding had no counsel, and somebody stepped in from the community, I don't know if it was a community agency or a community person or whatever, and simply it could have been a relative, but simply financed the representation. Maybe they had connections, they knew a lawyer was willing to do, there are many things like that. So there were occasionally private lawyers that came up, but I would consider that to be very exceptional. So, but my main reason for the first alternative being the preferable one is the expertise of the lawyers who are already there. They're already there. And I mean, nobody will ever know what they know. I mean, I have been out of there now 12 years, and what I don't know about their daily work, I tried to learn as much as I could, but it has changed. The thing is constantly changing. What's going on in the community is changing. Being there and knowing all this is an indispensable resource in a lawyer. So thinking about how much benefit you would get out of having counsel, whether it was through legal aid extending or through a state-funded counsel model, something that allowed that to happen, as discussed in the New Brunswick case. Having those same people on the ground, they wouldn't have to work half as hard because they already know. They know who all the people are. They know who all the social workers. They have the wonderful assistance of the community liaison. They have their own social worker who also knows the social workers. So when you bring the legal aid lawyers into it, you bring all this expertise and this resources, which is unique to Labrador. I mean, it's indispensable, but it's also unique. That was my main reason, because you could spend twice as much money and not get as much out of a different model. The state-funded model, for instance, if you were financing private lawyers to come up, could be very, very expensive, or to deal with the cases. That, depending on how that's all worked out on the details, could be awkward. And of course, they're free agents, so they can say tomorrow no. Whereas the legal aid lawyers, they're employed, they have a regular gig, and they're committed. They wouldn't be there if they weren't. And so the chances are they would start it and finish it. And nothing more important than that. If you're a parent who has to strike up a relationship with a lawyer, you really don't want to be, it happens sometimes, but you really don't want to be changing lawyers any more than you have to. So those are the merits of it. But yes, if it required an amendment to the Act, I think it would be a fairly simple one. And I would recommend that it either be carved out just for child protection as a kind of a legislative pilot project, I suppose, and that the legal aid apparatus be given discretion to a mandate to fund, at least on some, like you could have a sunset law. You could say this is in place for 5 years, this will be reviewed in 5 years, much like happens with child protection legislation. That way, if it spins out of control in some way or people find it's not working, there's a way to review it. You wouldn't be stuck with it on a permanent basis. But I think it would work very well because I know how devoted and dedicated the lawyers up there are. And even if they move on and someone else comes in, it'll be because they want to do this work. So, yeah, but it is really important. It is very important. And I mean, just the practical side of it. One of the other parts of my duties in Labrador, as you know, was the other parts of family law, child support, and custody cases and so on. And in those contexts, we often had to have people prepare financial disclosure. And I can assure you, it was more than pulling teeth. And yet this seems to be the most obvious part of that area of the law, preparing a statement of your financial expenses and your financial income, and then providing verification, much like happens for legal aid. And yet it could take a year, even with lawyers involved. I cannot tell you how frustrating it is to not see a financial statement after 6 months when there's been a lawyer on the case. But this did happen. But when individuals are representing themselves, which in about 70% of our cases, family law cases, they were, I wasn't at all surprised. The person would just look at the form and say, I have no idea what this is all about. And they would say it over and over again. And so what I'm getting at is that the difficulty of individuals, particularly unrepresented, trying to negotiate an eligibility scenario should not be underestimated. Even though our act requires it, the Legal Aid Act does require it. It's been in place a long time, but I can remember many times sitting down with clients and helping them fill out the form once they brought in the documents, and that might take several weeks when I was a lawyer. And every lawyer who's dealt with it knows we have the highest level of illiteracy in the entire country. We've had it now since we entered Confederation, and nobody talks about it. I talk about it occasionally because I used to see it every day. You would give a person a note saying your next court appearance date is, and then when I was being very attentive, I would say to the person, now you have your note, yes. What does the note say? And they would just look at me. They had the note in front of them. I knew they couldn't read it, right? So, you add that to other circumstances that affect Indigenous people in Labrador, and you create delay and you create frustration. And nobody gets more frustrated than the lawyers when they're trying to move it forward and the client's not able to help them much. And then, of course, the demands of the system are on top of that. So, yeah, I have a lot of sympathy for everybody involved, trying to do what they're supposed to do. But I would like to see a change that would allow people with a small amount of money to qualify on some basis, whether that's blanket or case by case. I think they put it this way: the legal aid office in Happy Valley Goose Bay, at least the one that I observed, is very well equipped now to do that. I mean, they have a very professional staff up there. They're well set up. They have supports. And whereas maybe 20 years ago, whenever that arrangement went away, they might have found this quite onerous to go through this kind of setting up a financial payment arrangement or something like that. That might have been very difficult for them. I think they're more than capable now of doing that. They have long-term employees. They've been dealing with these things for a good while. So yeah, it is a problem, but not an insurmountable one, for sure.
And so currently the only, I guess, class of people who can currently get legal aid representation without having to provide financial disclosure would be youths who, if their parents, or if they sign an affidavit, or if the parents sign an affidavit saying they're not prepared to provide their financial disclosure, they will automatically be approved for legal aid, which is, I can't remember how many years that has been in place, but the last maybe 10 to 15 years. So something of that nature, do you think that would be beneficial? Some sort of affidavit evidence from an applicant saying that I'm a member of the Innu community and Natwashish or Shesh. Is that something you would recommend?
Yes, I think something like that. And even if you required them to have somebody from the community vouch for them, sort of not a guarantor, but you know what I mean? Someone who would say, I support this application. I think that would be, because you need something to document the circumstances. And I had forgotten about that. You're quite right. The youth situation got resolved that way, because that was the impediment. I know back in the 70s and 80s, that was a tremendous impediment until that solution came about.
Moving on, because I'm sure the two of us could talk about legal aid in Labrador all day.
Right.
The recommendation about timelines, and you've discussed a bit the most recent appellate decision, or the LB decision. My experience has been that family division, the Supreme Court has interpreted that very strictly. They've been taking the position that these timelines now have to be adhered with very strictly. Is that the case in your observation in provincial courts, especially in Goose Bay, or are they still taking a more fluid approach?
I can't. They're well aware of it. I have discussed it. They're well aware of the LB decision and the imperative. The problem they have is the criminal caseload. And I mean, it's part of their job. So it's a problem because it's every day. And then on top of that, and I've had occasion to write on this, so I won't say much more, but on top of that, there's the tremendous in custody challenge and the bail hearing challenge, which occurs in Happy Valley Goose Bay because it often involves people from all over Labrador, of course, and the court in Goose Bay ends up dealing with it. And that can be anything from one person on a Monday morning to 22. And I have experienced the 22, rarely experienced the one. But it's a tremendous burden because you have a mandate there. Under the criminal code, you have 72 hours to do something unless you get consent, and it gets problematic, because not all situations lend themselves to consent. But yes, the judges are aware of it, but it's that competition for time that I was talking about, and the competing mandates that exist in the criminal cases. And you've got the added element in the criminal cases, which, even though it's in the back of the mind of every judge, and that is that if you're dealing with violence, particularly in criminal matters, you always have a victim and witnesses, sometimes the same people. And so you've got, the clock is ticking for everybody, and it is causing problems in that respect. So the judges are well aware of it. There is an ability, I mentioned it a couple of times in the other contexts, there is an ability to have judges from outside Labrador, when needed, to preside over child protection matters. I mean, Judge Trahy basically, when she took on that responsibility, it wasn't at that time directly her responsibility, but she agreed as the judge in Wabush that she would, and she has done that now for quite a number of years, and it's a lot of work, and it does involve some travel for her, but I would think with the support of the court that you could have other judges who would be available. For instance, you could set a day, just one full day, not to be interrupted, for child protection matters in Happy Valley Goose Bay Court, or if it affects Sheshie and there was court on circuit in Sheshie or in Natchitoches, well, it would be that docket. And then you could have a judge from outside who is there basically to move these matters along in the way that the judge in Goose Bay would, or the judge in Wabush. That would allow them to do all the other things they have to do and bring in additional judicial resources. I mean, I think that is doable. Provincial court judges are busy, but not all judicial centers are equally busy. And the numbers, the numbers reflect that, and they all know it. So I think you could, with appropriate scheduling, bring in additional resources, and that would allow the judges then to, sort of double up their time, I guess the best way to have it. Allow a matter to be heard. What I didn't like, and what nobody likes, is the interruption, the constant competition and interruption. It should drive lawyers crazy, particularly in family matters, and in child protection matters. It should, and it probably did.
It does.
It does frequently. And really, we have to acknowledge, as they say, you can't cure the problem until you acknowledge the problem. Well, we have to acknowledge the problem. It is a genuine everyday problem. And the only solution I see, in the current provincial court world, is to bring in other judges. And since most of the appearances, as I said in my report, almost, I would say 80% of the court appearance dates in child protection matters are brief matters. Presentation hearings can be brief, they can be longer, they vary all over the place. But but most of them are what we would otherwise consider case management type appearances, where the judge wants to know things and the parties want to know things, and they need to start scheduling the next move, the next step. This is not complicated, but the problem is, as I said, when you've got other things that are jumping out at you from the cells and taking up your time, you had to make a choice, and that's a difficult choice. And the judges, sometimes they go one way, sometimes they go the other way. But the point is, it creates unpredictability for everybody. And I think particularly the parents. Yes, I do think about the parents. They often don't understand what's going on, so they're spared some of the frustration. But the lawyers understand it all, and they're honestly trying to move the thing ahead. But the thing that would move it ahead is not available. So I think the provincial court would be amenable to that, if it could all be done with effectively working technology, particularly video conferencing. You need to be able to see people. I'm a believer in that. And if that were set up properly, there are judges who would say, I'll do this day, I'll do that day. And before you know it, you've got 6 months of case management type matters set. Now, if there's something on that docket that one of the resident judges should deal with for whatever reason or wants to, well, that can be set aside. That can be put into the Happy Valley Goose Bay docket, but not all 20 matters. In other words, we need to dodge the bullet. I tried to dodge the bullet the whole time I was there, but it's difficult, and there are competing pressures, and they're very real. So, but I think it can be done with all the goodwill that's there, and there's a lot of goodwill. But you need the facilities, and of course, I go back to the points we were discussing earlier about having as many of these matters take place in a way that everybody can be seen and heard without breakdown. Once that's taken care of, then I think everybody will step, because then you've got an efficient system. If you've got an efficient system, nobody minds stepping into it. When you have an inefficient system in the ways that the current system sometimes is, then it's a strain on everybody to step into it. And understandably, because they're not making it up. It really is happening that nothing is happening. And so I have a lot of sympathy for the current situation. But the timelines thing in general, I found that actually one of the most difficult parts of the mandate to look at. The LB case makes it look simple, but it isn't simple. And these, so I suggested, for instance, that a timeline for an outside date for completion could be enacted. And I'm thinking of the quasi, the similar timelines in criminal matters, where you have 12 months for this and 18 months for that, or 30 months for that, and I guess 18 and 30, and you could have something similar. But as I was discussing earlier in response to one of the questions, I suppose then you get to what are the consequences if they're not met? Now, I don't think there are a whole lot of cases that wouldn't meet, say, a 12 or 18 month time limit. 12 months, to my mind, seems reasonable if you're dealing with a young child. And you could even do it according to the age of the child to some extent. Because with infants, obviously, there are all kinds of implications, and toddlers. And then once you get to 10 years old, children are probably in school. In some ways, their life is largely controlled by that. A large part of their life, and they're moving ahead in that respect. So you don't need to be as concerned about the disruption to their life. So I could see constructing it like that with an outside time limit, but then you would have to give the judge, along the lines of our earlier discussion, power to apply some consequences. But I would sternly say it should be without prejudice, because I know how quickly things can change in these cases. And what looks really good for 6 months can totally go off the rails in 3 months in a family situation. And if the children are put in danger, well, obviously somebody's going to have to intervene and start a process of investigation, which is in effect, I've always thought child protection cases were investigations, inquisitions in a sense, but we don't like that word. So we'll say investigations, where the court is also investigating to see how deep a problem it is. At the same time, the social workers and the lawyers are also doing that. And while that process is going on, the children had to be safe. So I can see giving a court a dismissal power if for some reason, and I'm thinking of this kind of case, and this did happen a few times. So there's a key witness to some incident in a child protection case that's quite concerning. And that key witness has made a referral. The referral has been investigated, and there seems to be some substance to it. But then as the matter goes along, the key witness is no longer available or cooperative. And this can happen. And all of a sudden, reasonably, the lawyers representing the manager are quite concerned about bringing the case forward for a full hearing, because they're not sure that they can finish what they thought they were going to be able to finish. And so the matter sometimes drags on because they're hoping that person will settle on a point of view, and time is ticking. So I can see in that kind of a case where a judge should have the power to say, look, we've waited long enough. These children have waited long enough. I now need to make an order which terminates this proceeding. And if the parents are in a position and want to make an application to control the care of the child, if not to be fully responsible of it, then the judge should have the power to do it, applying the best interests of the child. So I think that would be, and I know there is, or there has been a review of the act going on, and I don't see any reason to not include something like that. I think doing what we're doing with the shorter timelines, I can see the 1 week and 30 days and so on. These seem reasonable. But once you put in an outside time limit, say a year, then everybody will know the clock is ticking. And even judges need to be prepared. If it's 11 and a half months and you've got your hearing date coming up, you're going over that file thoroughly to see what the heck has been happening, and to be prepared to deal with any application that you get. So I think I would rather have the outside time limit. Mm-hmm. And because now you've got the LB case, which says you got to move expeditiously anyway, right? And one of the great encouragements up there, and I heard this repeatedly, is that the lawyers are all talking to one another. I can tell you in other areas of family law, that is not happening. Not universally and not generally. But in child protection, and particularly in Labrador, the lawyers are communicating with one another. They're talking about what they have to. They're negotiating, and they all know one another very well, and that helps a lot. They do their job, but I think if you didn't have that kind of communication, then you would expect delays. But where you do have it, then all you have to do is give somebody a clear rule, much like we have in the criminal cases. You have a clear rule, clear timeline. The problematic part of that is when the parties represent to the court that they need treatment. And of course, the problem with treatment is that it's frequently not available, no matter how devoutly it's sought. And that becomes then an open-ended source of delay. And, I think the timeline should be the timeline. If you determine if it's going to be 18 months, that's one thing. If it's going to be 12 months, that's another thing. Whatever it is, it ought to be the timeline regardless of circumstances. And there will be people for whom that doesn't work, but we're talking about children who don't control that. And so, the court has to pursue what's in the best interest of children, which is usually getting the matter resolved one way or the other. So I can see there still will be dilemmas. There always will be dilemmas in these things. And the lawyers have, difficult dilemmas to make too, because sometimes they want to speed it up, and sometimes they want to slow it down. Yeah.
Well, what we often see happen is, I'm sure you're aware, in the criminal context, is people will waive their Jordan deadlines for various reasons. They want to get reports, they want to do programming themselves. I mean, would you foresee something similar being built into the system of child protection, where you have these hard lines, but if the parents are saying, I need an extra couple months to get housing, I need, a hearing right now would be bad for me, but in 2 months, would you foresee that flexibility there?
I wouldn't want to see that for younger children. I think if you're dealing with younger children, you need to have a hard and fast deadline, because I know, and we all know, how much is lost, particularly in the Indigenous communities, by having a child. And I mean, I was there long enough to see the grandchildren of my clients from the 70s in child protection, and of course know way too much, I suppose, about some of the things they had to deal with when they were very young, and then not wanting. My own preference was not to see them subjected to any more trauma-related delay, cut off from family, cut off from community, and so on. Now, again, those were the bad old days when children were shipped out in large numbers to places far away. I know some of that happens now, but then that was the rule rather than the exception. And so the consequences of delay were really enormous. And we often heard about it from the parents when they met with the kids a year after they'd gone and they could not speak their language. There was no hope that they would have to learn the language back again, because they had gone from being 2 to 3 and they just lost it. So, those are very stiff prices to pay. So if something had to pay a price, I would think it would have to be the adults. And but if you had older children, I can see where the court could have a discretion. That needs a lot of careful thought, and I'm sure a lot of thoughts going into it. I would be very interested in how the Innu communities would feel about that, and I can't speak for them. So, but I think that their feelings on whether they want these matters dealt with sooner, or they want to have the Innu are very forgiving people. I know that from my experience, and they forgive all kinds of unfortunate circumstances because they've survived them. But would they, for the sake of younger children, want these matters dealt with sooner or later? That would be a very important thing to know, and the inquiry can know that, I'm sure. Probably already know something.
I'm going to move on and ask just very briefly about the issue of interpretation, which I don't think anyone takes issue with the fact that interpretation needs to improve. You had recommended in your report, I guess, an independent agency, perhaps spearheaded by the IRT or by Innu stakeholders. Has the court ever employed interpreters directly?
Yes. There was a period of years, I think it was, and I can't be sure, but I think it was a period of maybe 4 or 5 years in Happy Valley Goose Bay, where we had on staff an Innu interpreter. And this is a person who lived in Sheshi and came up each day, like all the clerks, and basically had the status of a court clerk, but was primarily expected to do interpretation work. Now, if that was slow, then that person did other things. But they were employed by the civil service mechanism, and it was wonderful. I can only describe it as wonderful. We happened to have a very good person, very bright, very intelligent, had the wonderful gift of detachment, because that was not easy. But personality, in terms of personality, could deal with these difficult things, and both the criminal cases and the family cases, and then go home and lead her life, and stand up to it. Now, after about 3 or 4 years, she was on to something else. But we had another person or persons for a while who also were good and also were from Sheshchi and came up every day. And there were certain days they couldn't for some reason or other, but we managed to come by. So yes, that model has been used, and it was very good. We were extremely pleased when it came about. The judges I can speak for, because if we, for instance, sometimes we'd have on the criminal side, we'd have an Innu person appearing, and they would say they understood everything, but you could tell they didn't. And so we, even though the word had been sent that this person didn't need an interpreter, we had the interpreter there. Within 30 seconds, they were in the courtroom. We'd explain it again. They would try, and then they would verify, to us. So it was a great asset. And they generally didn't. They did do some work in family cases, but some family hearings that were longer. But primarily they were used on the criminal side.
Would that be something that you would recommend again if, not necessarily to rule out any sort of independent agency or IRT involvement, but if the court could make funding available and have a person perhaps trained through an IRT initiative working directly with the court, you think that would be?
You just said the magic word, training.
Yeah.
Because if there's somebody new, if they're not one of the current interpreters, and if there's only one of them, it is onerous. But if you were able to have two, the great thing is that, they, between the two of them, they could make up one full-time position, or they could both come, because there are two courts in Goose Bay that regularly can operate simultaneously. And often they will need interpretation in both. And of course, there's the online matters too. So the training is really, really important. And when I've spoken to that otherwise, but it prepares them for what they're about to do. Because even though they had the goodwill and they have the language and they have the smarts, I'll call it that, they need a certain degree of, a good degree of training in what an interpreter does and what an interpreter doesn't do. And, what kind of cues you're going to get and what kind of cues you have to follow and what kind of cues you're going to ignore. Because sometimes we used to see the accused would get into a conversation with the interpreter in the middle of the case. And some of the interpreters would think, oh, well, I'm not going to be impolite. I'm going to have a conversation. So, that part of the training is just boundaries, really, rules and boundaries and expectations. So as long as they got that, they would be equipped. And, I still think that the need is greater because of the enormous criminal caseload. And of course the circuit responsibility. So if you go and you're doing circuits, if you're going on circuits, you're going to need an interpreter with you there too, and they can't be two places at once. So I would say a core group starting of 3 who've received the training, and then because you can always count on one person for some, sincere reason having to opt out. If you give yourself that core group, then you're fine. This is what happened in 2007 with the training program. This was to create a core group on both Inuit and Innu sides, and it did. It really did. And they were high as kites at the end of that program because they felt, well, they were certified. They all got certification, and it was they got recognition, and they got training, and they got tools. I mean, those people were off to the races. And for about a year or two, we got solid dividends out of that program. So I would expect the same thing to happen if you started the new one.
On the issue of social worker recruitment, which has also, of course, been I guess we'd say a major theme of the inquiry writ large.
Yeah.
There are, I don't know if you have done any research or spoken to anyone about programs offered at other schools, such as the First Nations University in Saskatchewan. They have a social work program. Is that anything that, the setting up of scholarships, bursaries, et cetera, through the IRT to send students to these programs? Is that something that you've discussed with IRT members or anyone else?
No, I haven't. I haven't discussed that with them, but I think incentives are required for retention and maintenance, and because it is difficult work. I mean, the social work that you're doing in a child protection context is a creature unto itself. And usually when they're new, when they're newly trained, you know, they're able to start, but they need a lot of support and a lot of encouragement and perhaps incentive to stick with it. Because once they're trained, I'm here to tell you, because you all know it happens, they become very attractive to be lured away to anything else. I mean, this is the old the phenomenon among Indigenous people. When you have highly qualified people, they're in demand, and so to keep them in the work once you've invested in the training, you know, you have to have incentives, and either financial, and I think you know, in Innu communities, one of the incentives will be family time. You know, some system for giving them family time, the usual annual leave or whatever, however you do that. And that's why you need more than one, because they will be pinch hitting for one another, and they'll be happy to do it because they know when their turn comes, they carry huge family responsibility. In Natwashish, the family responsibilities of the average female in Natwashish exhausted me when I heard about them. I mean, it's not unique to them, but it is there. You know, grandparents are caring for grandchildren, and children are caring for parents and grandchildren, and they're all in the same house, and the burden falls fully on them. So anybody you get, you know, will probably be of that age or that situation, and so you need at least two in each community. So that would be a core group of 4. And then with the use of technology, notwithstanding the dialect difference, with the use of technology and after training, they would be able to pinch hit a little bit in both communities too, through the technology. Just what I described, you know, with the Supreme Court matter I sat in on. I mean, there was somebody who was somewhere else and was being present by technology to interpret in a murder trial. So, I mean, you know, but at least that alternative was there. And with a core group of 4 properly trained, yeah, I think that would be a good start. The separate agency only has this advantage. Separate agencies tend to get multi-year mandates. and you know, I mean, because there's a lot of work to set them up and we get the right people to run it and all this kind of thing. And one of the reasons I mentioned IRTS as possibly an agency is that, first of all, they impressed me as having accomplished a lot and being very much plugged into this issue. But the second thing is they're there and they know everybody, and you wouldn't have to invent the wheel of organization. They have a wheel of organization. They're doing the job now. They would have to create a subset, you know, a department of interpretation or whatever they would choose to call it, and then you know, under their umbrella, set up the agency. That was the main reason why I did it, because of their presence in the community and their it seems to be largely expanding involvement. You know, they need they need the support of the band council and the Grand Chief and Chief. They need all that too, but they have established a presence which, if it isn't permanent, is as close as it comes for management agencies. You know, they seem to be there unless there's a transition to something different. They seem to be there with their mandate for a fairly long haul. But yes, other than that, we could go back to the attached to the court model. And as long as those people were willing to travel when the court did go to the community, or if they already live in the community, that's even better alternative. Because that's what we did with interpretation. When we go to Natwashish, we had to rely on people who lived in Natwashish. And we hoped we always arranged it. The clerks arranged it well in advance. But then when you get there, there'd been a medical emergency, and your interpreter was gone somewhere because they had to, and so you fall back on the next hopefully available person. Usually we could find someone, but it was a bit ad hoc. So having these people there on salary and getting the training they need, whether it's in person or remotely, that's what we didn't have. We had people, but then that was after the training was done. And then when the training was done, we had people for a while. And then after a while, we had no training and no people. At least not, they're all volunteers, right? And they were basically ad hoc contractors. And when that worked, it worked great because they were good people. But when it didn't work, everybody was stymied. And the one thing I heard about the child protection matters, about the only thing now that will stop a hearing up there is no interpreter. They will do their best, to get the hearing going and keep it going and complete the thing. But if there's no interpreter, it's usually a dead stop. And it's hard to imagine otherwise. So I see this as a huge problem in the child protection context with Innu, because I expect the Innu to use their own language. I've seen that that's their strength, one of their strengths, and I wouldn't want to see it diminished in any way.
Judge English, I don't think I have any other questions. I'm just going to quickly look here. But a lot of what I was going to ask you, you've already covered. So,
okay.
Yeah. No, I don't believe I have any more questions. So thank you very much.
All right, thank you. I just had one thing I wanted to add. There was a point I noted this morning. We haven't talked much about the ongoing huge efforts to prevent matters going to child protection proceedings. But I'm no expert in that. But I did certainly talk to people about it, and I was encouraged by it. And it's still the measure of choice to deal with these safety issues for children. Prevention will always beat cure. The only caveat I would say is that however you go about the prevention or the litigation, if it gets there, is that we're always going to have to ask the question, is this fair? Whatever the outcome is, has this been a fair process for the families involved, particularly the parents? Because we all know, we've been around long enough to know that every bureaucratic measure that was ever created can be fair, probably designed to be fair, but over time, and if you've read the Hughes inquiry and you've read the Turner inquiry, I mean, and I lived through all those things, and so I know, there can be a measure of unfairness, even arbitrariness, that creeps into any, I'll call it bureaucratic, and I don't mean that negatively, but any bureaucratic answer to a problem. And the same thing is true with prevention, because you never want to have things going on in your prevention scheme. And I'm talking about a minority of cases, of course, but which is unfair. And so any system that is developing, and I'm sure there is one, and I'm sure it'll be good, in the Innu communities, always has to keep that in mind, that if you're making decisions about people or you're leading them to decisions, you have to do it in a way that's fair to everybody. I mean, this is not law. But if you look at the international conventions on the rights of indigenous people, and you look at our own charter, it's all about that. So that's the only other point I would make. It's quasi-legal. It isn't legal, but it's really, really important, because there are shortcuts, but they're not necessarily fair shortcuts. And that's my last point on that.
Oh, I don't have anything else to add there, Michael.
Right. Does anyone else have any follow-ups flowing from that? I do not. Okay, well, thank you, everyone. Thank you very much, Judge English, for your report.
Thank you.
We will see each other again soon.
Right. Hello again, everybody. Thank you for your attention there that time. I know that initially I had indicated that after this video, we would take our lunch break. But in discussions with the commissioners, they just have a few short questions for Mr. English. So we'll give him just a moment and then have the commissioners do their questions. Then that way, when we return after lunch, it'll just be Dr. Fallon and Dr. Black for us to watch. And that way we can hopefully get out of here a little sooner than we did yesterday. So I'll turn it over to commissioners now to just have some appreciation and some questions for retired Judge English. Yeah.
Okay, thank you, Bill. Probably more comments than questions. And the first one goes to Nastash, Commissioner Cupie.
Hello. I'd just like to say that I want to thank you for the work that you did on the research and your dedication. It's also going to visit the communities as well, and I appreciate that. So, and again, that this will help us with our work in the inquiry. So I want to say thank you to Mr. Commitment.
Oh.
Yes, thank you very much. I hope you can see me and hear me.
There it is. Oh, there we go.
Oh, okay.
Yes, thank you. And it's been a fascinating process for me as well.
Thank you. And we'll move on now to Professor Devine for a question or comment.
Okay. Hi, how are you today, Bill?
I'm very good. Thank you.
Good to see you again.
Yes, you too.
The first thing I had a few questions, but you covered them one way or another, either through answering other questions or in your presentation or in writing. So I just have one point of clarification, if you will, and because I'm very interested in, I guess, alternate dispute resolution kind of models. And you talked in particular about mediation services. You also mentioned case conferencing, that you had some familiarity with that, if I remember correctly.
Yes, that's true. When I was a lawyer doing child protection cases, I was involved in a number of them, particularly in the 90s, between 95 and 2000, before I went to the bench. They were routinely done in the St. John's area. And I encouraged my clients to go, and they almost always agreed. So that was the case conference without a judge. I found them to be very good. Usually we were able to resolve some minor issues. Occasionally we resolved entire cases, but usually we were trying to resolve things like, for instance, certain conditions that had been placed on parents while a matter was proceeding through the courts or whatever the process was, often involved relationships they had and certain limitations on them or access to the children, and that could be very difficult for people. So we would have a case conference to talk about really the pros and cons of that, and whether there was a compromise or a resolution And we were able to resolve that sometimes. So I had good experiences with it, and I highly recommend it. And I know that the lawyers in Goose Bay are using that mechanism from time to time.
Okay, thank you for that. My specific question is, I'm trying to imagine how mediation would look different than case conferencing model. And in particular, when you're talking about basically the state and parents, that's how I'm thinking, like a social worker and parents. How would you see that working in practice?
Well, it works if you have a skilled, trained mediator. I mean, that's it's the core element in mediation. And the reason why that helps is because that person has experience and abilities to get people to focus on not on their dispute, but on their common interests. It's the common interests that will resolve a matter. And usually, of course, in child protection, that's the children. Sometimes, though, it's more than the children. Sometimes the relationship with third parties, grandparents, other siblings, other stepchildren. You know, you never know what can motivate a person to resolve something. Sometimes it's because they want to bring other people together with themselves and the children. So a skilled mediator knows about that, and they know how to direct people towards that common interest. You know, you in a case conference, you have, and I hesitate to say adversarial because I know that strictly speaking, child protection is not adversarial, but you do have people who are coming from a different position. You have the social workers who have a concern or a series of concerns. You have the parents who may share some of those concerns, but they have other worries too, and they're sitting across the table, and you know there can be two solitudes involved in that conversation. What you don't have in a case conference is the neutral. And you have that in a settlement conference with a judge. You have that in a judicial case conference. You do have the presence of the neutrals, what I think I called and what's known as, with the judge, the power of the sash. In other words, kind of the influence. It's the influence of someone who's not only known to be neutral, but also be independent. And that can have a tremendous influence. But a mediator, trained, skilled, experienced mediator, knows how to talk to people either in the same room together or individually. So that's what I'm thinking about. If you don't have a certified, trained mediator with experience in these things, certainly in family law dynamics and social sciences and so on, then it'd be very difficult to make the mediation process work. As you know, we do have family services, which provides mediation in certain family law contexts in the province, and it's free and it's a good service, very good service. But it doesn't reach into child protection. It doesn't reach into some other things as well. And that's simply, I think, because you'd have to give a degree of training and experience to those people that they cannot or do not currently have, and would need a significant investment to get. So I'm thinking of a model where, and I think of this again for a minority of the sticky cases. I call them that for want of a better word. I'm talking about the cases where the lawyers who know their clients, know the case, say, you know something, if we brought in a trained mediator of this kind and we set aside a half day, we might make some progress in this that we haven't been able to make so far. So I see it as being selective. But if you solve one of those cases, sometimes they can involve 2-3 children, and you've made progress. Whatever the resolution is, you've made progress by doing that. So that's the model I'm thinking about. That would have to be adopted. I think right now it's possible for a judge to not to order it, but to approve it. In other words, to encourage the people to do it, and the parents and the other parties, but they would have to say they're willing. They would have to see this as a positive step. And it usually is because it can be arranged fairly quickly. And as I said earlier, it can be quite flexible. how you do it. It can be done remotely if the mediator is willing to do that. You have to have a good private confidential space. But once you've got that, that model could work. And I just like everybody to be aware that that's an option, as long as there's some mechanism, because these are private mediators, so they have a private practice. Some of them are lawyers. You'd need to have a system set up for them.
Okay, that's helpful. So thank you for that. But it's the only question I had at this point. So the last thing I just wanted to say is thank you for your report, your research and presentation. And one of the things that really stood out for me in listening to you was your great empathy that you have for the Innu and how much you care from, I guess, your experience down there and getting to know them and that. So I just wanted to also add that. Thank you very much, sir.
Thank you. Appreciate it.
Okay, thank you, Judge. From the commission, my observation will be the final one. You were asked to deal with Section 4, subsection 1, paragraph O and P, and you've done so admirably. You've covered a lot of the issues. Of course, as an inquiry, we are obliged to look further at the opportunity now given by Canada to apply Bill C-92. And it begs the question, given that you've raised some issues and recommendations about the court system, how the Innu might fashion a system of Innu law and child protection, and recognize that the recommendations that you've made are points that we will apply in determining, and as Innu have already worked at so much now, in determining where they go from here. So thank you for your input. We will definitely use your recommendations and your learned observations.
Thank you to the commissioners and the staff for being so helpful.
Thank you. That's an hour for sure.
Thank you very much. Thank you everybody for your attention this morning. Thank you very much, Mr. English, for your contributions. You are now free to go, so you're done with your questioning. You're more than welcome to come back for the afternoon session if you'd like, but you won't be required to be called on anymore. As for the rest of us, we'll take an hour break now, so we'll come back at 1:15 to resume with the afternoon session, which will be Dr. Fallon and Dr. Black's videos. Thank you very much.
Thank you.
So 1:15.
Yeah, I got my lunch, everything here. I'm good. Thank you. Also,
All right, welcome back, everybody. I hope you had a nice lunch break. We'll resume now with the afternoon session. So this afternoon, we will be watching 4 videos of Dr. Fallon and Dr. Black's testimony. They're broken down into 4, but we're going to watch them in 2 chunks. So the first is an hour and 4 minutes, and the second video is 25. We're going to watch those 2 together before we have a short break. After which we'll watch the last 2 portions, which are an hour and 15 and 43 minutes. So we'll watch those together as well. So we'll go ahead now with the first portion, which again, it'll run for approximately an hour and a half here now before we have a break.
Good morning. All rise. This commission of inquiry is now open. And everyone can be seated. All right. Good morning. We're here today with 2 witnesses who have been called for to appear before the inquiry respecting the treatment experiences and outcomes of INU in the child protection system, Dr. Barbara Fallon and Dr. Tara Black. I'm going to take a moment to affirm each witness. I'll start with Dr. Barbara Fallon. Do you solemnly affirm that the evidence you shall give to this inquiry shall be the truth, the whole truth, and nothing but the truth?
I so affirm.
And could you please state your name for the record?
Barbara Ann Fallon.
Thank you. And Dr. Tara Black, do you solemnly affirm that the evidence you shall give to this inquiry shall be the truth, the whole truth, and nothing but the truth?
I so affirm.
Thank you. And please state your name for the record.
Tara Black.
Great. Thank you very much. I should perhaps introduce myself too. My name is Molly Churchill, and I'm a lawyer who is working with the Commission of Inquiry with their legal team. And I will be asking some questions today in giving Dr. Fallon and Dr. Black the opportunity to share the work that they've done for the inquiry, to share some of their findings with us today. I'm going to start by pulling up a CV that Dr. Fallon provided to us. It's proposed exhibit number P447, and I suppose I should share my screen here, so make sure we're all looking at the same thing. Okay, are you able to see what I'm sharing here? And okay, great. And Dr. Fallon, can you confirm this is the copy of the CD that you provided to the inquiry? You can see it's dated March 2026 and a total of 88 pages there.
Yes, that's correct.
Thank you. And so you're a tenured professor at the Factor Inwintosh Faculty of Social Work at the University of Toronto.
Correct.
And also the Associate Vice President of Research at the University of Toronto.
Correct.
And we can see on page 2 of your CV, maybe I had that. One moment. Oh, I'm on the wrong. Sorry.
That's fine. I think that's Tara's.
Yeah, that is. My apologies.
Not
There
to
we
worry.
go. that you're also the Canada Research Chair in Child Welfare Tier 2 from 2016 to 2021, and again 2021 to 2026.
I am, as of today, I am not. It's a 10-year
That's
appointment and it's April 1st. So as of today, I am not, but I have been the Canada Research Chair in Child Welfare for 10 years.
okay. Thank you. And we can see that your thesis for your postdoctoral work was about factors driving case decisions in child welfare services, and it was nominated for a prize in 2006.
Yes, for my doctoral dissertation. Yes, correct.
Great, thank you. And then you've clearly published extensively, and there was one publication in particular that I wanted to highlight because it has already been entered as an exhibit previously for this inquiry, and that is the report entitled "Denouncing the Continued Overrepresentation of First Nations Children in Canadian Child Welfare: Findings from the First Nations Canadian Incident Study of Reported Child Abuse and Neglect 2019.
Correct. I was
Okay.
I was the chief science principal author of that paper. What was a study led by the Assembly of First Nations and the Public Health Agency of Canada.
Thank you. And just for the commissioner's reference, that report was previously entered as Exhibit P-087. Rather than continuing further through your CV at all, I'd like to just give you the moment to introduce yourself to the commissioners, to the Innu public, explaining a bit of your background and areas of research expertise and the experience you bring to bear on the work you've prepared for the commission.
Thank you, Molly. And I think both Tara and I are very honored to be here today. And certainly if our contribution to doing better for children, particularly First Nations children in Canada, can be meaningful in any small way, that is, it's really such a privilege and an honor for us to be welcomed to this auspicious group and to make a contribution to the Innu children and families. For over 30 years, I have worked either through primary data collection efforts with the incident studies, both nationally and provincially, to report on the incidents of investigations for children and families identified to the child welfare systems in Canada. Those are the incident studies. There have been 4 national incident studies. The reference that you made earlier was the First Nations Canadian Incident Study, which was conducted in 2019 and 20 at the request of the Assembly of First Nations. The other kind of, in addition to primary data collection, I work very closely with Tara to pull administrative data, extract, transform, and load the data onto what we call our Ontario Child Abuse and Neglect Data System, so that agencies and partners can access their own data in response to their questions about children and families. So we have, I always say it's not enough expertise, but we certainly have substantial expertise in trying to understand how administrative data can answer some questions folks have about children and families identified to child welfare systems. In my child welfare lab, of which Tara is a really important member, we always say that we work in service to children. That is our first accountability to the children, to agencies we work with, and then if we can publish it in the academic literature, certainly we do, but only in partnerships with communities. So you can see that because I'm very senior, I've published a lot in the academic literature, and certainly work very closely with agencies and governments to collect these data. So, and I'm happy to answer any more questions if something is unclear in my CV, or I can clarify any other expertise that I would have.
Thank you. No, that's very helpful. And we appreciate you being here today. I'd like quickly to Dr. Black to bring up your CV, which I realize I did accidentally bring up earlier. So let's bring it up for real here. It's proposed exhibit P446. Let's share it on my screen here. And can you confirm that this is the copy of your CV that you provided recently to the inquiry, starting with your education? And you can see it's a 34-page document.
That's correct, yes.
Okay, great. You know, rather than walking through any of the specific qualifications or positions as I did with Dr. Fallon, maybe I'll just start with letting you introduce yourself, as it's a bit more natural, and it would be great to hear from you to introduce yourself to the commissioners and to the Innu public.
Sure. Thank you so much for having me today. My name is Tara Black. I'm an associate professor at the Factor Image Faculty of Social Work in a position called CLTA, which is a contractually limited term appointment, and I've been in that position since 2013. Have about 20 years experience working with administrative and large data sets to help our community agencies and partners answer questions about the services and programs available to children and families involved with child welfare. I specialize in intimate partner violence and have been involved with administrative data, directing OCANS, the Ontario Child Abuse and Neglect Data System, since 2012, so almost 15 years of working with administrative data in child welfare.
Thank you. And could you give us just a sort of describe the OCANS project to us in a way that us non-researchers could understand, ideally in a way that I could, you know, then explain to my 11-year-old niece?
Sure.
Over to you, Tara.
Now I wish I had a slide about it.
We can do it. We can do it.
We can do it. So Ontario Child Abuse and Neglect Data System, we work in partnership with agencies. We sign data sharing agreements with participating agencies, leaving data ownership with them. So we don't own the data. We don't publish with these data unless they want to. We answer questions or touch the data only when they want us to. So we work directly with vendors, meaning in this case, we work with Matrix. In other cases, we've worked with Coyote, Penlu, CPIN, AS400, probably 10 different IT vendors. And we extract those data, push them securely to our server. We typically work in something called SAS, which is a statistical software program, doing data integrity, data cleaning, and then answer questions about those data in partnership with our participating agencies. And yes, then we can push those data to a secure ocans.org, where that agency has a secure login and can access different tools available to them to query their own data in different ways.
And when you talk about an agency, can you, what do you mean when you're working with an agency? Is that basically a service provider?
A child welfare organization or government, yes.
Okay, so child welfare organization or government themselves.
Yes, or authority.
Great, great. Thank you for that clarification. And then the other item I wanted to highlight from your CV is, again, that publication that we discussed briefly with Dr. Fallon, that you're a co-author of the report denouncing the continued overrepresentation of First Nations children in Canadian child welfare, findings from the First Nations Canadian Incident Study of Reported Child Abuse and Neglect 2019. I believe that's on page 12 of your CV.
Correct.
Okay, thank you. All right. So I know that you have a presentation that you will be presenting to us. We have that marked as an proposed exhibit P449, and I'd like to briefly share that just to make sure that we're looking at the same thing, that our records are the same as what you are using. So this is the, can you see the slide deck up there?
Correct.
Okay, great. And again, dated March 2026. Before we jump into that, I'd just like to ask a few questions to set the context, and I'm going to hand it over to you to tell your, to share your findings, share your research and your findings. I was hoping that you would start by just explaining what your research mandate or objectives were.
So we took instructions from the commission and from the community about what would be helpful in an administrative data pool for the purposes of the commission. And we matched that with the experience and skill that we could bring to some of the questions the community had about their children and families. So you can see from our report, we've really carved out the limitations and the knowledge claim quite carefully in order to respect that the data represents some things, but really only a piece of the puzzle. What we did was to try and represent the service continuum. So typically in child welfare systems, there would be a call from a concerned community member or professional about a child, about a family. A child protection system would make the determination of whether or not it is appropriate for assessment. There's lots of different words used, but assessment or an investigation, which there's a conclusion about the veracity of the concern. So that would be whether or not the case is opened for investigation. At the end of the investigation period, which varies according to province and territories, and in child protection systems, that assessment period varies considerably. The investigating worker or social worker would make a determination about whether or not the child or family needed ongoing child protection services. There's another disposition kind of layered onto that, which is the decision to place a child in out-of-home care. It's a very rare event. Nationally, it's around 3% of all investigations. And certainly, as the report indicates, and as the document you referenced for the FNCIS indicates, that placement differential depends on indigeneity and race. So we would also look at whether or not the worker decided to place a child in out-of-home care at the end of the investigation, whether or not, if the data would be available, the worker used child welfare court. Some of the other systems requirements are how long does the case stay open? If the worker makes that determination, if the child is placed in care, how long does the child stay in care? Sometimes we're asked to assess how many moves the child would make in care. And if a file is closed at any point during investigation, after ongoing services, after placement, we're able to make a determination about whether or not that case is reopened at any point. And that's because we really construct the data longitudinally. So one of the rationales for OCANs is that sometimes it's very hard to respond to questions that communities have, that agencies have about trajectories in child welfare. It's really a dearth. in child welfare research, and the queries that folks can use at the front end of their information systems sometimes don't give them that ability to describe a trajectory of a child or a group of children. And so with our brilliant programmers, that's what we do, is to take those raw data, use different tables, and construct trajectories for children and families so that systems, governments can reflect on some of the intersections of that service continuum to potentially locate interventions to reduce disparity, to increase efficacy, whatever the intention is. So I'm hoping that I'm thinking of your 11-year-old niece, Molly, so I'm hoping that I did a good job at explaining it, but maybe she should come on and query too.
Yeah, exactly. I would just sort of, in that, when you use the word longitudinal, is that kind of what you mean? Is that trajectory or that pathway? So looking at a specific individual or family and following
Exactly.
their pathway through the system.
Exactly. And you can do that through first contact. It's called the like entry cohort, and follow them until there's a final disposition, or you can do that as an exit. You can follow them after the system has closed a file and to see whether or not the family has come back. And that would be an exit cohort. It really depends on your question. And typically in Canada, you're used to looking at data that are cross-sectional, so a point in time. So on March 31st, how many children are in care, which is certainly an important measure, but one that doesn't tell you about, duplication, how many times that children has been in care, how long that child has been in care. So constructing data longitudinally really gives you the ability to describe a child's journey or interaction or intersection with the child welfare system.
Okay, thank you. And in the research report that you've prepared for the inquiry, it analyzes data about a few different stages or decision-making points within the life of a child protection file. So along that pathway or a trajectory. And without getting into the findings themselves, could you just give an overview of walk us through the decision-making points or stages that are considered and discussed in your report?
Thank you. So the first thing we did is to look at the screening decision. So when a community member or professional calls with a worry or concern or a challenge for a child or a family, we did a sensitivity and specificity analysis. So looking at that screening decision, essentially trying to understand through a series of proxies the appropriateness of that screening decision. So there's lots of methodological considerations and limitations to the way that we've constructed those data, but systems really like it, agencies really like it, to give them some indication about the front door of their child welfare system. Then we went on to assess the rate of investigation relative to a non-Indigenous population and the Innu population, to look at how many at a population level children are receiving an investigation in several fiscal years. I think there's 6 or 7 fiscal years that we looked at. Whether or not that child was placed in care, how long that child stayed in care. We also looked at the recurrence of investigations. So when an investigation was closed, we then said, okay, what percentage of investigations come back within a specific time period? And again, these are not outcomes. These are dispositions that can give folks some insight into how well systems are serving children, and where the intersection of disparate, where those service continuum decision points really increase or decrease disparities. Tara, is there anything that I have missed?
No.
Okay. Um, I guess sort of a follow-up question to that is actually not what I'm going to do. I want to let you just get into your slide deck, but there is a piece in terms of terminology that I'm hoping we can clarify at the
Sure.
beginning before we jump in, that I think will hopefully make it easier to digest the information. And this is, you talked recently about at the screening point. So a referral comes in and then it is screened for the decision of whether an investigation is going to occur or whether there's not going to be an investigation. The referral doesn't warrant investigation. And you've used the terms sensitivity and specificity. And for those of us who aren't immersed in the world of statistics and child welfare, data analysis, these terms can be a bit confusing. I'm speaking for myself at least. So I was hoping upfront to get, again, that like layperson's explanation of these terms. And again, keeping in mind sort of an 11-year-old niece. So starting with the term sensitivity, can you describe that to me, to an 11-year-old niece?
So it's a way of interrogating whether or not the decision to investigate the concern was correct. And sensitivity is essentially the proportion of correct decisions. So the ability to detect cases that need an investigation. So that's sensitivity. Specificity is the opposite.
I'm just gonna,
Yep.
so I'm just gonna say back, make sure we're understanding. Sensitivity basically means at that screening point, a case that gets screened in for investigation, it's later determined that there were in fact child protection concerns.
Exactly.
Okay.
And but the sensitivity rate also includes how many times you get that wrong, right? So right, so it's not just a like true positive. So that if what you just described is a true positive. So sensitivity is the overall decision-making process. So how many times do you detect a concern that needed an investigation? And we've interpreted that through the verification decision where the concern was verified. Specificity is the other way around, where the case is screened out. So intake worker or invest worker hears from the community member, the professional, about the worry or the concern for the child and decides this case is not eligible for an investigation, or it's not appropriate for an investigation, or what I'm hearing isn't appropriate for an investigation. So it's specificity is the ability to detect those investigations that don't need one. And that rate is also measured by how many times you get that wrong. Right, so it's it's a true negative, right? So we're dealing with true positives. We did an investigation for the kids where the concerns. A true negative is we did not do an investigations for kids that didn't need them. And then because that decision, there's 4 different outcomes. The calculation for sensitivity and specificity is a ratio between those 4 different outcomes. And that's what we're measuring over time. It really reflects what I would say is the challenge for child protection workers and systems is this over-inclusion, under-inclusion tension, right? We would never want to miss a child that needed protection. And we would never want to investigate a concern where a child protection worker wasn't warranted. And so the sensitivity and specificity analyses is kind of a way of adding data onto that tension in child welfare, given the tools available to systems, how well do we do in making that determination, which are it's a very, very challenging decision.
Okay. So when you're talking there about over inclusion and under inclusion, it's sort of when you're considering so a referral comes in, the screening decisions being made, and if the goal is really, okay, we want to make sure we don't miss a single investigation where there are true child protection concerns, you'd be potentially over inclusive, so investigating a lot of referrals to make sure you're not missing one where there are true concerns. But the downside to that is you might end up casting the net so wide that you do investigations and have that interference that, very intrusive interference in families where actually there aren't child protection concerns. Is that in terms of when you talk about over inclusivity? Am I understanding that?
Yeah, that's a very fair way to describe it, right? And so
okay, and then
have that
sorry,
so that those tensions, yeah.
Okay. And then the under inclusivity would be the opposite of that. If your concern is, okay, we don't want this level of intrusion in families' lives where there aren't child protection concerns. So we want to make sure we want to not do that. And the risk is that you end up not also investigating cases where ultimately it's later determined through a further referral and investigation that there were child protection concerns for that family that was initially screened out.
Absolutely, yeah, that's a very fair way of describing it. Yeah, and a better
Thank you for walking me through that.
I just did, so that your 11-year-old niece is going to be proud of her answer.
Yeah. No, I appreciate you walking me through that. Okay, what I would like to do now is hand it over to you to present your slide deck.
Okay.
And this is P449 for us.
Tara, do you want to just take yourself off mute so we can do this together?
Absolutely.
We haven't practiced, but we're a pretty good team. So again, this is really what we tried to do, is just to produce a brief synopsis of the report as a kind of an additional way to describe the takeaways in addition to our executive summary. So, and to Molly's point, what were our instructions? That really was to work on behalf of the commission to try and better understand some of the disparities between Innu and non-Indigenous children in Newfoundland and Labrador, using administrative data as a contribution to the very important work that everyone here is so committed to. And so we try in any data table that we present, one of the instructions that we work on the national level and the provincial level with First Nations advisory committees. And, about 20 years ago, what really resonated with me was that the data should never be unpacked from the devastating impacts of colonialism, because really what we're seeing in these data and some of the differences is a manifestation of colonial practices of the residential school system, of the 60s scoop. And so, we take that instruction very carefully, and we've tried to frame the data table similarly. We then, in doing so, we highlighted the OCAP principles and we described our methodology, and then we painstakingly made every table note clear about what assumptions we used, because we want to make sure that the knowledge claims are are clear and transparent and correctly interpreted. We looked at investigation rates. So what are some of the differences in investigation rates using child population? So it really is investigation per 1,000 children. So we used census data to establish the rate of investigation. We looked at some of in those fiscal years, we looked at some of the investigation recurrence data. Again, it can be a useful system proxy for the efficacy of it. There's lots of caveats and things to discuss, but essentially sometimes it's a handy metric to again assess, okay, if we close an investigation and there's a very high rate of occurrence, then there may be some additional work to do to think about how we've met that family's challenge or issue. We looked at out-of-home placements. Certainly that's a key. It was the placement decision was certainly for one of the calls to action for the Truth and Reconciliation Commission and a key decision point for this commission. We looked at placement types in order to kind of understand if a child has to be removed from their families of origin, where is the child placed, and then time to discharge. So how long does that child stay in that placement? We've had a robust discussion around screening accuracy and that kind of tension between, screening in the children for investigation that have a concern, where potentially the child welfare system can assist that family or child versus screening in where there is no verified concern. And then with very careful methodological considerations, we documented what we think are some key takeaways. So Tara, did I miss anything?
I don't believe so.
I think I have to move people over here. Okay, I'm going to shrink the box. So why this research was commissioned, certainly a formal inquiry into the treatment experiences and outcomes of Inuit children in Newfoundland and Labrador. We began talking with the commission and many other great partners represented here in August of 2023. We really, on our part, we wanted to ensure that we would be helpful to the process. We're very cognizant of when child welfare systems spend funds, that it should be very clear that it should be to help children and to in particular for research to really inform systems and systems reform. And then from our perspective, we wanted to look at the historical trends, give you a snapshot of present day data, potentially identify any data gaps that we saw, and then hopefully this report has some good findings as the Inuit exercise jurisdiction and develop their own information systems. And just to the right of the screen, we just tried to highlight the establishment of the Inuit Roundtable, the working relationship between the Inuit and the Newfoundland province when the ISM data system was implemented, and that's really our jumping off point. The protocol agreement that included data sharing provisions that we were engaged about 3 years ago, and we sort of had, we were happy to work with folks to see if our skill set would be helpful. If they were interested in what we thought, we were happy to engage in discussions. And then I think formally in the last year, we had resources for our programmers to begin to work with Matrix folks, to begin to work with the commission and the province to produce a report that's hopefully helpful to your larger purposes. Tara, I can't see you anymore, but if you have, please just interject.
I will.
So again, as I mentioned, the OCAP principles are something that we think about, and I always describe them as they're not, we're like, okay, we did those. It's something that we can do a better and better job at as we work with First Nations communities, thinking about how to operationalize those. We're very clear that the data belongs collectively to the Innu folks, that the discussions with the commission, with the Innu community really shape the research questions and our scope. And of course, you know, our scope is also limited for what we can contribute. Access, so that we're hoping that these data mean that they're helpful in meaningful ways. And the possession is that we're very respectful of data and privacy concerns. And at the University of Toronto, we take it very seriously, these data, to ensure their protection. This is the way we've thought about the OCAP principles for the purposes. Molly's already asked for some clarification about OCANs, but it is a system that's probably, I think, Tara, about 20 years in the making, and reflects that need from our agency partners to think about data longitudinally and the challenge of querying that in an information system. So we do that, and all the data experts on the phone, this ETL, extract, transform, and load functionality. We stage the data, we validate the data, we ensure that we have the right tables for the question, and then the production of the tables here is for our agency partners that we work with every day. We push those to the website for this purpose. We put those data in a report. Just to note that the data do come from Newfoundland's Integrated Service Management System, and we defined Innu as any person in the family unit that was recorded as Innu. So 2018 fiscal year to 24-25 fiscal year. The measures we used were counts, proportions. So we looked at, you know, how many, what proportion did that represent relative to the child population in the community, what were some of the disparities based on a population rate, and then the sensitivity and specificity, which we've had a lot of conversation around, what is a way to think about the screened-in decision, or to help assess the veracity of the screened-in decision. The population of Innu children, we went back and forth with the province about what that count was. This was the number that we used to calculate some of the disparities. 1,170 Innu children versus 64,030 non-Indigenous children. So that was based on kind of a 2021 census and provincial report. That's something that we can talk about, and folks can query those numbers as well. And so again, these are takeaways: rate per 1,000 children. So we're looking at the service population relative to the population, the population in the community. And we see that for the investigation decision. So once that screening decision has been assessed, how many children are investigated? Just over 2 times in 2018-19, and just under 3 times in 24-25. So that disparity between Innu and non-Indigenous children has grown. And then the rate of investigation for Innu children is 170.94 per 1,000 children. I always think of that as, you know, about 17% of Innu children were the subject of a child protection investigation in 24-25. I'm just pausing, Tara, in case I've missed anything.
Yep.
And so then we looked at, okay, when an investigation is closed, what is the percentage that come back for an investigation within those 12 months? And again, this could be a helpful systems measure if folks think it is. Certainly the peak disparity was in 21-22, which was almost a 17% recurrence versus a 7.5% recurrence for non-Indigenous families. So that's kind of double the proportion. This, it corresponded to COVID. These data are not causal, so we've interpreted that as potentially an influencer, and it's potentially influencing that doubling. But certainly, I know that Tara, maybe you wanted to speak to it. Maybe that the system also did a better job at recording whether or not any member of the family unit was in you. So anything that's not causal data is subject to interpretation. So that may be part of where you see that order of magnitude, that doubling. There in 24-25, you can see that the Indigenous recurrence declined to 8.2%. So it's approaching the non-Indigenous level of 5.2%. And then just to remind folks that it's a proxy, which means it's not like, it can be used as a proxy or an indicator of the efficaciousness for the decision, and the system's response to ongoing need. Tara?
So one of the things we had asked the province, and this was part of our validation process, is asking these questions. And one of the things that came up was asking about this 21-22 increase. And one of the things that government had said was that there was some point around that time that in Matrix, in their information system, they had made the field mandatory to complete, as opposed to workers being able to leave that blank. There was a point during this time period where data quality might be the reason for increase rather than a true increase in more Innu families being investigated or being verified.
So we've labeled this the most dramatic improvement in the data. And so this is where we're looking at the out-of-home placement decision. We see an 82% decrease in Innu placement rate, a 77% reduction in the placement disparity. So when we initially assessed the data, it was close to 7 difference, 6.7 per 1,000 children versus 1.55 per non-Indigenous children. So there's certainly been, for Innu children, the disparity is decreased from 6.7 to 1.5. And those are the fiscal years being assessed, the 7 fiscal years being assessed. The remaining disparity is 1.5. Equity would be 0. So certainly from the out-of-home placement decision, where the disparities have been declining in the years that we assessed.
Can I just ask a clarification question on that slide?
Yes.
So that's basically saying of cases where there is an investigation, so that I'm looking at the middle one there where you talk about the disparity ratio going from 6.76 down to 1.55.
Yes.
That essentially in 2018, 2019, an Innu child was, where there was an investigation, was 6.76 times more likely than a non-Indigenous child where there was an investigation to be placed out of the home. And
Correct.
and then by 24, 25, they were still more likely, but now it was about 1.5 times rather than about 6.7 times more likely.
Exactly, yeah.
Okay, just wanted to make sure I understood that. Thank you.
So we then looked at placement type, and I know this is from the first draft to the second draft. This was where we worked with our partners to get a better understanding of placement type. And so what we've represented in these slides is the INU placement days in 2018-19 to INU placement days in 24-25. Kinship care rose from 56 to 66% of those placement days, which is really a consistent trend towards family-based care. And you see that trend also reflected in other child welfare systems. Foster care declined from 32 to 21, reducing non-Indigenous, non-related placements. And that non-Indigenous children use group care at higher rates, 5% versus 2.3, suggesting growing complexity in the non-INU cases. So there are some changes in placement type that folks may want to think about or to question as well. I'm just going to make this smaller so I can see again. And this is the percentage of children discharged within 12 months by admission cohort. So again, we've censored the data at 12 months. When we work with an agency for 15 years, we can look at the discharge rate like for 24 months, 36 months, depending on what our partner wants to say, but or is interested about. And so this line graph compares INU children 12-month discharge to non-Indigenous children 12-month discharge. So the bottom line is non-Indigenous children, and the top line are INU children. The INU children were more likely to be discharged within 12 months than non-Indigenous children from 2019 to 2022. And then in 2023-24, there was a sharp decline. So that rate dropped from 21 to 32. And certainly it warrants more investigation into the case complexity, reunification practices, and resources. So those are things that we've highlighted that we really can't comment on from these data, but it occurred to us that those may be things that folks want to talk about a little bit more. One interpretation is that fewer admissions and longer stays could mean that the system is now admitting only the most complex cases and successfully diverting others through prevention and other kinds of collateral services. And here is the sensitivity and specificity, which has already been highlighted in lots of conversations. So again, the higher the sensitivity means fewer missed protection concerns, as Molly so aptly explained, and the higher specificity means fewer unnecessary investigations. And this is where, this line graph perfectly illustrates the tension between the two. So when you're not as investigating many cases, you're worried that we don't want to miss a child that needs an investigation. And so there are certainly that tension is reflected in this screening decision. This is for the overall system, so all families. So we put them together to kind of get our bearings before we looked at differences. And then for the specificity improvement, so the percentage of non-maltreatment cases correctly screened out in 2018, it was about 27%, and 24-25 was about 69%. So that's a very interesting finding. For non-Indigenous specificity, it was around 58%. And in 2018-19 and in 24-25, it was around 80%. So between 2018-19 and 2021, 70 to 80% of INU cases without verified concerns were still investigated versus 40 to 43 for non-Indigenous families. In 24-25, you see that gap narrowing, depending on the year, between 30 and 53 percentage points. But in the end result is that new families still remain disproportionately investigated. And that the false negative rate, so meaning that he's got screened out and it should have been screened in, rose slightly from 6.6% to 9.6%. So just to note that that it may be missing some legitimate protection concerns, but again, we don't want to overinterpret these data. They are proxies. but we thought it would be helpful. And then this is a summary slide. I mean, again, there are some variations in the fiscal years that we examined, but we just thought we would take the endpoints of the data, the 2018 data to the 24-25 data, and to look at some of the key metrics. So the investigation disparity ratio has increased. The recurrence rate for INU folks is very similar. The placement disparity has certainly declined. The INU placement rate per investigation is also declined, an 82% decrease in the rate per 1,000 children. The use of kinship care has certainly improved in those intervening fiscal years. The specificity has also improved, and the sensitivity, slight decline. So as we kind of screen out more cases, there's a slight decline, and the false negative rate, there's a slight increase that folks may want to look at. And so again, these are key implications that we thought would be helpful. Certainly happy to have questions or any kinds of or any questions about our thinking. So we think systemic change is possible. The 77% reduction in placement disparities certainly, and improved screening specificity is really a positive trend. And I think a good indication that these kinds of collaborations can produce measurable equity gains. The INU disparities are now 3 times more likely to be investigated. And that's certainly something that warrants a more investigation. There's a difficult trade-off in screening. So as we've talked about, like improved specificity. So the cases that don't need investigation come with a higher false negative rate for INU families. And again, right back to how we frame the data, administrative data cannot capture colonialism structural impacts. They say nothing about the cultural appropriateness of services or a community's perspective. And so we just really are very cognizant that these data have to be interpreted alongside INU knowledge and the lived experience of communities. The data were not designed for Indigenous realities. Systems are designed to capture service activity, not the structural causes behind the data. Critical decision-making, cultural fit, colonial context really only exists in the narrative nodes, and it's impossible to analyze in this research report. The data don't show why the investigations occur, whether decisions are culturally appropriate. We can tell you that it did. We can't tell you whether it was the right or wrong decision to place a child in out-of-home care. And certainly the social determinants of health, which we, in every room, I'm sure we're all in, we talk a lot about it. But there is very, very clear and cogent research that poverty, housing, and intergenerational trauma impacts family functioning and the ability of caregivers to meet the needs of their children. The quality of the kinship care support, these are things that these data cannot show. And certainly what is hopeful is that, future systems are really going to be co-designed with INU leadership to capture variables that are meaningful to communities, that support that jurisdiction and really reflect the understanding of families and well-being. And then the recommendations and path forward, we sort of summarize those in 6, but the ability to kind of maintain longitudinal tracking across all decision points, we view it as helpful. That's where you can monitor those disparities and kind of in real time understand whether or not there are interventions that you can employ to, at that point in the service continuum where your theory of change is to reduce that disparity. The growing gap in investigation rate, certainly, again, we kind of have to look at the screening in practices. One of the things that we didn't do is to look at referral sources and the potential biases at the front door in that screening decision. The growth in kinship care is really positive, and just this is really a kind of nod to the literature. Caregivers, kin caregivers really need that ongoing financial support, training services, and data systems can't really capture the quality of the care. The Indian registration numbers and reserve residency really must be captured consistently. Community level disaggregation, I think, between the two nations is not currently possible, so that's certainly a limitation in the report. We've already mentioned it, but really that partnership of designing a new information system, a new data system, really has to reflect EU values, priorities, and knowledge. These data are one form of evidence, but they really only are helpful if they're contextualized with that lived experience and community-based knowledge holders. So Tara, I think I've talked a lot, and you are probably best suited to talk about the data limitations. So did you want to do this slide? Happy to, but
Absolutely.
over to you.
So some of these things we've mentioned before, but some of the data limitations, particularly with administrative data, we've noted here. So missing identity data, again, not knowing or not being able to disaggregate these findings by First Nations community, which we would love to do if possible, that the administrative data does not capture colonialism's role, cultural appropriateness of these services, or community decision making. That the system transitioned, the province adopted Matrix in 2018, and we were unable to assess data pre-2018, given how those data were migrated or merged. Just to note too, small sample sizes, especially when it comes to placement of Innu children, that those are fairly low. So when we talk about time to discharge at 12 months, that those sample sizes can be relatively small. So just to be a cautionary note for interpreting proportions. The 12-month verification window in assessing sensitivity and specificity is a proxy measure. So we're looking at all those cases that were either screened in or screened out. Our proxy measure for getting it right is a verified investigation within 12 months. So just a cautionary note there that this is a proxy measure and it is limited to the verification decision. And finally, we do have some incomplete follow-up because there wasn't the time to follow those certain cohorts. So for example, for the children who were admitted into care in 22-23, we were able to follow those children for 12 months into 23-24, but cannot follow them to the 24 or 36-month mark.
So I will just conclude with, I guess now what is clear, that certainly the placement disparity is to be applauded. That Innu families, though, remain nearly 3 times more likely to be investigated. It does certainly, and this is kind of a systems finding in other jurisdictions where we're able to work with agencies or jurisdictions to analyze their data, as rates in out-of-home placement decline, what the children being admitted are really ones with significant needs and intersectional needs. The children that weren't admitted into care, it's worth understanding how prevention services are keeping that child with that family. And again, we're always very careful to make sure that these data are really one form of evidence, and the need for other considerations when we're trying to interpret what they mean. So I am going to stop sharing if I can find.
Thank you very much for that. I think it's really, really helpful to get that perspective over the years from 2018, 2019 forward on differences at the various decision-making points, looking at Innu children versus non-Indigenous children. I do have some follow-up questions I'd like to ask, but I'm also wondering if people thought this might be a good time for maybe a 10-minute break and people can.
So I think we have everyone back. It has been 10 minutes. And I'd like to just jump right in with a few follow-up questions that I have. And I'd like to start with the question. I know you've addressed some of the limitations of the data and things that the data itself might not be able to explain. But from your perspective, that the investigation rate, so you've identified that in the most recent fiscal year, that an Innu family is almost 3 times more likely than a non-Indigenous family to be subject to a child protection investigation. And I was wondering if you could provide your thoughts on the potential why of that.
Well, I mean, that's where the interpretation, I think, is something that should be done in concert with communities. One of the research and the responsibilities is to rule out anything that could explain it, like better identification of Innu families. So if there has been a change in practice from 2018 to this year, or 24-25, I guess, the last fiscal year, then that is going to potentially impact that rate as well, right? So you kind of have to rule out that explanation, which is not, I mean, these data are not causal, so it's challenging. The drivers of child protection investigations certainly have to do with structural inequalities, and that's clear to me that Indigenous First Nations children across Canada have profound structural disadvantages that are often reflected in the kinds of data that we would collect in the incident studies, where we can see families struggle, children struggle. The driver is around neglect, around risk of something happening given those structural deficits. So I would purport that the disparity in investigation rate, reflects, if we rule out any methodological considerations, certainly reflects those structural disadvantages. I think the other thing to think about is, and it's where clearly in the placement decision there's something happening, Newfoundland and Labrador, that is important. If families only have one place to go, which is the child welfare system, that's also going to drive the investigation rate. If there is an ability to meet what is a chronic need or a family functioning issue for that family without a child protection system, that's, I think, the hope for child welfare systems in general. How can we work with families to assess and support them? But the data, I think we ended it probably 3 or 4 times, are require other kinds of interpretation, and we're pretty clear about the limitations as well.
Thank you.
Tara, anything to?
Nothing to add what we didn't already present in terms of methodological considerations as well.
I'm going to ask sort of the same question regarding the reduction in out-of-home placements. So again, if you're to comment on potential whys based on your experience.
No, I think there's I mean, in other systems as well, I think there's a real clear understanding that wherever possible, children need family-based care. And so the attention on what services can be provided to families in the home, I think means that the resultant data show that fewer children are being placed in care. Again, there is a very intentional policy to look for kin and kith when a child can't remain with their families of origin for a temporary period of time or longer. How can that child remain connected to their community, with their families, in ways that, you know, allow caregivers to address whatever concerns there are and keep children connected to communities, culture, their families. So I think, you know, that hopefully child protection systems are understanding that, you know, family-based care, you know, Paul Steinhauer was one of our great child pediatricians at Sick Children's Hospital. And in the 70s, he said, I think that it really resonates with me in my career. He said something very simple, which is, you know, if you don't have to place a child in out-of-home care, don't place a child, right? Which is, you know, which is really like, it's so fundamentally profound decision for that child, for that family, that I think there is really an intentionality behind not placing in children and looking for other kinds of ways to keep that child safe and supported, and to work with families in their communities. But my Newfoundland and Labrador and Innu folks are in much better position to interpret what those data mean for that jurisdiction.
I'd like, so we've referred to a report that you have prepared, and so the latest version that we have is a March 5th, a draft report, which we've identified for our purposes as P448. I do want to just bring that up, make sure you can identify it, ensure that we are referring to the same document. So let me share my screen here. So the report for the inquiry, draft report by the OCAN's team, March 5th, 2026. This is the latest draft. This is the latest report.
Thank you, Molly. Yeah, both Tara and I have it in front of us.
Thank you. I was hoping, again, this is just going to a terminology piece. If you could, in the preface, you talk a little bit about the data, and you talk about the data being unduplicated for those of us who aren't in the data world. Can you just explain to us what that means?
That we only count a child or family once in a data line.
Okay, thank you. Another term I was hoping to get some clarification on is you use the term outcomes. You talk about child welfare outcomes over time. For example, you discuss the OCANs, that data system, as enabling system level analysis of child welfare outcomes over time. When you use that term, what do you mean? Because I think there are different ways of understanding the word outcome, and it would just be helpful to get clarity.
Yeah, and I guess the modifier is the systems outcome, because we can tell you again, and I think we concluded our presentation with, you know, we can tell you what the system did, but we can't really talk meaningfully about an outcome for a child in ways that would be accountable to a community or to a family. We're all wanting to make decisions for families and children that are responsive to their needs, address the problem, ameliorate any downstream impacts of some of the challenges. So we use systems outcomes together because we're talking about how the system responded, as opposed to did the intervention result in a meaningful change to the caregiver? Was the issue for the family co-identified? Was the concern around the child in school addressed? Did we set that child up for success in school? If that was the challenge, did we, even the prevention of victimization is very challenging in administrative systems. So, whether or not this child was a victim of maltreatment is very hard to assess through these data, and whether or not the recurrence meant that they were re-victimized or that the family concern was still present, again, is challenging to interpret. So I take your point, Molly. It's really about a systems outcome, and where I guess our conclusion of the presentation is that if you want to get to kind of meaningful outcomes that respond to children, to families, to their communities, then you kind of have to marry the two. We were looking at dispositions by systems, and the work that is done, which is very challenging work. Child protection systems and workers have very challenging decisions to make about families and children, but that's what this report reflects.
Thank you. I had a question as well, in the section of your report where you talk about some of the data limitations. I'm going to bring up your report on page 37 towards the bottom. Under the field missing and inconsistent data fields, there's a sentence here about information indicating whether a child was placed specifically to access essential services is only partially available and not consistently captured within structured data fields. And that sort of jumped out at me, and I was wondering, are you able to speak to what you did learn from the data about that type of occurrence? And also if you have recommendations about how that could be better captured.
So if it's a limitation, I'm not sure we're going to interpret it, because that would be something that we would want to be very conservative around. Tara, did you want to talk a little bit about, I know this is work that Praveen identified. Did you want to talk a little bit about it?
I think in this report, in the context here, we are talking about, we couldn't get at the why the child was placed. We are specifically talking about admissions to care, time to discharge, days of care for Innu and non-Indigenous children. But other than that, we are not able to say anything about why they were placed, either whether that was access to services or some other concern.
There may be opportunities, information systems to include that if that is of interest, to include it so it can be reliably populated, right? For every placement you would want. The trick, of course, is that those fields have to be reliably populated in order to have it be meaningful with respect to interpretation of it, right? So that's the challenge for information systems.
So basically a question of what data a worker is required to collect and enter into the administrative data system.
Absolutely, yeah.
Thank you. And now so we've pulled up this March 5th draft report. I'd like you to speak to why it is that you consider it a draft report.
Sure. So we respecting the timelines for the commission, which I know is accountable to families, we kind of were confident with our last data poll, not till January, mid-January, I think, Tara. And we quickly kind of confirmed our findings and wrote the report. We received some feedback from folks, and we incorporated those into the next draft, which is the March 5th report. Tara and our programmers have been working with the province to verify the data. So what we would like to do is to be able to work with the province to just make sure that the interpretation of it, given our assumptions and things like we constructed the data in cohorts, we unduplicated the data, we censored the data when the verification decision was made, that we have made consistent interpretations. And that's what we call the validation process. So we were hoping to have a little bit more interaction with the province, and it looks like that can happen, so that's terrific. The other two things we thought would be helpful was, in your initial request of me was to kind of describe the service continuum. And so one of the very important decision points that the child welfare systems make is the decision to transfer a case to ongoing service at the end of the investigation. So we went from invest to placement, and certainly children can be placed from an investigation, but they can also be placed when a case is opened for ongoing services. And so that missing that, like that kind of like almost when we look at other First Nations data, that kind of step diagram, right, where what's the rate of investigation, what proportion of investigations get transferred to ongoing services. We have some questions about the interpretation of that field at the back end, and we're hoping that that would kind of fill in the service continuum. And the other one is the maltreatment typology. So we typically are used to assessing data where we ask workers, what's the overriding concern for this investigation? What's at the end of it, what do you remain concerned about? And those data have a one-to-many relationship in the information system, in the Newfoundland information system, where multiple concerns are listed, and we would love to have a conversation. Is there a way to think about what is the overriding concern for this family? Because again, it doesn't tell you about the experience of the child, of the family, of the community, but it can be helpful in trying to kind of understand at a global level what families are struggling most with. So for those reasons, we labeled it draft. We did begin by saying how we're very honored that you would want to work with us to help with these data. So if we're able to do anything that would be important for the Commission, for the INU, for the province, we will endeavor to continue on.
Thank you for that. I had another question relating to the data, and that was your view in working with the data that you had, whether there were data gaps that stood out to you in reviewing the data.
So I guess that just to note, and Tara spoke to it on the slide, that when we're constructing the data longitudinally, that we are unable to kind of look at the 12-month recurrence rate for most fiscal years. For a 12-month recurrence rate, you need 2 years of data. So that's just something that and we'll hand over our scripts to the province, to the INU folks. If they're helpful, we're happy to hand over the scripts if these data constructed this way have been helpful. Tara also spoke to and so did our slides about, and this is endemic, I think, to information systems, that it's, they're good at capturing service events, but they're not good at kind of illuminating like the clinical context for why this family was investigated or transferred to ongoing service or so the child is placed. And so, you know, those data fields, I mean, just globally, we struggle to kind of, you know, approximate them, or we say proxy, or like have a parallel information system that really looks at service outcomes for children and families, the clinical concerns for families, and the documented needs that are reliably populated again, that, you know, are retrievable, so that you can say something about children, populations, or differences, is something that we are continually challenged by. That's one of the rationales we do for with the incident studies, because we have a really hard time finding those. I mean, workers, if you know, you can engage with them after an investigation, they know how well the child's doing, they know the concerns for the families, they know the household worries around economic deprivation. And so that's where we say, like, do a file review and also consider, how is the child doing? How is the caregiver doing? You know, did the household run out of money for basic necessities in the past 6 months? Even something like physical harm, right? So it's very hard to locate it typically in an information system. But a worker, if you, like, after an investigation is closed, will certainly know whether or not there's physical harm, the nature of the harm, and whether medical treatment was required. So that's, I mean, I think those are endemic to information systems, that contextual kind of piece. What the other thing, I guess, what you know, First Nations say to us is that, you know, you're measuring the deficits, and you're measuring the challenges and the kind of protective factors of communities, of families, of culture, are nowhere to be seen in the data that you present. I think it's a fair enough point. And that's, I mean, that's where when, you know, the exercise of jurisdiction and the development of information systems, I think really it kind of behooves us to create systems that present a much more balanced presentation of children and families.
And I think some of the questions I had, I think you've answered it already, which is great. So I'm going to ask a final question on my end, which is quite open-ended, is just whether there is anything else that you think it is important for the commissioners or for the Innu public to hear from you today about the research that you've conducted for the inquiry.
So you say your hardest question to the end. Yeah, it's a really impactful one. I mean, I guess from me that the, you know, that the impact of colonialism is so profound. And when you look at these data, I mean, it's easy for us to talk about, oh, did we get it right here? The assumptions here, the knowledge claims, but, you know, these are children and families. These data are children and families. And, you know, I guess why we want to ensure that communities hear from us is that we understand the burden of suffering and the legacy that colonialism has wrought, and the ongoing legacy of colonialism. So I would want them to hopefully hear that we've been very respectful when we're presenting these data, and that I think also it's really a call to kind of build on, you know, we knew that family-based care is the right thing for children. We knew that children have to be served within their culture. We knew that child welfare cannot begin to ameliorate those social determinants of health, those structural disadvantages. And I think that like for us to all be called into that mission, that we have to do better for children in this country. We have to do better for First Nations children, and serve their families and their needs in ways that are respectful. And and that that are part of the solution and not part of that continual discrimination and racism that we know has resulted in half the children in care in Canada being First Nations. So I don't know, Tara, is there anything?
No, just conversations that we've had with our partner communities, that what our administrative data or quantitative data does not capture is the experiences of children and families through the system. So we can talk to overrepresentation and disparity and disproportionality, but capturing how Innu children and families experience interactions with our systems and experience those different outcomes, we cannot capture.
Thank you both very much.
All right, thank you everybody for your attention to that portion. So we are now halfway through Dr. Fallon and Dr. Black's evidence. We will now take a quick 5-minute break. So about 5 to 3, we'll all come back and watch the last 2 videos, which we'll play together, which will be about 2 hours long. All right, so you're all free to go.
Thank you.
All right, welcome back, everybody. I hope you enjoyed your short break. We will now watch the final two of the pre-recorded videos from Dr. Fallon and Dr. Black. The first is an hour and 15. The second is 43 minutes long. We will watch both back to back without a break, just so we can get out of here a little bit earlier. So we'll watch those now, after which point we'll conclude for the day and be back tomorrow at 9 a.m.
Perfect.
Great. Okay. So then, yes, I'd like to hand it over to the province.
So first of all, I just wanted to thank Doctors Fallon and Black for their report. And just by way of introduction, I have Mark Griffin here with me. He is an ADM with SSWB. We also have Sarah Dow present, who's also an ADM who's been present at some of the circles, and Edith Minty, who is a director with the department. I believe Doctors Black and Fallon probably would have met, certainly with, I think, Sarah and Edith before, and possibly Mark as well. I'm not 100% sure on that. He's nodding.
Yeah.
I know that they've all expressed to me in meetings we've had that this report is very well written and comprehensive, and should be very helpful going forward in trying to I guess, make things hopefully better wherever we can. And I know as well that certainly Sarah Dow has indicated, and I'm sure the others would say the same, that they are more than happy to meet again with Doctors Fallon and Black to, if there's any other information or assistance we can provide. One of the first questions I have, it's noted at, I think, the second page, that the scripts that were used would potentially be made available. And I think there was a question whether or not the actual data used could be made available as well to us.
The data, well, come from your information system, come from Matrix. So we pulled them from the back end, and the scripts are what we create to make the data talk this way in the tables. It's the scripts certainly, hi Mark, hi Sarah, hi Edith. We pledge to make them available to folks if they're helpful. The data, Tara, I don't think we can transfer the data out of OCANs as per our strict privacy protocols, but you can, Matrix could give you the same polls and you could use the same scripts.
Yeah. Yeah, so anytime we received an extract from Matrix, my understanding is they would make sure that that extract was okay and following any kind of de-identification that needed to be done by the province. So they would have those extracts available.
Yeah, good question.
For analysis, they're they're your data from the back end rather than.
And then with the scripts, then you can reproduce these data, or you can use them going forward for sure.
Okay, thank you very much. I'm going to start by, I'm just going to briefly mention, I guess, some suggested edits we would be suggesting before the final report is made. And I'm going to follow up with an email to the commission and CC you guys on this. And these are just our suggestions that normally we would have provided beforehand. Starting with page 10 of your report, there is the first full paragraph cites the Department of Child, Youth and Family Services 2011, which says that the 16 would be, I guess, the termination point of a continuous custody order. We would, I guess, like it to note that the current legislation has been changed, is different, and as if the most recent legislation, it's now 18 years old, and I think that would go back to 2019. So And like I said, we'll be following up with this in an email. On page 16 of the report, it is states. Close to the bottom of the page under identification of Innu children and families, it says that Indigenous identity is captured in the ISM people table through the standardized Aboriginal identity lookup codes. My understanding, the current label of the field in our system is is Indigenous identity, and the word Aboriginal is not used. Again, that's a minor point. On page 17 of the report, it is noted.
Sorry, Catherine, I think Tara has a question, sorry.
Oh, sure.
I missed the page number of that reference.
16 at the bottom, Tara.
Oh, it was page 16.
Aboriginal is in italics, identity lookup codes. Maybe that's an artifact of the information system.
Yeah, and that may be the case, Dr. Fallon. We're just noting
We'll
there.
check, yeah.
At page 17, the second paragraph, it's not possible for analyses to be further disaggregated by Sheshatshiu Innu First Nation and Mushwa Innu First Nation. My understanding is that after 2022, they were added as separate fields. So that's correct in that prior to 2022, there was no differentiation, but now there is since then. And I think that's referenced in one of the slides, slide 15 as well.
Yes, agree, yeah.
And the last note is that on slide 8, there's reference of a decline of foster care is reducing non-Indigenous, non-relative placements. And I think the clarification is that some of the foster placements included in that would be relative or significant other foster placements. Those placements wouldn't be captured under kinship, but they would be captured under foster care.
I guess the province can give us instructions as to how we would know that in those fields.
Yeah, and that may be something that will require some follow-up discussion, perhaps, because I'm unfortunately not able to clarify that myself right now.
Yeah, we didn't see that possibility, but we're happy to interrogate it, sure.
Yeah. I do have a couple questions, and I think I only have 2 questions actually. Under the findings you made about placements, I'm not sure what page that is. It's around page 20-ish. There was a chart in your slides, and it's in your report as well, about the types of placements, foster placements, kinship, things like that. There was a question about the other category and what sort of placements that would encompass. And in particular, would that encompass ILA placements, or to your knowledge, would they be under the group home, the groups category?
What is ILA?
Oh, sorry, independent living arrangements. So
that would be other.
That would be under other, would it? Okay. Is there any other type of, I guess, other that you can think of off the top of your head that would it be that, or?
Not off the top of my head, but I would be able to get back to you on how we mapped that. Yes.
Okay.
It's pretty rare.
And the other question that was put to me, to put to you, is at the beginning of your report, let's see, I believe this would probably be around page 4, just the executive summary and the methodology. when you're calculating the number of investigations, so, you know, referring to how many investigations there are, would you be looking at screened in referrals, or would there be another, I guess, criteria you would use as to what constitutes an investigation? Because I think you said in your evidence you would only use one, it would only be one investigation per child or per family. Is that correct?
For family, but that's different than the screening decision, right? So these are screening, these are concerns from a community or a professional person that would have, that is directed towards the child welfare legislation and authority, where someone is making a determination about whether the concern is such that it requires an investigation or not. And so I know this was a point, given the way that social and health services are constructed in Newfoundland and Labrador. This was something that Tara and our programming team we went back and forth to try and understand that inclusion criteria. Tara, did you want to add anything?
No, just that I know we use the term investigation. I think you use the term assessment or PIP. So that language doesn't always line up. But no, these are not referrals. These are referrals that have been screened in for protection. Not necessarily transferred to ongoing services, though, that part.
But assessed. Yes.
So would that be a
for
case?
protection concerns?
Okay, so would that be like a case opening? Is that what you would?
It depends. Like if we call it an investigation opening, probably, is there an assessment opening?
Yeah.
At the end of a certain time period, the worker is making a determination about verification and also the need for ongoing services. So typically investigations get closed, and then if necessary, there's an opening for ongoing services. That is the disposition that we're struggling to interpret, and look forward to conversations with your colleagues.
Okay. Just let me check. I think I'm good for now. We may have, this might be something that needs to be followed up later, but I don't think I have anything else to ask at the moment. Thank you very much.
Happy to chat later.
Thanks.
Okay, I'll start, Molly, if that's all right.
Please, that would be great. Thank you.
All right, great. Thank you, Dr. Fallon and Dr. Black, for your report and your presentation earlier today. My name is Haritha Popuri. I'm a lawyer at OKT, and along with Judith and some other lawyers here, we represent jointly the Innu representative organizations, and that includes Innu Nation, Shehajit Innu First Nation, Bushwao Innu First Nation, and we also represent the Innu Roundtable Secretariat. So just like Ms. Churchill, I will be posing my questions to both of you since you wrote the report together, but whichever one of you wants to answer, feel free to jump in, and then if you have anything to add, please do so. And I'll be referring to your report throughout my questions, and at times I might project it on the screen, but it would be helpful to have a copy available with you while I ask the questions. Okay, so I'm going to start by clarifying what is not in the study, and then I'll start asking some questions about your specific findings and analysis. So looking first at the time frame, I understand that the time frame for the data analyzed is between 2018 and 2025. you mentioned that the province had a different data system in place prior to 2018, and then it migrated into the new system, ISM, which was run by a company called Matrix. Is that correct? Okay. So can you maybe help us understand why the data from before 2018 was not incorporated into your analysis?
It wasn't because it wasn't part of our research objectives. Through a series of conversations, we agreed that given the implementation of the new administration and new administrative data collection system, that our talents would be best suited to understanding it from 2018 forward.
Okay, and so is it the case that the data from before 2018 just wasn't provided as part of the collection you received, or it just wasn't because it was beyond the scope? Sorry, go ahead.
Well, the data were provided with the permission of the province and the commission through Matrix, right? Through directly through the vendor. That's the way we pull the raw data. Data prior to 2018, Tara, did you want to reference those?
Sure. So whenever an organization migrates from one system to another, we know from previous experience that getting access to those legacy data can be difficult, depending on how that data has migrated over. So we knew from the beginning that 2018 forward, we were fairly confident that we would be able to get a good extract of those data from Matrix. Anything prior to that, we had no idea whether we would be able to get or not, depending on how those data were migrated over. Sometimes data are migrated into PDFs and therefore cannot be extracted from those data systems. So we did not extract anything prior to that point. However, there are children in the system who were placed prior to that. So, I mean, when you talk about children and families, so yes, there are children who were in care in 2018 who were involved prior to that. So that person is in those data. But anything prior to 2018, we don't have confidence in at this point in terms of what we could extract from the current vendor, which is Matrix.
Okay, and just to be completely clear, did you see or receive any kind of administrative data that had been extracted from before 2018?
So when we were doing validation with the province, what had happened, typically our validation process is we would produce tables and then share those tables with the province, say, can you run the same things, see if our answers line up, and then if things are off, we would then start this validation process of going back and forth in terms of, well, what cases did you get, what did we get, where can we consolidate these things? What had happened in this case is, I believe Mark Griffin had done a ton of work before we started our analyses, and they had securely transferred those data in Excel format to our servers securely last summer. And when we look at those data to try and kind of retrospectively validate the data, what we found is that there are rows in those data where the child or family was involved prior to 2018. Now, we can't see that on our extract, and we're working with Matrix to try and figure that out as to how maybe the province could do that and we couldn't. So those one of the things that we'll probably be talking to the province about going forward as to how we could consolidate the two.
Or whether it's possible.
Yeah.
Okay. So in your view, it's not clear yet whether it would be possible to consolidate them. Okay. And then those Excel spreadsheets that Mark Griffin prepared, would it be possible to provide a copy of that to the inquiry as a follow-up?
I don't know that that would be up to me.
Not from us, yeah.
Yeah, the government securely transferred those Excel spreadsheets, so I would guess that would be a government question.
In that case, I'd like to ask the Commission Council to work with the province to obtain those spreadsheets if possible, redacting them for private information and confidentiality, and disclose them to the parties with general standing, if that is possible within the time remaining for the inquiry.
I think that's something that we're very happy to just engage in those discussions with the province and better understand what the data is, if there are any concerns, et cetera. So definitely something that we'll have a side conversation on to determine if that can be done.
By the sounds of it, those spreadsheets would be of interest to the ENU organizations, particularly if they are in Excel form rather than PDFs. So I'll just note that. Moving on, I'd like to ask about, just to be sure, for data that was collected prior to 2000, do you have a sense of what shape that data is in, whether it's retrievable in any form?
No.
No, you don't know what shape it's in, or no, you don't know if it's, no, it's not retrievable.
Well, both. I mean, we don't know what shape it's in, so we can't comment as to whether it's retrievable.
Okay. All right, now I'd like to ask some questions about disaggregating the data by essentially the home community of an Innu child. So your presentation flagged as a place where improvements could be made is in tracking the community for these children, as well as with the Indian registration numbers. So just starting with the community, it sounds like from the province that there has been better tracking of this since 2022. But I just want to be sure that in the data that you analyzed, this wasn't consistently recorded, meaning it wasn't consistently recorded if an Innu child was from Shehajit or Natwashish.
Right.
Okay. And then with respect to Indian registration numbers, what was the, I guess, how consistently reported was that information, and what would that have told you if it had been more consistent?
I don't believe we had that information. We don't have a table outlining that number.
How would it have impacted the analysis if there were Innu children who were not registered?
That would probably be a question for the province as well, as how they would endorse Innu versus something else. If the person has to be registered in order to use that as or to endorse that data field, that would probably be a question for them.
And yeah, and to report placement with ISK and all those sorts of things, but that's not something that we were able to speak to.
Would it have been possible with the data set that you had to look at the home address of the, I guess the family in this case, and determine from that what community would have been associated with the child?
We wouldn't have asked for that data table, and we would not be allowed to, under our ethics agreement at the University of Toronto, to hold those data.
And
maybe then the last couple of questions on this topic. My understanding is that for several years, the province had two zones, a Shahajit Innu zone and a Mushwao Innu zone, and each of them had their own zone managers that administered child protection services. Did you see any indication of that information in your data set? And no, thanks.
So I guess on page 39, the limitations in capturing service context is the administrative data that we receive do not capture information about service availability, worker caseloads, training, resource constraints, policy changes, etc.
So in general, would you say that there just wasn't enough information available, I guess, to really say with certainty what community these children were associated with?
From our vantage point, yes, that's correct.
Okay. And all right, okay, I'll leave it at that. Okay, so then when it comes to determining whether a case involved an Innu child, it sounds like that category was more consistently tracked, again, especially after 2021-22. And I just wanted to get a better understanding of how a case was tagged as Innu, essentially. So you note, I believe at page 38, in the report you described that a case was tagged as Innu if any person in the family unit is Innu, and that could be a parent, it could be the child themselves, it could be a caregiver. But at page 38, you note that this might not always be the most consistent or appropriate definition. I'm wondering whether you might be able to expand on why that is.
Well, it's a decision we made to analyze the data. So and it's the most expansive one, right? And it's one that when we work with communities, they give us a different instruction. Sometimes they're only looking at the identified child and their ethno-racial identity or indigeneity identity. We made the decision to broadly define Innu as any member of the family because it's the most expensive one and probably the one that, is more community-based or captures the intersection with Innu communities. So it's a analyst decision. So one that leave it at that. Tara, anything?
I don't think so.
All right, and then the last term I'll ask you about for now is just with respect to cumulative disparity. That's coming from page 19 of your report. And I'm wondering if you could explain how that concept carries through in the rest of your report.
So the cumulative disparities is a concept that we really that we typically use again to our testimony earlier this morning. Is it this morning? Yes, still this morning. No, it's this afternoon, but from this morning, when we Molly kind of framed the paper looking at the service continuum, and so we want to see where the system then kind of, when we're looking at disposition, kind of doesn't necessarily arrest the disparity, but may exacerbate it. So typically we see that in the placement decision. And certainly in the denouncing the continued overrepresentation of First Nations children in Canadian child welfare, that pattern of cumulative disparity where we started a 3.5 times more likely to be investigated. We look at transfers, we look at court, we look at placement. We see essentially the system is not arresting those disparity points. So that's something that we kind of front-ended to say it was something that we were looking at during our analysis.
And some of those decision-making points in the continuum that you mentioned, so court applications, for example, that's not set out here in the report.
Yes, that's correct.
And is that because the information wasn't available in the extracts you got from Matrix? It was not available. Okay. All right. All right. I'll now turn to your findings in more detail, starting with Table 1, which is at pages 20 to 21. Okay, so, and correct me if I'm wrong, but I think maybe the takeaway, or one takeaway from this, is that Innu children are more likely to be the subject of an investigation by CYFS in 2024-25 than they were in 2018 and 2019.
More
I
like,
saw
but
mixed
not
reactions here.
indigenous. Yes.
The disparity is 2.87.
Right, so they're more likely than a non-Indigenous child to be investigated. Okay. So then just breaking that down a bit more in terms of how you've set out that information. With what I see here is the use of a rate per 1,000 children. And your chart calculates that rate with reference to population. And so you used, for the Newfoundland non-Indigenous population, you used a 2021 census figure. But with respect to the Innu child population, you relied on, could you maybe explain your source for that population figure?
Sure. For the child population, typically we use census data. The census is completed every 5 years. So census 2021 would be the most recent that is available at this time. And we have paid for a custom Statistics Canada tables because typically Indigenous status is captured by groups, age groups, instead of by single years of age. So it's hard to capture, you know, something like the location of under 16, under 18 is very hard to calculate. So we ask for single years of age. So we're able to do that for non-Indigenous. When we were looking at Innu children, the child population seemed extremely low. So that was sort of a red flag for us for the census that perhaps, and with our experience before of, you know, 20, 30 years of doing the incidence study and working with child population data, is that sometimes our First Nations communities do not complete the census for very good reasons, but that can be a barrier in calculating rates. So then we started looking at other data that would be available. One of the things we came across was public health data that was calculated for both communities, again, grouped. So that's the data we did use. We had to estimate the 15-year-olds because they were group data. So I think if I remember correctly, it was like 10 to 14 and 15 to 19 or something. So we estimated the 15-year-olds in that group and then came up with our estimate for the child population for Innu based on those two communities.
And so you mentioned that this was public health data. I understand that while you wrote in the report that this came from the province, in fact, it came from the two First Nations public health departments. Is that your current understanding?
I think we said broadly government, and yes, so we can correct that to be public health rather than government.
Okay.
If that's all right.
All right. And then I also note that the population data is for Innu children, you use the data that's from 2019 for each of the years you analyzed. And then for non-Indigenous children in the province, you used the same population, which comes from the 2021 census. So I just asked if you had population numbers that were accurate for both Innu and non-Indigenous children for each year included in the study, would you have used the data specific to each year in your analysis?
Yes, if we had accurate data, but they don't exist at a population level.
Okay. And so, and if there was a growth in the Innu child population over these 7 years, would that create differences in the actual rate of investigation that we're maybe not seeing in the table with the data that was available?
If the child population is a bigger number, the disparity would be less.
Okay. So now just looking at the findings a little more closely. First, I'll just note that while we have been talking about rates per thousand, it might be a little bit easier for some people to understand. Maybe it's Miss Churchill's niece or just myself. If we were to use the more kind of approachable standard of percentages. So that would be, for example, in this chart, instead of saying 129 Innu, a rate of investigations for, 129 per 1,000 children, you would say 12.9%.
Exactly, just under 30% for Innu children versus just over 6% for non-Indigenous children.
Right. Okay. So in summary then, across the 7 years, somewhere in the range of 12.5% to almost 19% of Innu children were the subject of a child protection investigation. Is that accurate?
Yes, it's, as you mentioned, the caveats around the child population, but that is our estimate.
Right. Okay. And then in contrast, I think, as you just mentioned, about 6% of non-Indigenous children in the province were the subject of an investigation in each year.
Correct.
Okay. Now I'd just like to turn to the report from 2022 that was mentioned earlier. This is entered as an exhibit P-087. This is the, the full title is Denouncing the Continued Overrepresentation of First Nations Children in Canadian Child Welfare, Findings from the First Nations Canadian Incident Study of Reported Child Abuse and Neglect 2019. So as we heard from you earlier, this is a report that both of you are familiar with, yes?
Yes.
Okay, and I'm just going to share that document for a moment and ask you a couple of questions about that. So just bear with me here. Okay. Okay, can you both see the document?
Yes.
All right. So this report provides an analysis of the treatment of Indigenous children in the child welfare system as compared to non-Indigenous children nationally.
So I'll just correct you that this figure is Indigenous and non-Indigenous. Most of the tables are for First Nations children because we had a First Nations advisory committee.
Okay.
So the distinction is an important one. For Métis and Inuit children, the data are available to those communities, and we've worked with some, but most of the rates are for First Nations children compared to non-Indigenous children.
Got it. Okay. And the data that was collected here for this report, which I'll refer to as the national study, it was collected as part of a 3-month sampling period towards the end of 2019. Is that correct?
Partially. So boy, okay, I have to keep Molly's 11-year-old niece in mind, but so the issue for this study was a complicated one. The decision to fund it was last minute. The Ontario government wanted to conduct what was then its 6th Ontario incident study. So the data for Ontario were collected in 2018. The government decided to go ahead, and through the Assembly of First Nations and a contribution agreement through the Public Health Agency of Canada, they then elected to fund the 3-month case selection period, of which we design calibration weights to do the estimate for the year. And so while we were underway, there was a high-profile death in Quebec where all research was stopped, and we ended up doing a census pull from their administrative data and mapped those fields onto our data collection instrument, and then weighted the data accordingly. So sorry, Harisha, for that long explanation, but that's how we collected these data.
Okay, and the year to which the data relates, it's apart from Ontario, it
2019, yeah.
From 2019, okay.
Yes, and the estimation would be that we can verify with other Ontario data that there wouldn't have been much of a difference in terms of volume of investigations, and that's so the knowledge claim, of course, is the weights, and we want to make sure that the error terms around those, and we were confident that that was a reasonable knowledge claim of 2019.
Okay. And so in the overview you provided, I think it's apparent that there were differences in the methodology that you used for the national study compared to the report that you did for the inquiry. For one, yes. The one you did for the inquiry is a longitudinal analysis.
Yes.
But would there be some basis for comparison by just looking at the data in the inquiry report from 2018-2019 and looking at that against the national study?
Well, no. I mean, methodologically, I would say no, because the purpose and objectives are very different, right? We pulled these data to produce an estimate of Canadian child welfare services, not a provincial one, with really the exception of Ontario and Quebec. So methodologically, it would be challenging to say there's a basis. I think where you could one of the things that strikes me is that initial investigation rate is very similar, right? And we see that in other analyses of First Nations, of Native Americans. We see that kind of initial investigation rate at between 3- and 4-fold. So methodologically challenging to compare. This is a case file review with workers. The Newfoundland analyses that we did on behalf of the Commission is really about administrative data, and as I mentioned, challenging to get more of the context. So,
okay, so it sounds like, if I understand you correctly, it's this disparity that was measured, let's say, with rates of investigation. Here it's 151 per thousand, or 15% for First Nations children, compared to 42 or out of 1,000, or 4.2% for non-Indigenous children, which is about just under 4 times greater. Okay. And similarly, in the rate of investigation that you set out, and I can take us to it, for the Innu, there was a disparity there, which was, it started out around 2, and it increased to 2.87. So that disparity is something that is in common when you look at the national
investigation
data.
Yes, that I think that's a fair statement.
Okay.
Methodologically, very different purposes and
okay.
Populations. Yeah.
Okay, I'm then going to take us to table 2 regarding recurrence.
Is this in the FNCIS or
the inquiry report?
Okay.
Okay, and that's it starts at 22, or let's see.
Yeah, just on the next page.
There we go. Okay, so the table itself is on page 22, and I'll probably stop sharing. I just wanted to show the national study. Okay, so we spoke about what that term means a little bit earlier today, and what I take from that is recurrence tracks where an investigation is closed at first, but then another one opens within 12 months.
With a verified concern.
Yes. With a verified concern. Okay. And so essentially, this is not something that we would want to see too often, because it would suggest that there are struggles within the family that were potentially missed at an earlier point. And so we would ideally want that figure to be very low.
It can be, that can be an interpretation. Again, to my earlier testimony this morning, it's a systems indicator potentially of efficacy, and we always encourage it to be viewed in concert with others. So.
Yes, and actually that reminds me that earlier you did mention that there are some caveats to treating recurrence as a proxy for the effectiveness of the system. I'm wondering if you could elaborate on that a little bit more here.
Well, the challenge with these data is if we were to view recurrence as a miss, we would want to make sure that the same concern identified during the index investigation is what has come back and been verified. And so we have no way of knowing that. The other kind of the inverse of it is that we look for a verification decision. What it doesn't measure is cases that can reoccur without it, which also could be a proxy of need that's unaddressed. So those data are not, this table wouldn't capture those instances. I think Molly's observations around outcomes, this is, these are service disposition outcomes, whether or not the family has come back with a new need that wasn't identified in the investigation is not going to be answered in this table. So we really want to kind of move the field towards what did the worker assess as the family need? How was it remedied? What was the plan to ameliorate it in concert with the family, cultural connectivity? And then based on that, then how good a job did child welfare do in meeting it in concert with all of its partners?
That's helpful, thank you. And we noted this term before, but it would help me if you could just explain a little bit about the reasons why an investigation could be closed. What would make it a closed investigation?
Well, just globally, I would say that there can be a verification decision and a case would be closed because there's not an ongoing protection concern for the child. The case could be closed because as we were talking with the sensitivity specificity analyses, it's opened and there's not a verification decision, there's no concern, so it's closed. It could be that the system has met the family's needs with or without a verification decision, but typically in child welfare systems and investigations get closed, and then if necessary an ongoing service could be opened. So in the FNCIS, the rate of transfer I think is 1 in 5. I have so many incident studies in my head. I think in the 2023 data in Ontario, it's less than that. It's about 18% of investigations get transferred to ongoing services.
Okay.
So typically an investigation can be closed for lots of reasons.
And then I just wanted to know whether when you describe on page, let me just find it, I think it might be page 21, you describe the rate of recurrence for the province as low. And I'm wondering whether that is an observation you made with respect to kind of national data, or what would lead you to classify it as low versus high?
Well, given the high stakes decisions, I guess that child protection systems make for children, 5%, if we were to interpret it as an error, I'm not saying that that's, there's not lots of limitations for that interpretation. That means that that's a pretty 5% error is pretty good, given the kinds of high stakes decisions that are being made for children and families. There is enormous variation in recurrence, depending on the system, depending on the agency, and honestly, it's a reflection of the community as well. And resources in the community as well, because I mean, not saying for Newfoundland and Labrador, but the child welfare researcher in me would observe that what gets called child maltreatment is quite expansive. And so sometimes for child protection authorities acting in a community, there may be nowhere else for a family or a child to be referred to other than a child welfare system. So that recurrence is also part of that context that are missing in these data that weren't able to measure, is kind of the health and social service infrastructure available to families. Tara, I don't know, anything to add?
No, just that in our experience, we've tried to stay away from having benchmarks or anything like that, but yes, that we've seen enormous variation.
Yeah.
In recurrence.
So in that case, would it be more helpful to continue tracking it over time within Newfoundland and Labrador in order to better understand whether improvements are being made, whether it's lower or particularly higher in 1 year, and that might be cause for further investigation, or it's better to keep it focused within the province?
I think it's a helpful proxy if it's viewed as a proxy and part of a metric that informs decisions, because as we've mentioned, there are lots of limitations to it. So you really want to round it out. Why are families coming back? Is it for the same concern? Is it for a different concern? You know, some of our First Nations partners, the recurrence is because there's a full suite of prevention services attached, and so that may manifest itself in this ever expensive definition of child maltreatment, but really it's because they're able to access different services. You know, whether it's through a child welfare system, that's not for me to decide, and you're not asking me that question, but what recurrence is very helpful to is if a child is injured again, and any data that we've ever seen, that's not why families are coming back. Families are coming back because of those structural issues, those social determinants, because the system is a forensic one, so it does a pretty good job at preventing urgent protection concerns. The challenge, of course, is when a system is asked to ameliorate the challenges families have without the right tools and resources, and that's typically, you know, why families are coming back. But there's a lot to unpack, I think.
And so maybe tying that into something you write about the spike around 2021, 2022, where it goes as high as, I believe, 16% for the Innu. You suggest as one possibility that it had to do with the COVID-19 pandemic. And so there could have been, the impact could have been more pronounced if during the pandemic, the CYFS department was the only one that families had available to get supports that it needed during that time.
Absolutely, yes. That could be an explanation. And whenever you see those kinds of differences, of course, you want to rule out a methodological one, and that's where we're saying the province at that time is saying, hey, we're really going to make sure that workers populate that field. Then the number of Innu children would obviously increase from previous years, so that may be part of that increase. We can't say, right? So.
Was it possible to tell what services were offered in cases where there was recurrence?
Not from the data we received.
Okay.
But that's a good, you know, I would imagine that's the work I had for everyone, so.
All right. I'm now going to move on to table 3. That's at page 24. I'll start with a few questions just to unpack the meaning of an out-of-home placement. So you define in a couple of places, you define placement as, quote, any out-of-home living arrangement for a child, including foster care, kinship care, group care, or other residential settings. So you could say that the way placement is defined, it's inclusive. And in particular, it includes something like kinship, even though the province would not call this, it would not consider this a version of being in care.
Correct, because we thought it would be helpful for these research objectives to, regardless of whether it's considered in care or not, to illuminate that placement category.
And when a child is in kinship care, it still means that they have to change where they're living due to the involvement of the child protection system.
Correct.
So there's a displacement from their home environment.
It's a change in residence for the child.
Change in residence, yes. Okay, so in that sense, would you agree that kinship is a less intrusive form of placement, but it is still a placement?
Well, I think the less intrusive form of placement is is not really one that I can answer because I'm not a child who is being asked to move residence. So even if it's to my beloved auntie or cousin, and that's not for me to decide, but it is a change in residence for that child. Maybe a necessary one, but it's a change in residence for the child. The theory behind kinship is that it's less disruptive. Theoretically, although this is where I think there's a dearth, particularly in Canadian child welfare research, about outcomes for kinship care, right? So it's going to be a different kids that are connected in a way that enables a kinship placement are going to be different potentially than children who are placed in foster homes or a group home or anything like that. So it's really, it's kind of challenging to, and I don't think it's a yes, no, agreed or not agreed. I think it's one that we have to do a better job at understanding from a child's perspective what that is. Tara, anything to add?
No. No.
And then the way that placement has been conceived for this analysis, it would include Innu children who are placed within their own community, so in another home within Natwashish, for example, as well as Innu kids who were placed outside of their community. So let's say that child was placed in a home in Shehaji.
We don't know where.
But globally, that's a sample, but we don't know where. Yeah.
Okay. And would it have been possible at all to know whether the child was placed outside of, so somewhere else in Labrador, outside of the two communities, or whether they were placed somewhere in Newfoundland or outside of the province altogether?
We don't know that.
Okay. So what would need to happen in order to be able to analyze that in the future?
Well, we would have to know the address of the placement, right? And the address of the child, from the index event, and the address of the placement. We've done those analyses for different agencies where we're looking at, within their catchment area, where are children placed if they are. Those are not data that we had.
And I think you mentioned before that that data was not available to you under the terms of your data sharing agreement. Is that?
We didn't ask for those data, but nor would we be allowed to hold them at the University of Toronto.
Okay. Okay. Then one last section on this. Would there have been a way to know whether an Innu child was placed in an Innu home as opposed to a non-Innu home?
No.
Not in the data we.
I mean, the kinship label or determination is a broad one, but I mean, again, maybe it's a proxy, but no, not from the data we received.
Okay, then just looking at the information that's set out in Table 3, it looks like this is a kind of a success story in that the number of Innu kids who were going into a placement each year has gone down and gone substantially down over the 7-year period.
Correct. From these data, that is correct.
Okay. And specifically, you can see that things start out with a rate of, a count. You have 92 Innu children admitted into an out-of-home placement in 2018-2019. And then that number goes down to 30 Innu children by the end of the study.
Correct.
Okay. And now looking at the rate, the decline is, if you convert it to percentages, it goes down from just over 70% of investigations involving Innu families to about 13% in 2024-25.
Correct.
Okay. And this is a substantial reduction in your view.
Correct.
Okay. I think your presentation said 82% reduction.
I guess that's the math.
And then in terms of the disparity between the rate of admission for Innu children compared to non-Indigenous children, that goes down as well from 6.76 to 1.55, which is about a 77% reduction in disparity.
Correct.
Okay. Nevertheless, there is still some disparity as of 2024-25.
Correct.
All right. Now, I know that you would caution us against trying to compare the findings in this report against the national study.
I would.
Okay. So I think perhaps maybe I would ask in general what might make possible or what might be a future direction of research in order to be able to compare, let's say, the placement rates for Innu against the treatment of First Nations children nationally.
Well, that would be a very expensive study, first of all. So one of the differences in research objectives is that in the FNCIS, we looked at the number of children placed relative to the population, right? So we didn't control for the front door. Here, it's the number per 1,000 investigations, right? So it's a decisions-based disparity because that, I think, reflected the instructions we had from the commission and from the Innu communities. So, and it's just mathematically, I mean, again, these are children and families, and these data represent a burden of suffering. The sample size is small. So that's like mathematically, then this is the way that we felt it was best interpreted. In the FNCIS with the, we had a universal sample, it doesn't really get weighted. We had the rest of Canada with these calibration weights in Ontario. We work with a sample, unweighted sample of like roughly 40,000 to design weights that bring it up to over 300,000, right? So that's why it's just really, when these data are longitudinal, the CIS are, point in time for the year, the incidents of reported. So it's a really different kind of calculation. That profound disparities exist for First Nations children. I've never seen data that don't represent that.
Okay. Did anything about the rate for Innu children in this case, the rate that was admitted into a placement, did it strike you as being kind of unusually high compared to what you've seen in other studies?
Sorry, the rate of placement, the rate
Yes.
per investigations, 1,000 investigations, is that unusually high?
And more specifically looking at 2018 and 19, where you set out that it was 713 per 1,000 investigations. Does that strike you as being quite quite unusually or significantly high.
So I won't say unusually high. I will say, I mean, these are where we really need to do a better job at collecting data and being accountable to children and families. You know, that's 70% of children at the end of the investigation are placed in care. Again, we don't have great Canadian data, but of children in care on any given day, about half of those we estimate, again, with all those caveats, are Indigenous. So, I mean, and I use the word Indigenous intentionally. So, you know, I mean, that's all I'll say, I guess.
Okay. Then kind of taking a step back, something you noted in your presentation is how it's important to be able to think about this analysis against the context and sort of major shifts in practice, policy, and in particular, the kind of reforms that have taken shape for the Innu in having a more collaborative governance model. I believe that's the term you used. And so I'd like to mention or reference a source that has been entered as an exhibit and which speaks to that context in a little more depth. This is exhibit P-441, and it is entitled the Innu Services Report. I can share my screen just to make sure everyone knows what I'm referring to. Just a minute. Okay. I don't know whether this report has been shared with you in advance or if you are familiar with it, but I can provide a short description of what it contains. So it provides a kind of summary of the Innu organizations that have been involved with this inquiry. And in particular, it describes the history of Innu prevention services. So that is starting around here. And what it says there is that before 2017, there were no prevention services to the Innu. It wasn't provided by the province, and as such, it wasn't funded by either the provincial or federal government. But things changed in 2017. In 2017, the Innu started Innu prevention services with federal funding. And that is what became Innu prevention services, including, and it included things like an advocacy role for Innu representatives. And these Innu representatives engage with families and with provincial child protection services to try to get better outcomes for children. The funding has increased over that time, as has the staffing for Innu prevention services. In the first year, it was 7 workers, and further down in the report, it says that the number has grown to 35 full-time staff members serving both communities. So hearing that description of the emergence of Innu prevention services at pretty much the exact same period that's been covered by the report, do you think that it could provide an explanation for this significant decrease in the placement rate for Innu children from the beginning of the study period, which is 2018-2019, to 2024-25?
So methodologically, we did not measure that. We understand the context, and what I would say is there, given that 700 children for every 1,000 investigations were placed which has dramatically declined, the way of working with communities to ensure that their children are safe, that their caregivers are supported. There's not a different way of thinking, in my opinion. I know I'm an expert witness, but in my opinion, that is exactly what we should be doing, is working with communities to support their own children, and that it has impacted the data. As a researcher, I have to say you can't rule out the explanation, but we didn't measure it. But I mean, that's the way we need to go forward with communities and for children.
And so in working closely with communities, in empowering them to understand and attend to the needs of their own people, would you say that it helps carry out this philosophy you spoke of not placing a child out of their home if you don't have to place them out of their home? Like
Absolutely.
it really, yeah, okay.
We're good to go. Thank you.
Thank you. And I'm hopeful that the last sort of areas that I'll be asking questions should go a lot faster. I'm going to move to table 4, which is at page 25. And I'll just start pretty general. I'm wondering if you could maybe take us through how the information is organized in this table and what it's presenting to us.
Sure. So this was an added table from the first draft to the second draft, and it was our attempt to get at different types of placement, because we had admissions to out-of-home placements, and thought, oh, I wonder if we could get at different placement types. So this was our way of doing that, of looking at longitudinally the days in care that a child would experience. So same format, we went through different fiscal years of from 2018 to 2024. We disaggregated by Innu or non-Indigenous children. And then what we're able to do is map placement type table to broader categories called foster care, group care, kinship care, and other. And what we did was then we looked at how many days in care were spent in each of those types of placements, how many children those represented, the average days in care per child, the percentage of days by placement type, and finally, the proportion of children that were in those placements.
So then just to maybe start at the very top, for the fiscal year 2018-2019, with respect to Innu children who had been placed in some form of care during that time period, looking at foster care, 69 of the children who were in a placement, of the Innu children who were in a placement, were in foster care.
Correct.
And those 69 children collectively spent 21,793 days in foster care.
Correct.
Okay. And so then the average is just how long each child would have spent in foster care.
Correct.
And then the days in placement would be, so 21,793 days in foster care over the total number of days that all Innu children spent in all forms of care.
Yes, correct.
Okay, and so that works out to 32% of the Innu children who were in placements and spent, 32% of the time that Innu children spent in a placement was spent in foster care.
Correct.
Okay. And then lastly, what we have is information that tells us that of the Innu children who were in placements, 29.8% of them were in foster care.
Correct.
All right, great, thank you.
It's a complicated table. Sorry.
No, I mean, in other places we ask for a breakdown that's not there, so it's actually very helpful to have these
We
details.
just thought we just put it all out and folks
Yeah.
can say what's helpful or not. So yeah.
And so I know in your presentation, you kind of summarized how there was, actually before I ask that, I'm wondering if you can maybe speak to why it's important to track something like placement days.
Well, again, this is just a different way of looking at placement type. Typically, the way you would see someone from an organization or government report on placements is that how many children are in care on this date, and you get a breakdown of what that would look like. Here, we're able to say longitudinally, in that given fiscal year, where are our children spending time and for how long are they spending that time? It's one thing to say, 60% of kids are in foster care, but maybe those are smaller stints compared to longer times somewhere else. So we thought it was a helpful way of looking at things.
Yeah, and I guess the other reason why we produce this metric is when typically systems are trying to respond to people who think that a child in care is in care forever. And one of the things we try to emphasize with these data is that, most children spend less than a year in care. And I guess the inverse is that, on average, a child is away from their caregivers 315 nights. And so, like, both of those interpretations is really important with respect to accountability and the gravity of this decision that systems make for children.
Mm-hmm. And so maybe looking at that if our concern would be a child spending more of those nights outside of their home, then it looks like consistently where they are spending the most time is in group care. Or rather, when someone is in group care, they tend to stay there for longer on average than when they are in a different form of placement.
That's probably true. Again, that data limitation where, especially for INU children, when we're talking about group care, we are talking out of a very small number of children. So in this case, in 2018-19, we're talking about 6 kids.
But on the flip side, you see that, and again, I'm still just looking at 2018, 2019, for those kids who are placed in kinship care, they spent on average the least amount of time, but perhaps that's a function of the fact that most of the children, the highest number of children were placed in kinship care.
Well, and a different population, right? So children who have a kinship care placement available to them are probably going to look different than children where the placement is group care. And there may be, behavioral issues, there may be multiple challenges for that child. And the result is that they stay in that placement for longer. For that youth, I guess.
And so just one last question on this table. Well, rather on page 28, you write that extended stays in group care are generally associated with poorer outcomes for children. I'm wondering if you can talk a little bit more about what you mean by that.
That would be the same comment as what Dr. Fallon just said, was that typically what we see, given our research, is that children who are placed in group care are more complex. I see that term being thrown around quite a bit these days, either behaviorally with internalizing, externalizing behaviors. And so that group of children do not tend to do well and tend to have overlap with criminal justice. You hear about crossover children, and that's what we're making reference to there.
Okay, so
The question, it's the attribution, right, is the challenge. Right, so children who are placed in group care tend to have intersecting crisis kinds of situations. The group care presumably should ameliorate some of it, but prior to entering group care, the challenges for that child exist. And so the poor outcomes, of course, we as child welfare professionals need to understand the role that group care can play in ameliorating those. But the attribution, again, is not only to the type of care, but to the supporting services around that youth, that child, that family.
So just by measuring the time spent on average in group care doesn't necessarily tell us what the quality of that care was and how it may have ameliorated the challenges that a child was facing or not.
Right, exactly. Right, and right back to what Molly said, you know, we need to do a better job at understanding the outcomes of that placement for that child based on the reasons why that child was placed in the group home, the service plan, and what professionals around that child and family expected to have happen for, you know, him or her or they.
Mm-hmm. All right, I'm gonna shift now to table 5. And that's at page 29. Okay. So discharge essentially means that they were in a placement before and then they no longer are.
Correct.
Okay. And then kind of similar to what I did with table 4, I'm just going to kind of take us through how the numbers work out across these categories that you have here in table 5. So with 2018-19, for Innu kids, you can see that in 2018-19, 92 Innu kids were admitted into a placement. And then within 12 months or a year of that admission into placement, 36 of them were discharged. So 36 of them were no longer in a placement.
Correct.
Then within 2 years of being admitted in 2018-2019, an additional 13 were discharged in that time.
Yes.
For a total of 49 being discharged after being admitted in 2018-2019.
For more than half, yeah, admitted into that fiscal year, yeah.
Right, right. And then when you look to 3 years or 36 months out from being admitted in 2018-2019, a further 11 more Innu children were discharged in that time period.
Right.
And so in total,
Oh, 9. I think that's 9.
Is that not? Oh, my bad. 9.
Yep. That's right.
Yes, yes. Okay. And so in total, within 3 years of being admitted into a placement, 58 out of 92 had been discharged, meaning 63% had left their placement.
Correct.
Okay. And so what that leaves is, and I may be getting the math wrong, but I think it's 34 Innu children remained in a placement longer than 3 years.
Correct.
Okay. And so one way you could determine the number of Innu kids who remain in a placement after 3 years would be to subtract the number in the third column from the total number of kids who had been placed or admitted which is set out in the first, well, rather the second column.
Yep.
Okay. So, then taking us through the years that we have information across the 3-year period, I guess. What you can see is that 15 Innu children remained in a placement after being admitted into a placement in 2019-2020. So that would be 58 minus 43.
Correct.
Okay.
I'm just doing the calculations on the Excel spreadsheet. So yes.
All right, great. And then the next, for the next fiscal year, 68 Innu children were admitted that year. And then after 3 years, 21 of them remained in care.
Correct.
Okay, 21. And then for 2021, 2022, 60 Innu children were admitted into a placement in that year. And then 24 remained in a placement after 3 years.
Correct.
Okay. So just to repeat those numbers now, that means there were 15 Innu children remaining in a placement based on 2019-2020, 21 for 2020 and 2021, and 24 Innu children who remained in a placement 3 years after being admitted in 2021-2022.
Correct.
So then that number goes up over time.
Yes.
Okay. All right, so if we leave out that first year, so 2018-2019, which is, as we discussed, 34 Innu children remaining in a placement after 3 years, the general trend here is that it's increasing over time.
The proportion is increasing. Well, yes, if you take away the first.
Children are staying longer in care. Yes.
Children are, yeah.
That is what the number of children being admitted to care is declining. And
yes,
the children are staying longer in care. I think that was the takeaway that we had.
Okay.
For both populations, really, yeah.
And then looking even more closely at the differences over time, it appears that there are fewer and fewer, you know what, I think this has already been addressed, so I'm going to move on to.
No worries, of course.
Yes. All right, and then, so what Table 5 does not tell us is when those kids who remained in care after 3 years were ultimately discharged.
Correct.
Okay. And would the data that you have permit an analysis that would tell us whether the average time until final discharge for kids who remain in care after 3 years, whether that's going up, staying the same, or is going down over time?
I don't know what it would say, but we could do that.
But for 3 fiscal years, right?
Depending on the depending on the cohort.
Because we need 2 years of data for 1 month of inclusion, right?
Yeah,
for 1 year of inclusion, we need 2 years of data. Because we have to, the child could be admitted on the first day of the fiscal year, right? And be discharged on the last day on like halfway through the next fiscal year or the first day. So we need 2 full years of when the child is admitted to care in order to calculate these data.
So the most recent cohort we could do it for would be 2020, 2021, and follow the kids that are still in care, which one of them for like another year.
Yeah.
Okay. And so, I mean, if the general trend then is that new kids are, while fewer of them are going into care, they are tending to stay longer.
Right.
Would you say that that would probably apply as well for the kids who are staying in care for longer than 3 years?
We would have, I'm sorry, I guess I don't understand your question.
That's all right. I think as long as we understand what the general trend here is, with the window that you've used because of the data that you have, then I think I can move on.
So we could, for 3 of those fiscal years, we could track 2 more fiscal years. That's what we're saying, right? So, because we need 2 years of data to calculate 48 and then 60 months.
Okay.
So we're really, and you can see that we were really limited by the last 3 fiscal years to look at that 3-year window. So that's the challenge for us to extend that longer.
Mm-hmm. Okay, understood. Thank you. So I think as you set out in your report that it's possible that what's happening is that as the number of placements go down, but Innu children are spending longer in those placements, it could be attributed to the fact that it's the more severe or more complex cases that are going into a placement.
That's one hypothesis, yes.
Okay. And so just looking at those terms, I'm wondering if you could explain what, and we've touched on this a little bit with group care, but could you explain what would make a case more severe or more complex?
Absolutely. Looking at a child holistically for a child that is symptomatic of structural racism and it's manifested in behavior, emotional, academic challenges that exceed the ability of the environment to meet those needs. That could be an explanation. It could also mean that the caregiver or the families of origin have multiple challenges that aren't solved in a way that the child can safely return. There's lots of kind of intersections between those kinds of concentric ecological kinds of systems. But this is a trend where the placement rate's declining and children are staying in care longer. So the hypothesis is that, well, in order for that child to have reunification, that's a subset of children where it's going to take longer to ensure that the child's needs are met, caregivers' needs are met, and then reunification is going to be successful.
And so would it be possible to test that hypothesis or that explanation? Meaning, is there anything in the data that could help us detect whether there is more or less severity or more complex challenges associated with a particular placement?
Not in the data we received, and I think it's as we spoke earlier this morning, it's a limitation in administrative data systems where those kinds of clinical concerns are very difficult to extract and interpret. So that's why it's a hypothesis that children in situations that are more challenging stay in care longer. And certainly that requires an intervention with a clear theory of change of why that is in order to reduce the numbers of the days in care.
But do you think in general it would be possible to, and you may not have an answer to this, but could some of the challenges potentially be managed through more intensive prevention services and family supports as opposed to having to put a child in a placement?
What do you mean by prevention services? So the situations, I guess, where a child has significant behavioral issues, I wouldn't say that's prevention, I would say that's intervention. Because the condition exists, right? So we want to make sure that we're able to intervene and work with the family and the child to ameliorate whatever that behavior is in ways that the child can thrive at school, whatever he, she, or them want to do. So the kind of the right, and this is where the right assessment and supports for that child and family is really prescient in terms of understanding why children stay in care longer.
All right. Then with the remainder of my time, I think I'm just going to wrap up now by asking a few questions that take us, maybe take us into the future, get us looking at the bigger picture and kind of directions for further research, especially as the INU shift into having jurisdiction over prevention services and ultimately all aspects of child well-being. So you noted in your presentation earlier, I believe, that ideally you would like to see this type of research inform reforms to systems. And I think maybe more specifically, we could say to the way data is kept and tracked and collected for further research, for example. And so I'm wondering whether you might have any additional recommendations that haven't already been discussed about what the province might consider doing to make its system perhaps provide more of a robust repository of information that would be helpful for tracking the kinds of measures that you have in your report here over a longer period of time.
Well, I guess constructing the data longitudinally, I think gives you a lot of information in addition to kind of service counts and cross-sectional data. Cross-sectional data are limited in terms of what it can tell you about a system. If you collect the same metrics over time, it'll tell you more, but the ability at a case level to construct cohorts and track children and families over time, I think is really builds that accountability into communities. So just in general, information systems, even, we're often shocked when we do work that like key fields like identity are not populated reliably. So one of the things that Molly asked us to speak to early in the testimony is that service continuum. So if you only start to reliably populate identity at the placement decision, then you can't really say anything about those kinds of disparity intervention points in decision making. You really need it from screening through to placement and discharge, because you have to know where the system kind of can correct disparities with interventions and thoughtful theories of change, and where kind of checked or measured where the system exacerbates those disparities. And this is what we see so often with First Nations children, where the system is, exacerbating those disparities as opposed to correcting for them. So that they're reliably populating those kinds of key fields are something that we always kind of stress. the data quality. So the challenge in general in information systems is that, you know, the connection between a frontline worker who's being asked to make really challenging, impossible decisions and the data that they enter are often not clear. So, you know, we really try and work with frontline workers to return data that is meaningful to them, to, you know, to show them their work, how it's been used in advocacy, the importance of reliably capturing to the best of their abilities and the system's tools, the challenges for that family. And so that it's like you need to kind of create a virtuous circle, right? Where the data, just as I said, these data are children and families, and like they can have meaning if they are reliably populated and capture to the best of everyone's ability the challenge or situation for that child and family. So that connecting folks to administrative data and the importance of it and its ability to not be definitive, but to provide really important metrics for context of their work, and to be accountable to children. I mean, I always tell the story of, Tara's heard it before, where, you know, my older daughter, who was 10, and we were walking home one night, and I was intent on making her accountable for her privilege, and I had heard about a terrible situation and of two children being placed, and I said, you know, Claire, what would you think if someone came into your home and said that mommy and daddy weren't good enough parents, and they took you and your sister and you separated you, and you know, and they said, trust me, this is going to be okay. And my then 10-year-old daughter said, which is the answer we should always ask, is, well, I guess I would want to know, how are they going to make you a better parent? And I thought, okay, that is the question that we all need to answer when we knock on the front door, or we tell families they need to work with a worker, or you know, or we place one of their child, and so, you know, that's the question I think that we in our lab are really tethered to, and you know, it sounds lofty, but I think I'll always remember that moment going, hey, the 10-year-old had the right response.
Dr. Black, I don't know if you have anything to add in terms of recommendations for data keeping, I guess, by the province.
I would just echo what Barbara said in terms of longitudinal data, or in addition to counting services and counting investigations conducted in a year, or how many children are placed or in care in a specific day, of really looking longitudinally at things. So I'll echo that. We've said in the reports, you know, keep calculating disparities. So not just looking at what's going on for any population, but comparing it to something is always, I think, a helpful measure. And then Dr. Fallon's also reiterated before about, you know, instead of focusing so much on risk, can we talk about protective factors, talk about community well-being, and really work with your First Nations to think about what could we be collecting differently and hear from them.
Yeah, and sort of on that note, I'm wondering if you might be able to comment generally or offer recommendations on ways that the province could partner with the Innu to kind of do that work of continuing and deepening the research that you've done and our knowledge collectively of these disparities. So maybe that means partnering in terms of sharing the data to begin with, but also maybe the importance of collaborating on further research. So if you could maybe just speak to that kind of partnership piece between the province and communities, that would be very helpful.
Well, I guess it's not quite the same thing, but from our perspective, that's always where we start, right? So, I mean, the provinces have accountability with respect to compliance for systems, right? So it's shifting the conversation to, you know, accountability with respect to outcomes to communities. And so we, in our child welfare lab, which is not complicated as running a system, start with questions from the community and see if we can answer those. And that's really what we try and, you know, privilege always. And if it's going to be helpful for a community partner, then typically then it's helpful for our academic responsibility, because we're at the University of Toronto, and so our responsibility is to actually produce academic outputs. Fortunately, we turn it around. We first create the community output, and then we say to communities, would you like your work to be represented in the academic literature? And because, you know, it's very helpful to other folks trying to understand accountability to their communities. So it's the kind of turning the paradigm around, and working with communities and families and children as really the experts of their own experiences. People love their children, and 99% of caregivers just want to do their very best for children, and lots of folks get in the way of that. Lots of reasons get in the way of doing that. So I think if you start there, it's a journey, and it's a commitment, and it's one of those things where people are going to make mistakes. You didn't ask me about how many mistakes I've made over 30 years, a lot of them. But it's just kind of that commitment to doing better. It's really, if you lead with that, then, I think most people are really responsive to it.
And then maybe just lastly, touching on something that I think you have probably heard already, which is that the Innu are working on developing their own law. And with that comes an opportunity for them to establish their own data system. So I'm wondering if you have thoughts on any kind of considerations that might uniquely apply to a First Nation that is operating under its own law in terms of the data, and what it would capture, what it would do with that information, and maybe thinking about that goal of trying to improve the way we track and analyze outcomes for children, so that it's more meaningful to the communities themselves.
Well, that's really a question for the community. So I would probably start there. But, we're both social workers trained ecologically. So, the context for the work, the population you're serving is, those kind of macro level factors are really ones to consider. And then kind of working towards the individual, I think, and constructing measures that are going to understand the relationship between the macro and the organization and the family and the community, pulled through those concentric circles are really, I think, considerations in understanding how better to serve families and children. The inability, and this is where child protection workers, you hear a referral reason, and I always say it's impossible in that moment to determine, is this like a Tuesday morning for this family, or is this the worst moment in this family's life? And that ability to say what it is not, it's important. Because if it's the worst moment in that family's life, nobody needs a child protection worker. If it's a Tuesday morning where that child is really, for many, many reasons, their needs aren't being met in a way that threatens their security or development, then it may be an opportunity for caregivers to seek out help and support. And in some cases, that child may need protection. It's always the way that we do things that we have to interrogate, as opposed to, there are some moments in any child's life that are daunting. And certainly for some children, there's no question that in that moment, they need another adult to step in front of their caregivers and to help their caregivers better understand their safety, security, and well-being needs.
right, that wraps up my questions for this afternoon. So thank you both very much for your time.
Thank you.
Thank you. I'm gonna ask one question that ties, one follow-up question that ties a couple of themes that were addressed there, a couple of concepts. In a response, so there was a question about the potential of comparing placement rates for the Innu against treatment of First Nations children nationally, and you discussed the different methodological approaches used in the incident study, the First Nations incident study, and the report that was produced for this inquiry. Dr. Fallon, one of the differences that you mentioned is that in the incident study, you looked at the number of kids placed relative to the population. And in the report that you've prepared for the inquiry, you looked at the number of kids placed relative to investigations that occurred. Can you just explain that? Because I know you were asked as well the concept of cumulative disparities. Does that apply here in terms of the looking at the investigation rate and then looking at the placement rate?
In a way, the reason why we decided to interpret the data that way is because it is really the decision-based indices is really a way for a system to understand their role in continuing the disparity, right? So it corrects for the front door in a way, controls for the front door in a way. And so we can, I guess, interpret the data. I mean, I think it's challenging with sample sizes, honestly. We could, I guess, look at the data would be sort of very hard to interpret, I think, Tara, if we looked at the placement relative to at a population disproportionality is, the non-Indigenous service population compared to the non-Indigenous child population versus First Nations service population compared to the First Nations child population, right? So what's the disparity between it? And so then the service population, we would just swap out to be the placement population. We could look at it. I don't think it's as helpful as saying, okay, of children who are investigated, what happens?
Yeah, I think maybe my question, I was trying to give too much context maybe in framing it, but is that concept of cumulative disparity, like what you've set out in the report is in the most recent fiscal year, Innu children are almost 3 times more likely to be investigated. And then of those who are investigated, they're almost 1.5 times more likely to be placed in out-of-home
in the last fiscal year. Yeah.
Yeah. Is that an example of a cumulative disparity in that the 1.5% builds on, sorry, the 1.5 times builds on the 3 times?
Yeah, exactly. Yeah. And the cumulative disparity also is not, it's a way to think of it conceptually is that like if we didn't have a child welfare system, then the cumulative disadvantage of a First Nations child relative to a non-First Nations child in Canada is also something to think about, right? With respect to school, access to resources, poverty, educational opportunities, access to recreation, right? That's the cumulative disadvantage. Then when you meet child welfare, I mean, that's like, you can't just look at child welfare when we're talking about the trajectory of a First Nations child.
Okay. Thank you for that indulgence with the follow-up question. I really appreciate both of you taking the time to be here today and to share your research findings with us all, with the with the commission, with the Innu public. And I'm happy to say that the commission of inquiry is concluded for today. So thank you.
So while Molly just said the commission of inquiry is done for today, I do have a few final words before I throw it to the commissioners to close off today. So we've concluded now Dr. Fallon and Dr. Black's pre-recorded evidence, though they will be available for a half hour tomorrow for questions from the commissioners. Also tomorrow, starting at 9 a.m., we will have Family Council giving their final submissions. So Adrian Ding will begin as counsel for the family of Kirby Mistinapio. As a reminder to any of the family council who are on the call, you'll be appearing from your own offices or wherever you would like virtually. It's not expected, or we're not really even prepared for you guys to be coming in person. If you were planning to be here in person, you can just send me an email, and we'll discuss things. As a reminder, again, the parties will all have 1 hour maximum each, and to give your submissions. So as I said, we'll start at 9 a.m. tomorrow. If anybody has any questions about what time they're supposed to go, just reach out and we can chat. But with that, I'll turn it over to the commissioners to close today. Thank you.
Thank you very much. We're so happy that you were all able to attend, and I'll ask Mike to respond first of all to the submissions we've had today.
Well, thank you for everybody for your attendance. It's certainly been a very interesting day. Certainly Dr. Fallon's work is a bit complicated, and I'm trying to tease some of the parts out to some of the people we're doing today is good, it's helpful. And we'll get a chance to speak with them tomorrow and to officially thank them for their work. And of course, we finished Bill English's today, or retired Judge English, which is also an important piece of work for the inquiry. So thank you, and I hope you have a good evening. See you tomorrow.
And Anastasia will be finishing our day with a prayer, but I simply want to say to Ms. Churchill, Dr. Fallon, and Dr. Black that about a year ago, as you said, in 2023 in August, we were quite anxiously hoping that Peter Ralph and Caitlin Urquhart would be able to get each of you, all three of you, involved in the inquiry. And we're so happy, so pleased that you were able to do that. The quality of your work for each of you is extremely high, and we value it a great deal. Now I'm going to ask Nastash to also make her comments, as well as to close us off with a prayer for the day.
I'd like to say, Dr. Fallon and Dr. Tara Black, thank you for the presentation today. And before tomorrow, I'll have some remarks to say as well. So I'll do the closing prayer.
Yes, we're just going to bow our heads here. Thank you.
At the Benamin, Anujish, Umachishuk, Kaminin, and Tabodenica, Utnengas no Chewan, Eshanagwag, Ishapabanawet, was Magdashu Jenmitten, Taship J. Shajin. Taboidashu Jenmitten, Teji, Wijin, Teji, Dwane, Kai Besast, 8 ton, Pagan Gamisat, 8 ton. Tika Ispatenda, when Espesaji Dane, to Sestadan. Tinaskumatin Jin Gai Denamin, Teji, Minuata Gushin. Asta muiji jaji kasno mando do gwen janet skok kasagan jaji mando mano takushit kewin. Tante kamat no mando nano mino takushun ano mishauke ano shochimgan. Kata ben min abo begusen nantam jatan antented. With the min abo takwak jaji shechen jam the swaba den je ispanyan ano jis kasagat. We dip me at the Benamin, Jiniscomatin, we Jewin, Ano Jiskasakat, Especiajidan, the Pachetnamad, Gasno, Jagwan, Jeto, the man, Ano Jiskasakat, Jimate. Amen.
To Mr. Committant Nastash, also, we want to extend our prayers to Elder Swashim Joachim Nui of Natwashish. He, of course, has guided us throughout the period of the inquiry. He's in hospital now with some bit of complication issues with pneumonia, and we wish him all the best, and our prayers are with him. Thank you again.
Amen.
Thank you.